covered in smoke and ash. Thick smoke and ash. Terrible, terrible, terrible.
Term.
Ready?
Thank you, Judge President. Good morning, Judge Sutherland.
Good morning, Chief Justice. Commissioners, good morning.
How are you, sir?
I'm excellent, thank you.
Thank you. You look comfortable, so I won't spend much time trying to settle you down.
Thank you.
You started your career as a prosecutor, am I right?
That's correct, yes.
I can barely hear the candidate, Chief Justice.
I'm sorry.
Judge, if you could please bring your mic closer.
Yes,
President
I'll do that.
Maya is struggling to hear you.
Yes, forgive me. My answer was
Thank
yes,
you.
I did start as a prosecutor.
And then, yes. Now, before we come to your judgeship, for how many years were you junior counsel, and for how many years senior counsel?
I was a junior for 16 years and a silk for 16 years before I took a permanent appointment.
Sorry, Chief Justice, he's fading. I don't know. He sounds very far.
Right, is that a little better?
I can't hear you.
I'll keep it very close.
For 16 years and senior for 16
That's right.
years. All right. For how many years have you been a judge?
This will be my 9th year. I took a permanent appointment in January 2012.
And for how long have you acted as Deputy Judge President?
On and off now for getting on for 2 years. I've had 3 spells acting. The first was in August of 2019, and then later on in 2020, and again now in 2021. So this is my 3rd spell as acting AGJP.
Thank you. I'm going to let the JP continue. I just want to take up the names of colleagues who would want to put questions to you. I made an error for which I apologize most profusely, colleagues. Please bear with me. I should have welcomed Judge President Leo, who's representing the Judges President, because Judge President Mlambo, who was relieving her, now has to be JP for the purpose of Gauteng. And I should also have welcomed the Honorable MEC Nisufi, who is representing the Premier. I apologize for the lapse. I can assure you it has nothing to do with the consumables over the weekend. May I have the names of colleagues who would want to put questions to the judge, please?
Lamola, Makwanisha,
Muimang, Bofu,
Tepe.
Nyambi,
Schlimmer.
Dodovu,
Bonod.
Thank you. JP, over to you.
Thank you very much, Chief Justice. Judge Sutherland, you are applying for a leadership position in the Johannesburg High Court. You've sketched in your questionnaire the leadership role you've played. I just wanted to tap onto that. Are there matters that you, of a leadership nature, that you dealt with even when you were not acting as DJP?
That is correct, JP.
Could you tell the Commission of that, please?
I've been the lead in rolling out case management since 2014. You'll recall that when the Chief Justice announced that the judiciary should shift to a more judge-centered process, the divisions were all invited to pilot a case management model. And in 2014, the then Deputy Judge President Mojapelo asked me to frame a model which would work in Johannesburg. So I did that. It went to a committee. We workshopped that and we implemented that. And that model, with adaptations as we went along, was in operation until the middle of 2019. And the relevance of 2019 is that is when Rule 37A, as it is presently now, in force, came into force. The task team which did the legwork on preparing Rule 37A drafts was one chaired by DJP Traverso. I was one of the members of that national task team that did the legwork on that. So when Rule 37A was introduced, effective 1 July, the DJP asked me to prepare a model to align the practice in Gauteng with what Rule 37A provided for. Bearing in mind that that rule anticipates that the judge's president will have to tailor to the circumstances prevalent in their particular divisions. So I devised a directive which was then put into force, and it had certain novel features which have been important for the rollout of case management from that time.
Let me stop you there. The case management initiative that the Chief Justice introduced, even before he was Chief Justice, after 2010, became more relevant when the RAF phenomenon, that's what I'll call it, reared its head. There was a directive that was issued that was very unpopular. That was issued, I think it's called the 2 July or 2 August directive. Did you play any role in that?
I did indeed.
Were you acting at the time?
No, I wasn't. That was done simply as a member of a number of judges who was involved in advising the leadership.
Yeah.
But I had no formal role at that time. It was only after.
JP?
Yes, Chief Justice.
I'm sorry, allow me, you and Judge Sutherland, to interrupt. Judge, as you explained, for the benefit of those who might not be lawyers, commissioners who might not be lawyers, in a very simple way, you may wish to explain what the purpose of Rule 37A is so that they can follow your explanation. I'm sorry to interrupt you. I just thought it was necessary at this stage.
No, thank you, Chief Justice. The purpose of Rule 37A is to streamline procedure, particularly in regard to trials, but more broadly too, so that it becomes the norm that trials are not unnecessarily protracted, that preparation work on a trial is not unnecessarily protracted, and that matters do not settle at the doors of court and thereby jam up the available resources which are available for hearing trials. So the principal strategic objective is to get matters settled as soon as possible, and a judge intervenes in order to do that. If it can't be settled, it is to narrow the issues down to those issues which absolutely do need to go to trial or to a hearing, so that no unnecessary time is wasted in dealing with the dispatch of the work. In the course of that, one of the devices, which is compulsory for a judge to investigate, is whether or not mediation would indeed resolve the dispute rather than going the full litigation route. So those are the strategic objectives. The actual interaction is somewhat technical, but essentially what is required is for the judge who gives a certificate of readiness to do so only when settlement is no longer a reasonable prospect, where mediation has been considered and either tried or has not been successful, and where the issues have been narrowed down so that we can have a practical, sensible, streamlined trial or other hearing and use judicial resources as sparingly as possible.
Okay. Can I stop you there, Judge Sutherland? I think if commissioners want you to go further, they will ask you. Two more questions regarding case management. You coined the phrase phantom cases. I want you to explain what you meant by that in brief. And the other one is, have you played any role regarding the consolidation of the practice manuals of both divisions of the High Court in Gauteng?
Yes, thank you, JP. Let me contrast the way in which the trial role was managed in July 2019 with the way it's managed now in 2021. The practice up until that time was to enroll 120 cases a day. That's 600 cases a week in the trial role in Johannesburg. Although they were enrolled, everyone understood that 95% of them would never go to trial. That is why I called them phantoms. The practice was to, as a practitioner, get a trial date, have no intention of ever going to trial, and then settle at the 11th hour, thereby managing to garner up all the trial fees that one could. So there was an inherent abuse in the system. It also, of course, meant that the roll call ran 5 days a week for the whole day, while people came in and out settling it. That was a complete waste of judicial resources. As a result of the model of case management we put into place, the position we have now, in contrast to there, is that the roll call takes 10 minutes. We have, through issuing certificates of readiness only to matters that are properly needing a trial, reduced from 120 to now a maximum of 16 matters a day. And we can manage that with our judicial resources. One of the great benefits, apart from the charade of having 100 matters on the roll every day, is that the lead time between applying for a date and getting a trial in 2019 was 1.5 years. The lead time now from applying for a date for a trial is 3 to 4 months. And that's due entirely to the new way in which we have shaped the management of the trial court.
Okay.
JP, I didn't hear, is it 16 or 60 matters now? 16 or 60?
16.
Okay, thank you, sir.
Yes.
Continue, JP.
Thank you very much, Chief Justice. just explain the need for the consolidation of the practice manuals of the two high courts, without explaining what's in there and the reason why it had to happen.
As you all know, the Gauteng division has 2 seats, both with a large volume of work, and in which a practice manual evolved in each seat, which was not identical to the other. That, of course, is an irritation to practitioners, and also a difficulty for judges, because from time to time, judges in Johannesburg sit in Pretoria and vice versa. So there was a need to consolidate the practices of both seats into a single manual, so that we can have uniformity throughout the division, with the added efficiency and convenience that goes with that.
Yeah. And I think in all fairness, you did all that work and you were not acting as DJP. Simply, it's you volunteered to do it and you did it.
I did, yes.
And JP is still sleeping on it instead of implementing it so far, isn't it? My last question to you is 3-pronged. You're a white man. You are 70 years old. No, 2-pronged, yeah. So white man, 70 years old. What is your view to you applying for this job with those 2 dynamics?
Well, let me deal with age, first of all. The idea that you're washed up at 70 is a very old-fashioned idea. 70 is the new 50 in my book. I'm the life president of the club for promoting that idea. I think you'll find
Could you just stop? I'm not sure. Chief Justice, are you still with us?
Yes, it looks as if there may be.
I am with you, JP. It's just that the screen wasn't showing anymore.
Okay, thank you, Chief Justice. Sorry about that.
Thank you. So I don't think my age objectively is a factor of any great importance.
How many more years do you still have to?
I have 5 years of service left, and I'll be here regardless. So that's the age issue. I was going to say that I think you'll find that people in my generation carry on well into their 80s. And so if there's anyone here on the commission who can ride a bicycle over a 100-kilometer route in 3.5 hours, I invite you to join me, and we'll see who gets the orange first. As to the other question regarding the fact that I'm a white man, I do understand, as the Constitution prescribes, that the racial composition of the bench is something that needs to be weighed, and it's by no means the least important consideration. What of course I do not know is what policies or guidelines the JSC has set up in order to gauge how that balance is to be done. As far as I'm aware of the deputy judge president's posts in the country, there's only one white person in that office. Is that a consideration? It's not my role here to argue that point, but obviously that may well be the position. As far as the judicial leadership as a whole is concerned, if that too is to reflect the racial diversity and gender diversity of the country, then presumably there is space for white people in that capacity. I appreciate that there is huge sensitivity about the racial identity, more especially of those who do serve in the leadership of the judiciary.
Yeah. Okay. And, one last question, Chief Justice. I'm sorry, I've taken long, but this is the last one. You started acting after colleagues who were senior to you had their opportunities to act. And in that process, 2 women who were senior to you also acted. Is that correct?
That is correct, yes.
As DJP, is that correct?
Yes. Yes.
Thank you very much, Chief Justice. I've got no further questions.
Thank you, Judge President. Honorable MEC.
Thank you so much, Chief Justice. Good morning, Judge Sutherland.
Good morning.
Are you well this morning?
Excellent, thank you.
Thank you so much. It's quite clear that your court case management skills stands out as the key thing that we can get if we have to recommend your appointment. I'm very keen to understand how will you ensure that there will be a skills transfer to those that will be working with you if you're a successful candidate, and how will those skills be transferred? Thanks.
Yes. Well, there are two dimensions to that. The one is more generally across the bench as a whole. To what extent does one use one's leadership role to see that newer judges absorb knowledge and skills and have proper exposure to that? And the other dimension, of course, is who would succeed me. Both of those matters I'm fully aware of, and I think it's appropriate that it be so. I have been lucky to get along with all of my colleagues. Indeed, the Johannesburg bench is a very happy place. And the personal interaction helps enormously in that respect to engage newcomers and to make them feel comfortable. And also, insofar as it is in the realm of the DJP, to assign work and to direct who should sit in what court and so forth, one can systematically make sure that newcomers get the proper exposure so that they don't find themselves in a stagnant situation. That is always a danger. Happily, on a big bench, as we are 38 judges in Johannesburg, there's always room to do that fairly successfully. As far as a success is concerned, that of course is not something that lies entirely in my hands. With the JP and with the other Deputy Judge President in the division, it's incumbent on us to identify people who ought to be groomed and to see to it that they get the appropriate exposure. One of the things that is to be used to great advantage in Johannesburg and in Pretoria is the system of committees which are enrolled to advise the Deputy Judge Presidents and the Judge President. As you'll have seen, I sit on several of those committees, and one of the ways to orientate newcomers is to draw them into the various committees so that they can get involved in policy development. One of the really big important issues in terms of grooming someone for leadership is to have some role in policy formulation, get involved in the systems, and understand what, so to speak, the back office does. One of the least appreciated aspects of court administration is paradoxically the registry. The support staff tend to live in the shadow of the judges, and their critical ability to perform and to deliver what the judges need in order to give it an efficient service is something I'm very conscious of. So the answer to your question, MEC, is that there certainly are opportunities to do exactly that. I'm conscious of them, and that is what I will do.
Thank you so much, Chief Justice. I'm fine. Thanks.
Thank you, Honorable MEC. Honorable Minister.
Thank you, CJ, and good morning,
Good morning. Good morning, Minister.
Thank you. How do you put this issue of age to say that it is an old, it's old-fashioned, when old white males have always been privileged in this country?
Well, I don't deny that my white skin has allowed me to be free from oppression. But the extent to which privilege explains why I'm here is a little more complicated. I didn't grow up in an affluent family. I had no prospects of a university education. My parents had no money. The reason why I found myself in the civil service straight after school, because I took advantage of a bursary in order to educate myself. And I and my brothers are the first members of my family ever to see the inside of a university. So I'm not an example of someone who was born with a silver spoon in his mouth. I got here on my own. And I'm conscious of the fact that because I have been white, I have had certain advantages given to me under apartheid. What I am proud to say is that I have never served the apartheid project. I have throughout my life been in opposition to it vocally, as a boy, as a man, as a professional. And if anyone thought that the investment which the apartheid state made in my education was going to accrue to its benefit, they have been sorely disappointed. I appreciate that in the context of transformation more broadly, one needs to create spaces, but there's, of course, the danger of getting bogged down in the way we perceive one another. I fully understand that there may well be many people who look at me and all they can see is yet another white man, and that may be the end of their perspective. I simply ask that perhaps when you look at me, you can see a fellow South African who is concerned to be part of the nation-building project and to produce a community in which we can all have reciprocal respect and achieve social cohesion. If you can see that in me, then I shall be grateful. And as I come here as a volunteer for public service, take me as that.
Yeah, I've heard your role in the management of cases and files. What has been your role in the digitization process for the Gauteng division, and what do you think will be your appointment will enhance that?
Yes. Well, I'm fully aware of the ongoing project in that regard, and of course it has several dimensions. You speak of digitization. We have already in Gauteng got the Case Lines program, which I can go into detail a little later if that's necessary. That has been a godsend to us for COVID and is undoubtedly the way forward into a paperless future. There are steps at the moment being taken to digitize existing hard copy records going back. That's in its infancy, but is absolutely critical. When we speak this morning, the day after the University of Cape Town's library is burning, there can be no more urgent project than to safeguard the records in state departments. As a result of various reasons, the state of our archives is in urgent need of rescuing. It's not safe, and digitization can't come fast enough. Then, of course, e-filing is around the corner, which is going to revolutionize attorneys' litigation practices. And over the next 5 years, which would be the time that I would be serving as Deputy Judge President, some of the principal projects which need to be driven is the further expansion of e-filing, case lines, digitization, and of course, as we have learned during COVID, the fully implemented utilization of video link opportunities in order to create efficiency and save enormous costs. So that's the task ahead. And I relish the opportunity to be part of that.
Thank you, CJ, and thank you, Judge.
Thank you, Minister.
Thank you, Minister. Honorable Magwanisha.
Thank you, CJ. Good morning, Judge Sutherland.
Good morning.
Yes, my first question was asked by it has already been asked by the MEC. So I will focus on my last question, which is more focusing on you as a senior counsel, when you're a senior counsel. How many Black advocates, let's say name 5 Black advocates and 5 women advocates that you empowered as a senior counsel?
I made a report on that when I was interviewed initially in 2012. And the position was that I had done a check on my records. And during the time I was silk, running up to the time I was appointed as a judge, something over half of the juniors that I led were Black and women. And what perhaps is equally important is that approximately half of the attorneys who briefed me regularly were Black, either from Black firms or in what would generally be thought of as the big white firms, partners or associates in that. So I took the view then that my practice was reasonably well transformed. The issue of what I did in order to promote and advance Black colleagues didn't only stop in the actual fee-generating work I did as an advocate. I was a leader in the bar, and I was the leader of my group. And in both those capacities, I did several things. But let me give you just 2 examples. When I became leader of my group, the Bridge Group, in 1999, I took charge personally of the recruitment of pupils into our group in order to ensure that we would have an appropriate racial mix of pupils. There were already Black members in the group, and indeed from the time I joined the group in 1978, there had been Black members in that group, even when there were only 3 Black members in the whole of the Johannesburg bar. So we were a group that had forward-thinking ethos, and each year I would go and select a number of pupils that would advance transformation objectives, bring them into the group, assign them to pupil masters, as we called them then. I also innovated the pupillage system by assigning a silk to each of them, so they had 2 mentors. I always took a mentor myself, and in every case, I always took a young Black pupil who I could advance. And then, of course, after pupillage, the big question at the bar especially is what happens then? And at my initiative, we introduced a scheme which we called the Junior Associate Scheme, in which we would accommodate principally our pupils, but sometimes we could take pupils from other groups as well, to have subsidized accommodation, reduced fees, so that for the first 2 years, they would have chamber accommodation at a cheap rate, group fees at a cheap rate, and would have proximity to a group of successful practitioners who could draw them into matters. And in that way, an enormous number of young people came through our group and into practice, many of whom practice successfully today. The other example I want to give of promoting transformation by promoting individuals is the scheme which my group initiated at 2 levels. The one was with the Wits Legal Aid Clinic Access to justice has always been a problematical issue. And my experience of that over many years is that indigent people really only get help when some form of NGO can be present to intervene. It's not good enough just to have procedures at the level of the court. What we did was we went into a partnership with the Wits Legal Aid Clinic. They would send us matters which we would assign to juniors with a silk mentor, and that would enable the youngsters who at that stage would have had no experience and no reputation to be seen in court doing a credible job. My mantra in all the lectures I give to young advocates is that the most important thing in order to develop your market credibility is to be seen doing credible work. And over the years, that scheme flourishes now. Hundreds of briefs are sent to my group, which are distributed amongst the youngsters, who have all the assistance from the more senior practitioners, and they are in court, being seen to do the work, and at the same time, of course, we're meeting the Wits Legal Aid Clinic mandate, which is to actually realize, in practical terms, access to justice. So those are some of the things that I was involved in actively as an advocate, both in my own practice and as a leader.
Thank you, Chief Justice. Thank you, Judge Sutherland.
Thank you, Honorable Magwaneshe. Honorable Moima.
Thank you, Chief Justice. Good morning.
Good morning.
Judge Sutherland. Is my understanding correct from your judgment in Amapungani, which is one of your latest judgment that was confirmed, I believe, by the Court?
Yes.
Is my understanding correct to say that bulk surveillance continues to the extent that it put the law enforcement agencies in a better position to fight crime, but to the extent that there is no notification when it interferes with the attorney-client relationship and also with the media freedom, it is unconstitutional. And to the extent that bulk surveillance beyond South African borders, it is allowed. Is my understanding correct?
My understanding of what the Constitutional Court confirmed is that bulk surveillance is unlawful because there is no law which permits it. There may well be a law that is in due course passed to permit it, with or without conditions. But it goes no further than that. It needs a lawful sanction in order to be used under the principle of legality, which provides, as we know, that no public power can be exercised without an authorizing source. So that was the difficulty in that case with the bulk surveillance. There simply was no warrant to do so. There was a debate about other countries doing it as a matter of course. How could we do without it? Perfectly valid consideration. But if Parliament considers it appropriate, it will doubtless pass a law. And if that law is consistent with the Constitution, then it shall stand. But that's the state of the law on that score at the moment.
Thank you, Judge Sutherland. Thank you, Chief Justice.
Thank you, Honorable Moima. Advocate Mpofwesi.
Thank you very much. Good morning, Judge Sutherland.
Commissioner Mpofu, good morning.
Good morning, thanks. I just want to give you a word of advice. That seat you are sitting on now is not a place for modesty. That's where you are allowed to brag as much as you can. I just wanted to talk about the issues that the JP was talking about. Now, I have had experience with you for many, many years, particularly in the area of the rules, the rules committee of the GCB. And I wanted you to just link that, because in terms of your experience in crafting rules, as I think it was either you or the JP, for the people who are not lawyers, it's very, the issue of procedure might be seen as a subsidiary issue. But actually, for a court situation, it's crucial. I mean, in substantive law, you might know that if you do a contract, if you sign it, and so on, that's all very important too. But from a court setting, the procedural rules are more crucial and may affect access to justice. Now, to what extent has your very extensive experience being involved with rulemaking, procedural rulemaking, contributed to the things that the JP has highlighted as your contributions, and even where you have volunteered to do things without necessarily having the title to do so? And in that answer, if you can at least try and emphasize how important the procedural aspects and the management of a court setting is vis-a-vis the actual outcome and cross-examination and all those things.
Yes, yes, certainly. Thank you for the question. The point of departure is that the work of any division in the judiciary can only take place through appropriate systems. And one of the issues which bedevils Gauteng is the huge bulk of work which there is. Even with 38 judges in each seat, it is a strain to keep up with the demands. I recently extracted some data. The number of trial matters, that is to say, summonses which were issued in the last 6 months of 2019 compared to the last 6 months of 2020, increased by 26%. And regrettably, data available at my court for earlier periods is not available. I'm told by the registrar that it's kept by the Department of Justice and they don't have access, which surprised me. The reason I mention this early in my answer is that in order to have appropriate systems, you need to have the right management data so that your systems can produce efficient, expeditious, and appropriately organized work. And so the directives which I've been involved in drafting rules for are designed in order to create an efficient throughput. We need to know what's coming in, we need to know what is our available resources, and we need to have an objective to get through that work in a certain time. So without systems and without adapting systems to changing circumstances, whether it's volume or the complexion of the work, as the case may be, one gets stuck in a rut, and that's when you start having lead times of 18 months or 2 years between wanting to go to court and getting there. So systems are significant, and in order to have the appropriate ones, one needs to be alert to what's going on the ground. And I've endeavored both formally and informally to revise and introduce, where there were none, systems which will inform the leadership of the division as to how to make those adaptations. And that's an ongoing business. At this very moment, I'm in conversation with the registrars dealing with the motion roll. The lead time on that is unacceptably long. And we're exploring whether or not there are some simplifications we can introduce in order to accelerate that. But the ultimate point is one's attitude towards the management of the affair. And I've endeavored to engage all the players who are involved, both within the registry and in the judicial leadership, in order to produce an efficient system that will meet demands of the litigating public.
Thank you very much, Judge Sutherland. The other issue, which if the Chief Justice would give me some space to deal with this.
Go ahead, sir.
Thank you, CJ. You've been asked correctly in the context of South Africa about the fact that you are a white male. And my question, which will come at the end of what I'm going to say, relates to the extent to which the issue of pigmentation, mere pigmentation, should guide us when we deal with this question. And don't get me wrong, pigmentation is important because that was the criterion that was used to advantage white people of whatever. Even a white hobo was still superior than a black professor. So pigmentation is important. But the issue is somebody like you. I mean, from my own personal experience, I know you as a young junior in the 80s who was one of the few people who were prepared to assist us in defending cases of MK soldiers when it was not popular to do so, even at the bar. And as you put it, to that extent, you were a disappointment to the apartheid system. And I'm sure you were a disappointment to many of your colleagues as well. And I want you to tap into that kind of experience as far as transformation, which goes beyond gender and pigmentation. Whether we don't need transformation of ideas, of people who were able to fight against the odds in a hostile system. And as you know, I was an article clerk to Kathy Setchwell at that time, who defended those cases and who briefed you. And she was even a bigger quote-unquote disappointment because she was a woman, lefty, lesbian, and all the things that apartheid would have regarded as being a disappointment. But in my book, she's probably the greatest lawyer I've ever met in my entire life. So to what extent should we, look at the bean counting and making sure that the numbers balance, but also to what extent do we need diversity of character and ideas, which goes beyond the skin color?
I dare say the place to begin is what sort of a dream one has about where we're going. It is sometimes dangerous to subordinate your planning to too much blueprinting. Sometimes the best you can do is simply have a direction of travel and keep seeking opportunities to advance it in that direction. But one of the most fundamental problems we have at societal level, never mind at the level of the profession or the judiciary, is mindset. Without mindset, we achieve nothing. One of the great disappointments I think many of us have is that at this stage, a quarter of a century after democracy, there is no national solidarity that bridges all the segmentation that went as a matter of course in the era of apartheid. That's a project on which those who want to build social cohesion and a community that is not dictated by interracial animosity need to keep going. I'd like to think that that's been the organizing principle of my life. And what I think is important in developing mindset is for people to exhibit their mindset publicly. To take an example which is perhaps even more acute now than ever, given over the past recent months the issue of the place of women in society. We can pass laws, we can have efficient gender-based violence courts, we can do all these responsive things. But as long as women are regarded as a commodity, there can be no real long-term practice. And one of the greatest evils of our time is the commodification of women. Be it that they're a precious commodity or a commodity to be adored, it doesn't matter. As long as they're a commodity, they will be inherently subordinated. We have to get past that. That's something we need to be appreciative of in order to tackle it. And so mindset is critical. One needs to marshal one's friends around those projects and bring everybody else along with it.
Thank you very much. Thank you, CJ. I'm sorry, just to follow up on my earlier question. I don't know if you did address it, the connection between the rulemaking and access to justice in your answer.
Well, let me deal with that. I'm sorry if I didn't include that in my answer. If the purpose of the courts is to afford genuine access to justice, then the systems which we use must be susceptible to achieving that objective. It can't just rely on goodwill. There must be a structure within which people who seek that can achieve that. And so the opportunity to recognize the needs for fulfilling those objectives need to be inherent in the system that you choose. If we think about, on the one hand, structural changes which were introduced under the Labour Relations Act to create the CCMA, which is a crucial device in granting effective access to justice in that context. We don't have a corresponding institution in litigation generally. And that's why, as a matter of practice, there's no particular reason why it has to be that way, but certainly the South African experience has been that in the general litigation sphere, where rights and access to justice need to be advanced, NGOs have played an incredibly important role in making those things happen. The AIDS campaign is perhaps the most signal example of that. And that's why those who make the systems and write the rules have to be conscious of those considerations, because it must be catered for and to facilitate the opportunity to do so.
Thank you very much. Thank you, CJ. Sorry for the extra question.
No, it was necessary. Thank you, sir. Commissioner Tsepe.
Thank you, CJ. Good morning, Judge Sutherland.
Good morning to you.
I have two questions for you, Judge Sutherland. The first one is still about the work you have done, particularly regarding ethical conduct of practitioners and of the judiciary from the redrafting of the ethical codes while you were in the GCB. Could you tell us a little bit more about that role and what you continue to do there? And I'm looking at it as an important role in achieving the objective of an independent and impartial judiciary as a cornerstone to a democratic society and the rule of law. Could you speak a little bit more about that, your job, your role in that regard? Thank you.
Yes, thank you. At the time that I left the bar to come to the bench, I was the then principal lecturer in ethics to the Johannesburg pupils in their pupillage program. And triggered really by my hands-on involvement in that work, I became particularly interested in the normative foundations for the professional ethical code. And I recognized in working through what was then the Red Book how antiquated it was. And so I offered the chairman of the General Council of the Bar at the time to lead a team to redraft the bar's ethical rules, bring it up to date, and to get rid of some of the archaisms and so forth. And I ended up doing a draft to rewrite, principally aimed at the advocate's profession. That text which I drafted is now substantially 3 of the chapters in the Legal Practice Council's Code of Good Conduct for Practitioners. And what I was able to do was to, if we start at the little things, I managed to do the entire draft in a totally gender-neutral fashion. When you find text in the LPC's code that's not gender-neutral, that wasn't mine. And it was with an eye on those considerations that a lot of inappropriate rules were jettisoned, and largely speaking, what the LPC has approved has gone along with that. But in addition to that, I've been active in giving lectures on ethics to the profession. This Friday, I'm giving a lecture to the pupils of Babasa in their pupillage program. I've given lectures to various groups at the bar and to the attorney's profession on ethics, and I continue to do research on that and research on judicial ethics. I'm busy preparing an article on judicial ethics for publication in Sajay's journal in the next edition. So I've developed a particular interest in that dimension, both in the legal professional ethical norms and in judicial ethical norms. And I hope to devote time as it becomes available to pursuing that objective.
Thank you, Judge. My second question relates to acting judges, and it's...
Chief Justice, I beg your indulgence. Before she asks the second question, I would love to follow up on this question of ethics, if you allow me to do so.
Please go ahead, sir.
Okay, thank you very much. Good morning, Justice.
Good morning, Commissioner.
Okay. How unethical is the judiciary today, in your view?
Well, there are issues about which we ought to feel unhappy, and to the best of my knowledge, they're being addressed. We're not always entirely satisfied that they're being addressed fast enough, but it would be invidious for me to make comments on any of the particular individual issues which the Judicial Service Commission have to deal with. But if your question goes deeper than that, and you're asking for my perspective of whether, on the whole, the judiciary is ethically trustworthy, I have no hesitation in saying that it is. Aspects of what are allegedly or are indeed unethical are aberrations. And the country is fully entitled to be confident that the bench as a whole is ethically strong.
Okay, you, in your acting stint, you manage judges, part of what you're doing. Do you think, in your view, some judges are corrupt, or they can be corrupted?
I've never met a judge who I had any reason to believe was corrupt. Of course, judges have different views on different things, and we don't always, for example, agree with the laws that exist. Sometimes we think they're not strong enough, sometimes we think they're weak enough, Often laws which we recognize are well-intentioned somehow fall short of our own ethical standards. So judges do often have to grapple with rules and laws that don't sit well with their own ethical predisposition. But to suggest that one has an expectation that there's a danger of coming up before a corrupt judge, I think would be gross exaggeration.
Lastly, linked to that, CJ, what is your view about the current, call it a perception or an allegations that some judges are corrupt? What is your view on that?
Well, it's disappointing that the allegation is made. On the information available to me, it's an empty allegation that is yet to be substantiated. It's certainly open to anyone in the world to criticize the judiciary, and I subscribe to the view that the judiciary should be resilient to criticism. But if you want to say that Judge Sutherland is corrupt, then the least you do is to say why. The nation expects judges to be ethical, and if someone has a genuine basis for saying that a particular judge is not ethical, then one must come up and say exactly what it is so it can be dealt with. The Judicial Service Commission itself comes in for quite a beating from time to time, but it cannot function without facts, and it doesn't know the facts unless someone who claims to know them reveals them. And that's really where we are on those particular claims at the moment. It's very unfortunate that those who make those claims do so in such a damaging way.
It's okay. Thank you, CJ. I've even forgotten my opportunity to ask my question. Thanks.
Thank you.
Thank you, Honorable Dodovu. Honorable Nyambi?
Chair, I still had my second question when
Oh, I'm sorry.
Thank you, CJ.
Over to you, Commissioner Tsepa. I apologize.
Thank you, CJ. I appreciate it. Judge Sutherland, my question, as I said, my second question relates to acting judges, particularly
Yes.
in your divisions. In your experience, while you were acting as the DJP in the last 3 stints, do you think your division has systems in place to support acting judges, particularly in running of matters, judgment, writing, and just in appropriate allocation of matters to ensure that there is
Yes.
adequate exposure?
Yes.
And if not, what do you intend to do were you to be appointed in order to deal with that?
Yes.
Thank you.
Yes. Well, the short answer is I would have to do a survey of acting judges in order to determine what the current cohort of acting judges think about the extent to which they are properly and effectively integrated. But I can say that it's certainly a point that the leadership is conscious of, and the endeavor to give judges proper exposure during their time as an acting judge is in fact very important for reasons which are not necessarily aimed at the judge's self-interest. When one's looking at a pool of acting judges from which to encourage some or others to take a permanent appointment, it's self-defeating if you haven't given those individuals an opportunity to do various things. So in the institution's self-interest, there is a studied approach to giving that access. Often, just to take a concrete example, if a senior silk at the bar, for example, is an acting judge, and it is well known that that person has had a varied and broad experience, one can be comfortable that there is no specific intervention that's needed at that stage. But if you have a candidate who has had less litigation experience or whose principal credentials in practice have not been litigation, then it's incumbent upon one to know that, recognize that, and give that person an opportunity to be exposed to the various types of work. One of the ways in which that can be done, of course, is to put them on full benches or full courts, so they sit with other judges and do it. And of course, even when, for example, one is sitting as an acting judge with 3 other judges in the unopposed motion court, there's an opportunity to discuss with other judges doing similar matters on the following day what should happen and what should not. One of the unhappy consequences of the complexity of the work which we do is that it's unlikely that any acting judge, when arriving, will have had exposure to everything. They need to be inducted in the directives. They need to be shown the ropes around certain logistical things. And if I take a substantive example, in dealing with foreclosure matters, as a result of Gudwana and also of JAFTA in regard to eviction matters, the complexity of our procedure for ensuring that Section 26 of the Constitution, the right to housing, is properly met, is now very, very complicated. And if you haven't done foreclosure work in your practice when you come as an acting judge, you need to bone up on all of that. And we're very conscious of the fact that we need to do that. So, in summary, we're very lucky in Gauteng, is because we've got the largest concentration of practitioners in the country. And whether we're recruiting more generally, we've also got the largest concentration of women practitioners in the country. So in a sense, relatively speaking, we're spoiled for choice. And in seeking to produce a bench that meets all the requirements of the Constitution and our functional needs, we're always on the lookout to induct people appropriately so that if we do pick them, it's not a guess, there's a rational basis for grooming someone for a permanent appointment.
Thank you, Judge. Thank you, Chief Justice.
CJ,
Thank you very much, Commissioner Tsepa.
CJ, I'm asking to be put on the list. Sigogo.
Oh, okay, sir. Okay. Honorable Nyambi?
CJ,
Yes. Yes,
can you also
JP?
put me on the list?
Thank you. Honorable Nyambi?
Thank you, CJ. Morning,
Yes,
Judge.
good morning.
Commissioner Mpofu and the ministers covered the first question, so I'll ask you just one question. As we have quite correctly in terms of your CV indicated that you never served as an apartheid project. You have got serious experience. I can see that as early as that historic year of 1976, that is very significant in our country. You were a regional court prosecutor. So if you can be able to take us through in terms of that experience and how that experience is assisting you today in your current position, and concluding by giving the immediate current challenges facing judiciary in our country as somebody applying for this leadership position.
Yes. Well, let me deal with that step by step. My time as a prosecutor in the district and the regional courts I dealt with the usual range of crime. When I was on the staff of the Attorney General, I was prosecuting in murder, rape, and robbery matters. And that, of course, is a very valuable experience technocratically in that you're in court every day. One gets an enormous amount of experience in that. And so one becomes familiar with the courtroom dynamics. And later on, when one's a more senior practitioner, one's aware of what one learnt at that early stage. And you're looking to see whether those who you are mentoring have a similar opportunity to develop those skills. If I think of an ideal apprenticeship for the bench to become a judge, it would be an individual who has the opportunity to serve in many different capacities, as attorney, as a prosecutor, as a counsel, both as a defense counsel and doing civil work on both sides of any particular issue. And that's what I certainly encourage youngsters who are thinking of going into the profession to do so. The idea of having a generalist foundation is of enormous benefit to anybody who is going to become a judge. Because as a judge, you are going to have something of everything. And although we talk about experience in a somewhat glorified way, experience is simply familiarity with something and having had a chance to actually practice it. So that's the critical thing that needs to be done. What one's alive to as the judiciary, our greatest challenges really are meeting the demands of the litigating public. We need to have cases heard earlier than later. We need to be able to write judgments that are convincing. We need to get our judgments out on time. We need to be alive to the dynamics of our society and be aware of the context in which decisions have to be made. We need to be socially aware. And SAJE, apart from other informal initiatives, is one of the devices which is mobilized in order to give us perspective in those regards. But if I can piggyback on an answer I gave a little earlier on, it all begins with mindset and what the mindset of the leadership is. If the leadership is aware of issues, it can drive programs in order to achieve desired aspirations. So if I go back to my own personal experience, I was very lucky to have a well-rounded apprenticeship, and appreciative of that, I seek to promote opportunities for my colleagues who come after me to enjoy the same opportunities.
Thank you, Judge. Thank you, Chief Justice.
Thank you, Honorable Nyambi. Prof.
Thank you, Chief Justice. I'm covered.
Yes.
Good morning.
Good morning.
I'm not going to ask you any questions. You've answered all that I wanted to hear.
Thank you.
Just one question from me, CJ Sirita.
Yes.
Is there a follow-up, Honorable Klaver?
No, please add me to your
Okay,
list.
thank you, sir. Thank you. Commissioner Barnard?
Chief Justice, thank you. I too am covered. Thank you.
Thank you very much. Commissioner Sigogo?
Thank you, CJ.
Yes, good
morning, Judge. How are you?
Good morning. First class. Thank you.
It is quite concerning to me that in a big division like Gauteng, particularly Johannesburg, we have only one candidate for this position. Then my question is, as an acting DJP, have you identified black judges, particularly women, who should be given opportunity to act in that position in order for them to acquire necessary experience to be considered in the future? And if you have done so, have you communicated your same with the JP?
Well, strictly speaking, of course, it's the JP who would be in a position to be making those selection decisions. As you presumably know, The immediate predecessor to the acting deputy judge president's post was Judge Carlse. She did not wish to make herself available for this position, as she preferred to seek an appointment to the Supreme Court of Appeal, which in fact has now taken place. Judge Victor has acted. As regards the other women judges on the bench, my own personal view is that there certainly are those who already demonstrate the right interest in the organizational dimension of the work that could be groomed to be Deputy Judge President in due course. So I'm alive to that. I can't really offer you, from my vantage point, a better explanation of why, among all of my colleagues, I'm the only candidate here. It's not really for me to say. One might assume that some were not interested, others were not interested now, but may become later. All of those are imponderables. But that's about as far as I can really take that.
CJ, just a quick follow-up.
Let me just establish whether Commissioner Sigogo is done.
Yes, I'm sorry.
Have you finished?
Chief Justice, I have another question which is not related to this one. Maybe Commissioner Mpofu can take a follow-up.
Let me just make sure I don't forget that you still have a question. Over to you, Commissioner Mpofu.
Thank you, CJ. No, my intervention won't be as long as that of the Dovu until you forget the second question. No, I just wanted to come back to this question of why you're the only candidate. You've put some possibilities which might be that other people are not interested and so on. But isn't it a fact that the other reason could be that the people who might have thought about it support your candidature?
That is so. Certainly, I've been gratified by a number of express support messages which I've received. And I would hope that if you do approve me, that would be welcomed by my colleagues.
Thank you, CJ.
CJ, Cyril Kaba, because my question relates to this, may I take a follow-up at this stage?
Please proceed, Honorable Kaba.
Thanks, Judge. See, you bring in excess of 2 years of experience as a jurist to this position. And I also can contrast it with the fact that you are the only candidate for this position. Must I construe it as a deference to your seniority? I just want to understand the pecking order in the division. Thanks.
I don't think that deference to my seniority is a factor at all. I'm glad to say that the community of judges in Johannesburg is very egalitarian. There's no bowing and scraping amongst us. And so if it is so that any one or more of my colleagues supports me, I rather doubt it's simply on grounds of seniority.
Thank you, Judge. Thank you, CJ.
Thank you, sir. Commissioner Sigogo, back to you, sir.
Thank you, CJ. Judge, my next question is in respect to the phantom cases that you referred to when you were responding to the JP. In your response, you indicated that about 95% of cases will not proceed on trial, and in a way it could amount to inherent abuse of system and for practitioners to drive fees. My understanding of this phenomenon relates mainly to the cases of the road accident fund. And it has been, I'm not sure, but I believe you are aware that at a certain point, the road accident fund had taken a policy decision not to settle matters before they were allocated trial dates. And if that was the case, were the practitioners left with any alternative other than to get trial dates if their matters were not being settled by the RAF before they got trial date?
I'm not aware that the Road Accident Fund has said that out loud, but I am aware that it is the perspective of many litigation attorneys that that was the case, and that a great deal of the difficulties in Road Accident Fund litigation has got to do with the internal administrative difficulties which that institution suffers from, and its lack of money. Hence the radical decision last year for it to dispose of its entire panel of attorneys. So my remark about abuse of the system is not directed at the inherent dynamics of road accident fund litigation, where attorneys obviously have to respond to the defendant's stance in regard to claims, but rather to a very commonplace experience which is now becoming less common, and that is a matter is eminently settleable months before the trial, but it is left on the roll for no perceptible reason other than to be able to claim a trial fee. In our new system, the room for such abuse is much diminished, if not entirely eliminated, because there is an opportunity to hive off matters which have a prospect of settlement in another channel. And ultimately, the reason we can now have a trial roll of 16 matters and meet all demands for trials on such a number, as opposed to the absolutely nonsensical figure of 120, is that matters do go off somewhere else to settle. Or, if they're not ready, they don't take up space on the trial roll and then extend the lead time. So, from a litigation attorney's point of view, there are huge advantages. One of the great difficulties that inhibited RAF litigation previously was if you had a long lead time, by the time you got to court a year or 2 years after you'd sought a date, your medical expert reports are out of date. You now need an update. So those situations frequently provoked postponements. When your lead time is only 3 or 4 months, there's no danger of that. So we've not been insensitive to litigation attorneys' requirements, and certainly they are consulted in regard to what we want to do. And to contextualize this in the answers I've given to other questions, the system which we have and the system which we ought to persist with is one that meets the needs of the litigating public. And I think we've managed to achieve that. It will require adaptation as we go along. It's not going to be something static.
Thank you, CJ. Thank you, Judge.
Thank you so much. Honorable JP Leo.
Good morning, Judge.
Thank you, Chief Justice. My question, good morning, Chief Justice, and good morning, Judge.
Good morning,
Chief
JP.
Justice, related to the acting people who acted in that position. since the vacancy of that post, and I think I'm covered by the other commissioners.
Judge Sutherland, just one question. Are you aware that your court shoulders the responsibility to run a pilot project on quarter-next mediation, coupled with aspects of judicial case management? Win-win quarter-next mediation coupled with judicial case management, and that there was a report prepared by both deputy judges presidents that was presented to me. Some workshopping happened. Are you aware of that?
Yes, I'm fully informed about that. Judge
Are
Collopin
you? Yes, carry on, sir.
Judge Collopin and I have had a discussion in his role on the Law Reform Commission. He's briefed me on the fact that there's a bill in progress to expand the use of mediation in High Court litigation, and I look forward to seeing what that has to say.
And has your court already begun to implement, following the training program or workshop that was run in Gauteng by a colleague from the US who was assigned that responsibility?
Yes, some of our judges went on that course, and we have transmitted the information which was gleaned in that course to fellow colleagues. Our intention to pursue mediation training was halted by the COVID, and that of course has interrupted many things amongst that. But in more recent times, Judge Keatley and I, Judge Keatley being one of the judges who went to Utah, have been in conversation about what we can do in order to promote that. One of the things that, for example, was interrupted by the COVID was an embryonic project involving family law practitioners in Gauteng in order to streamline our systems to accommodate the particular problems that take place there. And obviously a realm where mediation would be as important as anywhere else. But for the moment, things are embryonic, and we do not have any programs in place at this time. It's work for the future.
Thank you very much, Judge Sutherland. You are excused, sir.
Thank you very much. And thank you very much, Commissioners.
Thank you, Judge.
Colleagues, I don't know whether you'll need a break for the room to be cleared for the purpose of deliberations. Do we need a break, or do we just march on?
March on.
C.
Good morning, Chief Justice. Good morning to all the commissioners.
Are you well?
I am well indeed. Thank you, Chief Justice. And you, I trust you are as well, and the commissioners?
We're very well, thank you. You hold several degrees, am I right? And a diploma.
Yes, I hold 2 degrees. Yes, 2 degrees and several diplomas, yes.
Yes. And what did you do after completing your second degree? Very briefly.
Excuse me, Chief Justice, my second degree.
After completing your second degree, what work did you do?
Chief Justice, I finished my second degree was my LLB. I finished my LLB at the end of 1988, and I started my pupillage the following year in the July. For the next 6 months until the December, I did pupillage. And then in December of 1989, I joined the Johannesburg Society of Advocates, and I've been practicing there ever since.
So for how many years did you practice as a junior, and for how many as senior counsel?
I practiced as a junior for approximately 27 years. And my letters were recommended by the Bar Council in May of 2016. And they were signed and conferred by the state president 2 years later in June 2018. So obtaining my letters in and of itself was a 5-year process.
Yes. And for how long in all have you acted as a judge of the High Court?
Chief Justice, I've been acting on and off, thank you to the JP,
sure.
Since February of 2016. So I've done 64 weeks in total. That's by my calculation. And during that time, I've been lucky enough, privileged enough, to act in all of the courts that the Gauteng division offers. So I've sat in Johannesburg, I've sat in Pretoria, I've sat in the motion court, unopposed and opposed. I've sat on appeals coming from the magistrates court, both criminal and civil. I've sat on full court, civil and criminal appeals. And I've sat in the tax court and, of course, in the civil trial court. So I've covered the range of what is available in our courts. And my submission is that I'm properly qualified and I'm properly experienced and adequately so, if the Commission considers it appropriate to accept my appointment.
Thank you. JP, before I invite you, let me just have a list of my colleagues, my other colleagues who would want to put questions to the candidate. Colleagues, please give me your names. And as I do, President Maya, please jot them down. And you, Judge President Lambo, since you are on the ground, if you could also just jot down the names as they are mentioned.
Martin Sera.
Liam.
Thing.
Bofo.
Maturo Dlepu. Makwanisha.
Tepe. Schlemmer.
Arnold.
Thank you. JP, over to you.
Thank you, CJ. In terms of this task you've given me, the commissioners were very fast. I only have 1, 2, 3, 4, 5, 6 names. I think you have more than that. but I just thought let me make that disclaimer up front. I missed some other names, so I'm sorry about it.
That's fine. If I happen to leave, I'll mention a name or two that are left so that we can take care of that, together with President Maya, of course.
Thank you very much, Chief Justice. Good morning, Advocate Crutchfield.
Good morning, JP.
You've said at the end of your questioning by the Chief Justice that you think you experienced, you acted in almost all the work areas of the division, and you're ready.
Indeed, yes, JP.
Right. Mine is just to confirm to you that I've given the Commission the spreadsheet of work allocation since you started acting. It's 64 weeks. You've done your fair share of the heavy lifting work. I think that's all I'll say. The Commission will ask you what I mean by heavy lifting. That is, you've done 7 solid weeks in the opposed motion court, and then you've done the special motions. You've done 3 special motions. Those are the complex special motions that don't go into the opposed motions.
Yes, and JP, if I may,
yes,
at this stage, I have 2 reserved judgments that are outstanding.
Yes.
One of those is a special motion, and it dates from the 30th of November.
Yes.
It sounds an excessive period of time. I'm aware of that, but it is a very big matter. It actually includes 4 separate applications. They overlap, they interlap. There are complex and difficult issues that arise. They deal with Anton Pillar orders. The main application is the return day of an Anton Pillar application. It covers issues of unfair trade, issues of, unfair competition, issues of restraints of trade, issues in respect of the Anton Pillar itself. Also, there are questions of urgency in respect of all the matters. The other matters deal with restraints of trade, unfair competition, and there is also possibly an opportunity to develop the law based on the Bierke judgment in the Constitutional Court in 2017.
Okay, thank you for that.
And my apologies, Chief Justice. And then there's one that follows from, JP, from the 8th of, in fact, the 9th of December, but it's the big one that is delaying the second one. But I give you a solemn undertaking, they will be delivered within the 6-month period.
Okay. You've sat in 6 full court appeals. Did you write any of those judgments?
Yes.
How many?
JP, I wrote the last 2 that I sat in, and I wrote 3 of the previous ones. And I sit in a full court appeals, civil full court appeals next week, and I am going to write the full court appeal on Monday, and I have a criminal appeal on the Thursday, a 2-bench appeal, and I'll write that judgment as well.
Yeah. My last question is, you've been acting on and off. The longest stint was, I think, was a term, if I'm not mistaken, the 3rd term of 2020, where you acted for 8 solid weeks.
Yes, that's right. Yes, that's right.
That was a statement of intent to see if you could last, if you are allocated a permanent judge's workload. Right. So you are happy that you've acted enough, and coupled with your experience as a silk, you're happy that you are more than ready to take up a permanent appointment.
That is my view, Chief, at JP.
In particular, taking the work of the division, you've acted in both the complexity and the volume.
Excuse me, JP.
The complexity of the work we deal with, as well as the volume thereof.
Yes.
Thank you. Thank you very much, Chief Justice.
Thank you, JP. MEC?
Thank you so much, Chief Justice. Good morning, Advocate.
Good morning, sir.
I listened attentively to your justification for the delayed judgment and I'm very sympathetic, but the reason why people go to court is because they want justice to be served. Excluding what we have just said, what is your attitude primarily to people who delay their judgments?
Judgments should not be delayed. There's no question about that. Justice needs to be seen to be done. Judgments should not be delayed. And yes, I know that I have had some judgments which have been delayed. But far as possible, they should not be delayed. I would add one rider to that. Some people hold a view that just get the judgment out, whether it's right or wrong or it's upside down or whatever, just deliver the judgment. I come from practice. I know what the costs of appeals are to the litigants. And I try to weigh both. And I would also add, I do add to that, is that my appeal rate appears to be very low. I have not had a lot of judgments which have gone on appeal. So, yes, I am aware of delayed judgments, and I am aware and I endorse the need for judgments to be delivered timeously.
Gauteng is a home for everyone.
Indeed.
With all people speaking all languages.
Indeed.
Beside English and Afrikaans, any language that you think?
I could greet you in Sotho or in French. But other than that, I'm afraid not. And I agree with you that it is better if people, especially living in South Africa, where we have 11 official languages, are able to converse in more than one language. And I think it's immediately a transformative moment if you can converse with somebody in their own language. And as a result of that, I'm a strong believer in that. I'm heavily involved in the transformation activities in the group of advocates to which I belong. And pre-COVID, during 2017, I put in place you could call it a course, whereby we got somebody, a teacher, to come and teach people who were interested to learn Sotho. It wasn't overly successful, unfortunately, because what would happen is somebody would attend on day one, and then on day 2 or day 3, they had to have an urgent consultation or they had an urgent application. But certainly, we just didn't get it right. There was something that we were doing wrong. But it is something that has to be considered and taken forward.
Thank you so much, Chief Justice. I'm fine, thanks.
Thank you very much, MEC. Advocate Madonsela.
Thank you, Chief Justice. Good morning, Advocate Cashford.
Good morning, Commissioner.
My question relates to your qualifications. I see that you have enrolled twice for an LLM degree.
Yes.
Or LLM degrees in, I think, constitutional law and tax law.
They were two, yes.
How did those two courseworks, how any one of them equipped you to be better suited for judicial appointment? 1, 2, what were the difficulties in finishing them?
Excuse me, Commissioner, I didn't hear the last part of your question.
The first question is, how did the two coursework programs that you did equip you for the judicial appointment? And in relation to the second part of the question, I ask you, I asked because I'm probably in the same difficulty as you. What difficulties did you encounter in finalizing the thesis pertaining to both?
The second question is, let me answer that one first, if I may. The difficulties in finalizing coursework are simply an absence of time. I still hope to finalize the thesis for the LLM. I have a topic in mind, and there is still the possibility that BITS will allow me to do that. So I'm hopeful that that can still happen. I haven't abandoned that. In respect of the first one, again, it was an absence of time. And yeah, that's all. But may I please add, I have loved both of those. The first one dealt with constitutional law. There was a module in advanced administrative law and advanced contract law, and then there was privacy. And all of those different areas of coursework have assisted me in my practice, and hopefully going forward, if the Commission will have me, in respect of my work. Then, as regards the tax, I've always been interested in tax. Everything somebody does has a tax implication. And as a result of that, I did that course and I thoroughly enjoyed it. And the issues that we are seeing economically at the moment in respect of stretched supply chains, so we have supply chains through various countries. None of those companies have a head office in any one particular place. They operate off a computer, set up operating off a remote service somewhere. It impacts upon the tax collection in any country. We see that with some of the big Amazon, Google, all of them. And yeah, I've loved all of that work. And although I may not have practiced directly in those particular fields, it's served to inform greater knowledge in respect of everything else that I do. I'll never regret doing any of the courses that I've done. Never. I've learned from all of them. I've benefited from all of them, and hopefully I'm able to use and impart some of that knowledge for the good of others.
Thank you, Chief Justice.
I hope I've answered your question, sir.
Yes, you have.
Thank you.
Thank you so much, Jesse. Judge President Leo.
Thank you, Chief Justice. Good morning, Advocate Crutchfield, SC.
Good morning, Commissioner.
Yes, I'm just need clarity on this reserved judgment of Most Than Another, which wherein they say you took almost a year to hand down the judgment. Can you give the circumstances under which you had to delay, or what caused the delay in you handing the judgment for almost a year?
Yes, ma'am. It was a big matter. That's the first thing. But you may have seen from my application that judgment happened, or the matter was heard in July of 2019. And with effect from September or October of 2019, I was appointed as the pupillage chair at the Johannesburg Society of Advocates. That would all have been fine, except that at the beginning of 2020, we ran headlong into COVID. And the amount of time and the amount of work, regrettably, that it took me to deal with the issues that arose from there impacted significantly upon the delivery of that judgment. I acknowledge that it is wrong. I agree that it ought never to have happened. There's no question about that. But in effect, those are the reasons. If the pupillage chair under COVID hadn't taken place, well, it wouldn't have happened. There's no question in my mind about that. And it's been a very good lesson. There's no doubt in my mind about that. And that will never happen again. and I go back to the question that the Commissioner raised earlier in respect of the delivery of justice. For justice to be effective, it has to be delivered as promptly as possible. And as promptly as possible would be certainly within the 3-month period, and even sooner than that. And you will have seen from my application that I have for my full court civil appeals, I think the one runs to the most to 4 months, and there were circumstances that related to that. But on average, they go out on 2 months. So I've learned that lesson. And it's just wrong.
Yes, thank you, Chief Justice.
Thank you, JP. Honorable Singh.
Thank you very much, Chief Justice. Good morning to you and to all the commissioners and admin team, and good morning, Advocate Crutchfield.
Good morning, Commissioner Singh.
I see that you have chosen in your questionnaire on page 11, item 4, to disclose under any matter to bring to the attention of the Commission that you had 2 great uncles. One great uncle, A.E.G. Trollope, who served between the periods 1958 and 1981 in political capacities in the Vervoet/Foster governments, with Mr. Trollope, your great uncle, ending up as Minister for Immigration and Indian Affairs in the period 1966 to 1968. And then you've also disclosed there that one of your great uncles was Judge Trollope J.A., who served from 1969 to 1981. Now, one can understand that you were very young. You were not even born when some of them were appointed. I'd just like to know, firstly, thank you for disclosing that, because I don't know if our research would have found that out. Why did you disclose that? And have any of their policies and their thinking impacted on your thinking? And then what do you were 16 years old when Trollope J.A. was a judge. So I just want to know how it has influenced your life one way or the other. Thank you.
Well, going back to A.E.G. Trollope, I never met him. And I was born in 1965, so you can see that he died 7 years afterwards. I thought it was right to disclose that he had held the position, and then particularly that he had been in charge of what was then called Immigration and Minister for Immigration and Indian Affairs, and that he served under Verwoerd's government. I wanted that to be on the table and for people to be aware of it. I don't hold with those policies. In fact, they're inimical to everything we do, everything we believe in. But I considered that it was the right thing to disclose it. As I say, I never met him. His policies never influenced me. And yes. In respect of the late appeal court judge, to a certain extent, he would have been a role model in terms of the fact that he was committed, that although it was difficult under the Foster government, you still had a liberal wing on that bench, and he formed part of that. His judgments in respect of commercial law still stand today. And insofar as there was a reference made to my diplomas, my qualifications earlier, one of the things he said to myself and my older sister was, education is never lost. You can never over-educate yourself. Even if you don't, if you study nursing and you don't actually practice as a nurse, what you have learned will always stand you in good stead. So to a very large extent, that influenced me. And I think his ethic of service, when he was appointed to the appellate division, as it was then called, His family, he had a wife and children. They remained in Johannesburg, and he worked and lived in Bloemfontein. So his commitment was such, both to the bench, to the judiciary, and to doing the right thing in terms of the law, that he was prepared to make that sacrifice. In effect, I think what I'm saying is that he was a role model.
Thank you very much, Advocate, and I'm sorry that it got you emotional.
No,
I'd just
not
like
at
to
all.
know, oh, is it just the cold, the slipping
No,
of
I
Gauteng?
am emotional. I'm stressed. I'm emotional.
Yes, no, one can understand that when you speak of somebody that you've lost. Have you had any occasion to disclose this on any public platform?
No.
Or in any speech that you gave or anything like that to talk about this and your relationships?
No.
No.
There are very few people. I never wanted to go to the bar and trade on particularly the late judge's name, or to his two sons were both attorneys, and his nephew was an attorney and counsel. I never wanted to trade on their name. There are, in fact, very few people who know. There's a handful of people at the bar who know that I'm related to them. One of his sons, or sorry, it's one of AEG Trollope's sons, rather. In fact, I'm sorry, I've given you the incorrect information. It was AEG Trollope who had the two sons, and then the two brothers had a nephew. But one of those sons said to me, if you want to go to the bar, go to the bar. Do it. And yeah. So no, in short, to answer your question, it's not something that's widely known.
Thank you very much, Advocate. Thank you, Chief Justice.
Thank you, Honorable Singh. Advocate Mbofiasi.
Thank you, CJ. Good morning, Senior Counsel.
Good morning, Commissioner.
Yes, thank you. I just, before I ask my question, wanted to say that I don't think that you needed to disclose your apartheid supporting ancestors, because I don't think that people should be individually accountable for what happened. There were more than 10 elections which excluded African people since 1948, and in all of them, white people by far majority, 80 or 90%, voted for apartheid. So you're not more guilty just because you had a relative.
Thank you, Commissioner.
Thanks. Yeah. Now coming to the well, I think I interviewed you for your silk application.
You did indeed. I was very grateful that you were present.
Thank you very much.
Commissioner, if I may,
yeah.
That was the third silk interview.
I remember exactly that. And I remember speaking specifically about transformation and the initiatives which you have done, and you can see how impressions last. I can't remember exactly what you said, but I remember that it was good. It was
very glad.
Now, more specifically, what I want to ask you about, because as you know my views on transformation, particularly at the bar, the professions general. There is, the fact that it took you 27 years as a junior to have to apply for silk, you know that people are eligible around 12 years or so, so more than double the amount of time that it would take an average male advocate, let's put it like that. To what extent can you attribute that to the gender dynamics of society, particularly when you started, and the fact that there's stereotyping about, what white women advocates or women advocates at all are only good for unopposed motions and divorce and all
and
that.
Matrimonial law.
And all that, yes. To what extent did that impact on retarding your progress, literally? And of course, the point I wish to make is that if that could happen to you as a white woman, you can imagine that the burden is doubled for black women who have to deal with the gender dynamics and the race dynamics. But let's focus on the gender dynamics and maybe in your answer, so that I don't have to ask a follow-up, you can say what needs to be done to break those barriers, the gender barriers in particular.
Yes, thank you, Commissioner. Just going back to the burden in respect of Black women, African women in particular, but Black women generally, and when I use the term Black woman, I include African women, Indian women, and colored women. I think they have it worse than white women. But your question is spot on, if I may, Commissioner. I was 24 years of age. I didn't come to the bar with contacts. I didn't come to the bar with a ready-made network. I did what were then, in those days, criminal pro deos. And I have sent through the list, I'm not sure if it's come through to the commissioners, of the criminal work that I did and the pro deo work that I did. Quality work of a commercial nature was simply not available in those days. I was lucky enough that the late Karen Folks-Jones, when I had been in practice for approximately 3 or 4 years, joined our group as leader of the group. And she, to the extent that she was able to, she gave me some of her unopposed divorces and some of her unopposed Rule 43s. But in those days, and to a very large extent still today, if you were female and at the bar, you did unopposed divorces, that was all that you were good for. You didn't know about anything that was vaguely commercial. And the result of that is that your skill level is in effect pigeonholed. Your confidence in everything else depreciates. And you begin to think, well, I can only do divorce work, unopposed Rule 43 work, matrimonial type work. And I can remember, like it was yesterday, when I went through for my first silk interview, which I think was in 2013, one of the people on the panel said to me, would you be prepared to act if you were asked? And I said, yes, I would, because I've always believed that we have an obligation. And the comment from one of my very senior colleagues on that panel was, but oh, Alison, do you really think that you'll manage? And that, to a very large extent, has been the experience of not only myself, but all of my female colleagues. And you watch as junior male colleagues who are junior to you get better briefs. And I don't mean necessarily more lucrative, but briefs that are more demanding, briefs that are more challenging, and briefs that are not solely focused on matrimonial law. And that in itself is devastating. There was an incident that one of my young female colleagues told me about approximately 2 years ago. She walked into a court, she had a commercial type matter. And the judge convened the court and said, oh, Miss A, B, and C, we don't usually see you in this court. Now, the judge never meant anything derogatory. I've got no doubt about that. It was just a comment that was made. But the effect of that was her confidence immediately reduced. It evaporated. Her attorney's confidence in her, in respect of that particular matter, evaporated. Her client thought, well, now what? His confidence in her immediately evaporated. So one needs to be more aware of the position, well, I think one needs to be more aware of the position that women find themselves in, even 30 years on, and of the effects of what has gone before. In respect of your question, Commissioner, as to the delay, how it's retarded my progress. Because you only deal in matrimonial law, your judgments are not reported. So you don't find yourself in the law reports. You don't experience that sort of, you don't become known by way of your judgments. And when I went to what was my second Silk interview the following year, I was told, but what reported judgments? And I said to the gentleman concerned, have you even read any of them? Well, no, he hadn't read any of them. And all of the reported judgments that I have from practice make some contribution. But they weren't commercially based judgments. They weren't for wealthy clients. And he hadn't even bothered to read them. So there is no question that progress in terms of work quality, progress in terms of just moving up the ranks out of matrimonial law and the like is retarded simply by the fact that you are female. There's not a doubt in my mind about that. And we're still seeing the effects of that today. And yes, the burden on our African women, our black women, is significantly worse. But there's one more thing that I wanted to add. And now I've forgotten what I was going to say. I've lost my train of thought. But Commissioner, it is an extremely valid point. Yes, what can we do to correct it? We've got to end the scourge that is gender-based violence. There's no question about that. I'm a great believer in education. We can't have every woman being a doctor or an accountant or a lawyer. But if we can reach a position in our society where we can educate every single young woman, keep them in school for longer, put them in a position where when the boyfriend, husband, the partner starts to hit her, she doesn't have to stay. She has enough confidence in herself. Her skills have been developed to the point where she can take her children, she can leave, she can put a little roof over her head, food on the table, and just keep her and her children out of that environment. This body, this commission, has the power to make the change. We need more women. We need more women as role models on the bench. We need to be able to show we are struggling to keep our women, black, white, Indian, in practice. I think the attorneys manage it better than we do, but our statistics in respect of women from approximately, well, now with COVID, it's basically from year one. They're decreasing, notwithstanding the work that we put into trying to develop them and keep them in practice. We need more role models. We need people, we need society to change, to see women are not only good for being in the home, they are more than capable to entrust them. And this is the body, in my view, that has that ability to do so. And I think we have an obligation to do so, to make the change, to bring in more African women, more Indian women, and even more white women. We need more women. That's my plea to the Commission. And please let people give more women better quality work from as early in a stage in their practices as possible.
Okay. Thank you, Alex. Thank you, CJ. On a lighter note, I'm glad that your third Silk interview went much better.
I was very happy to see you there, Commissioner.
Thank you.
CJ, can I take a follow-up, please?
Please go ahead, Honorable Lucas.
Thank you very much, CJ. Good morning.
Good morning, Commissioner.
As a Crutchfield, I don't have my glasses.
Oh, like me.
So I was listening to you attentively, and I'm sure if you have watched the interviews last week, you would have seen that there is something that is very close to my heart, particularly since we had that exercise as Parliament where women felt that there is really a lack of compassion in your profession, particularly those that are in front of courts and also those that are aspiring to become advocates and judges. Now, at a very structural level, in your own practice, what have you been doing to make sure that you empower, and particularly Black women, to make sure that you have also made a contribution to those things that you are so passionate about, that we can make a difference?
Commissioner, thank you. If I can go back to the point that you raise in respect of empathy. I have stood in courts at 24. I've been overlooked by judges. I've been humiliated by judges. And I know that terrible fear of being young and being female and being terrified of being in a court. I can remember that like it was yesterday. And I see that fear in front of me when I act on the bench. And people have spoken about my temperament, my empathy. I try desperately hard to bring empathy to our young female practitioners. I can see that my own terror playing out in front of me. I have actively tried to bring that into all my acting stints, and I shall continue to do that for so long as I can. In respect of my own contribution towards empowering our African women, I've been involved at various levels. We have, as I'm sure you know, the society of which I'm a member, and then we practice in groups. And I practice in a particular group. I have worked actively within that particular group to uplift our African, our Indian, and our colored women. We, over and above the language course that I tried to implement, I've also managed a skills upliftment, because we need to have a transfer of skills. And we've done that in two ways. We've done that in terms of making opportunities available to our youngsters, and those opportunities come together with a payment that is sufficient to keep them in practice. We've had to reduce that payment because of COVID, but it is sufficient to help them along. Now, in respect of our information, and I don't want to call it a lecture program, because it's not a lecture program. It's an information, it's a discussion, and it's an attempt to enable our young practitioners to get their practices up and running and to keep them in practice. That is the goal, that's the ideal, to keep them in practice. So we start with a talk on practice management. Respond to your telephone calls. Answer your emails. Don't wait a week to answer your emails. The attorney's waiting to hear from you. Tell him that you've read his brief. A talk on ethics, and a talk on tax and VAT for advocates. Not a talk on tax so that you can go and lecture tax, but just as an advocate, you need to go and make sure you register with SARS. Make sure that you have two bank accounts. Make sure that when the time comes, you register for VAT. Fees, how do you charge for your fees? And we assist them with that. Once we've got past those introductory issues, we then focus on, if you get a call in the morning, Tuesday morning, 8 o'clock, an attorney wants somebody to do an insolvency application. What do you need to know? What are the things you must find in your brief? What are the essentials that you need? Same with things like bail. All those disciplines that will assist our youngsters so that if somebody does approach them, they're immediately able to run with that particular matter. It gives confidence and it enables them to deal with whatever it is that the attorney wants. So I've run that. Insofar as the actual skills of becoming involved in work, we do it in two ways. We have a fund to which we all contribute, and I have gone out of my way. I wasn't one of those who had briefs which came included with juniors, so I've had to find other ways. And what I've done is I've leveraged my own contacts. When people have come to me and said, please, I need help with a brief, can you help me find something? I've gone out and I've leveraged my own contacts and said, please, I need you to help somebody with an opportunity to come and assist you in a brief. And there was a joke in my group at one stage. If you see Alison, avoid her, because she will ask you if you have a brief that you can accommodate somebody, if you're willing to give a talk, if you can help somebody with something else. And I can give you an example. So the bar has something called a Rule 7. And each member above a certain standing has to engage with another member, bring another member from a different group that you aren't acquainted with, and bring that member into a matter. Anyway, I kept contact with the lady with whom I was involved last year. And I had contact with her last week or the week before, and she just said to me that practice is very difficult. And she's an African woman, and I know that she's a single mother with children. She just said she thinks that things are not good. And I said to her that I know what area of work she does, I know what she wants to do, and I said to her that I will make some calls. I can't promise her that I'll be able to find her something, but I do promise her that I'll try. And I'll take some time this week and take some time next week to get her something, to try and keep her in. It's exposure, ma'am. It's empathy. It's giving people that confidence and giving people that opportunity. What we try to do, and I know I'm taking up everybody's time, but one of the aims of our skills development is bring somebody into a matter. So there is an attorney that's involved. Hopefully, the attorney will bond, for want of a better word, develop a relationship with the youngster, and the youngster will then in turn benefit from work that flows to the youngster. And we are seeing some success, I'm happy to report. But things are tough with COVID. The amount of work that's available has diminished. But we're trying. We're trying.
No, thank you very much. And
Thank you.
In any case, practical things appeals to me that I can tell you. Thank you.
Chief Justice, I have a follow-on also arising from Commissioner Mpofu's question, if I may.
Please go ahead, Advocate KNSC.
Thank you very much. Hello, Alison.
Good morning, Commissioner.
I recall that when we interviewed you and you were recommended for Silk, I think it may even have been me that expressed a concern that you should in future get involved in bar-related work. And you've given a detailed answer of the work you've given in your group since you took Silk, but you haven't mentioned adequately, and I think you would do yourself an injustice not to mention it, that you did in fact come very heavily involved in bar-related work after taking Silk. And not a long answer, but if you could just outline what you did, please.
Yes, I'm sorry about my long answers, but I acted as the pupillage chair last year, and I was heavily involved in operating that program, giving effect to that program. And the short answer is, we very quickly reformatted our lecture program for our pupils so that we no longer had in-person lectures. We had remote lectures. Together with the vice chair on the Bar Council, we were able to ensure that all of our less privileged members had access to data. So everybody was able to listen to their lectures. And what we did was we recorded every one of those lectures with the lecturer's consent. Those lectures are stored, and we've made them available to bars that have requested them. Polokwane in particular has made use of those stored lectures because they don't have a lecture program that's as comprehensive as ours. But that wasn't sufficient because we also run an advocacy training program, and we have to reach a certain point in order for the attorneys to commence with their conversion process. And we managed, fortunately, to reformat our advocacy training program to an online program, and it's still running today as an online program. It has required a substantial additional commitment from our members, because whereas previously we used to have 9 or 8, 10 pupils in a group, we now have 5. So I participated in our advocacy training, and I'm sure Commissioner Mpofu and Commissioner Kane were there over the weekend as well. We had 5 pupils in our group. We had 3 members. So myself and 2 of our colleagues. In some of the other groups, we have judges, but I was so proud of them. They did so well. So yes, it was an enormous amount of work. Come September, we received 207 applications for pupillage for this year. We interviewed, and I led that process over 2 weekends. We interviewed 200 of them. And it's a monumental task, but we did it. In addition, we have reviewing teams which review, without an interview, every single application. So suffice it to say, thank you, Commissioner. I followed on from you, but we worked extremely hard, and we had a measure of success, and hopefully we can continue building on that this year.
Yes, you did. Thank you very much. Thank you, Chief Justice.
Thank you, Advocate Kane. Commissioner Dlepu, Matolo Dlepu.
Thank you, CJ, and good day, Advocate.
Good afternoon, Commissioner. Good morning.
Okay. I've been listening to the challenges that you have been facing and women are facing in the bar. And I tend to wonder, what can women themselves do to change that, those are in the bar? I'm saying this because one of the things that the Legal Practice Act is seeking is to have access to the profession. And it looks like the bar councils actually are not actually doing much about it, especially the society that you belong to, that actually does not want people who did not self-pupillage with them, having the chambers in the same building that you have. For me, it does not reconcile. I can't understand why, because by doing that, you're excluding the people you're talking about. I mean, you say you have interviewed about 207. And how many of those 207 your Society of Advocates is able to take?
I can give you the statistics, ma'am, Commissioner. We have, this year, we only have capacity for 70. Please keep in mind that our pupils pay a minimal amount for their pupillage. We are not like Lead SA, which gets paid for the work that they do. So we have limited amount of resources. We have 70 pupils at the moment, and I can give you the breakdown. We started off with 80, but 10 dropped out along the way. At the moment, females, we have Black, Indian, and colored, we have 28. White females, we have 18. Males, African, Indian, and colored, we have 24. White males, we have 8. So there is, within the capacity that our resources provide us, we emphasize African people, Indian and colored, over white people. And certainly not only in terms of race, but in terms of number. There is an emphasis on previously disadvantaged people, and giving those people access to the profession and trying very hard to assist them for so long as possible. Insofar as you refer to chambers, we will accept anybody who is properly qualified. We have many people doing pupillage in Polokwane and joining us. There's no difficulty with that. They're admitted advocates. In effect, we have the same requirements as the LPC. The LPC requires that advocates do a theory course, that they do a practical course, that they write an exam and they pass it. We have the same requirement, and also the LPC wants us to register, which we do, and pay our dues, which we do. And we don't have anybody who is properly qualified, who does pupillage within the GCB, not necessarily with our society. Polokwane, Limpopo, you're free to join us. And so I disagree that our policy is anti-transformation. Within the resources that we have available to us, we take as many pupils as we possibly can. Our members give of their time freely and voluntarily. Our lecturers lecture, they don't get paid, they volunteer. Our people who write, who mark legal writing exercises, they volunteer. The advocacy trainers, they volunteer. We call upon a huge number of members to come and do your duty, to come and help. Assist our pupils and assist others in giving them access to the profession. I agree with you that we need to broaden not only access to the society and to the GCB structures, but to access to the profession as a whole. There's no doubt in my mind about that. There is a desperate need for legal resources, for legal advice in our rural communities, and we need to be in a position, the profession as a whole needs to be in a position to service that.
Just a follow-up. As you agree with me that you need to broaden your intake, or make sure that there's access to the profession, what do you think you can do as a society of advocates? What do you think can be done, or you can do, to make sure, because out of the 200, there's 1,000 more who can't find privilege. What do you think we should do combined? I don't want you to be talking about the LPC as another body, because all your body falls under the LPC.
Yes,
so
absolutely.
What can we do to do that?
Ma'am, regrettably, our limited resources are a problem. But there is a thought that instead of, for example, us giving coursework lecturers, theory lecturers, that a school is set up for pupils where they can do their theory, perhaps for 6 months, and then they can go off to the different organizations, because it's not only the GCB structures that are involved in pupillage, there are also all the independent structures that are involved. We just don't have the capacity to train all of the potential advocates in the country. Our members are, as I've said, free, they're volunteers. We have limited resources. Possibly, if the LPC or if the Department of Justice is willing to pay, we can make an arrangement. I think the point I'm making is the GCB, the JSA, and obviously I don't represent them here today, but I have no doubt that they would be amenable to assisting. May I interrupt myself to say that the funding that the LPC has made available to pupils this year throughout the country is of enormous assistance. There's no question about that. The pupils who have received it are enormously grateful, and it will serve to assist hugely. But we need to extend, just going back to your original question, if I may, we need to extend access to learning throughout the country. It's a concern that I have in respect of the fact that the GCB isn't accredited for pupillage. I'm very worried that it's going to lead to a weakening of the rural bars. I'm concerned about that on a long-term basis. But we need to increase access and capacity at those bars and at the independent associations. Extend the reach of the independent associations. so that there are more opportunities available to potential advocates.
Thank you, Chief Justice, and thank you very much.
Thank you, ma'am.
Thank you, Commissioner Zepu. Honorable Magwaneshi.
Thank you very much, Chief Justice. Good day, Judge.
Good morning.
Yes. Can you enlighten us about your commitment to the culture of human rights before 1994 and after 1994? I can see from your CV you graduated in 1986 with a Bachelor of Arts degree. It was during a time when it was very turbulent in our country. Were you involved in with any community organization during that time? And then after that, what did you do?
I wasn't involved directly. I can't say that I was. I was involved insofar as I witnessed what went on around me, and I was a Wit student. I saw and I heard what went on, and I think we were all greatly troubled about it. I have a fear of crowds as a result of some of the things that I witnessed on campus, and I can still remember exactly where I was standing when the last state of emergency was announced in the late 1980s. So I can't say I was actively involved in anything, but being at WITS gives you a greater awareness. There's no question in my mind about that. And my awareness of social issues in particular, of the issues that women have in society, and now I'm in a position where I've experienced them myself, gave one a greater awareness of that.
If I may proceed, Chief Justice, the last question.
Yes, Honorable Magwaneshi, go ahead.
Thank you very much, Chief Justice. I've been looking at your CV. I think it's a follow-up to Advocate Matontela's question. You finished the coursework for your LLM in 2007. And then the thesis was outstanding. Then you started, and then you did the advanced program in insolvency in 2014. Then you started with LLM in tax law, 2016, 2017. Thesis is still outstanding. Then you continued doing other courses. Another person would say it's not the question of time, it's a question of prioritization.
Excuse me, sir, it's a question of?
Prioritization. And that person would also link that with the outstanding or reserved judgments. Can you put us at ease that it's not the issue of just prioritization? This CV would not reflect you as a judge in terms of timeous delivery of judgments.
Yes. Commissioner, if I may, if one looks at the curriculum vitae as it appears, one will see that 2007 was the coursework for the first LLM, and the next course was only in 2014. So it's not a case that I simply abandoned the thesis and then went on to do the insolvency litigation. I still hope, certainly in respect of the LLM coursework, to finalize that thesis. It's not a case that I've abandoned it altogether. I certainly haven't. In respect of your reference to the cyber law and the competition law in the following year, I can see where your question has its source. But those courses were both done at WITS, and WITS only offers, they don't offer them every year. So if I hadn't done the competition or the cyber law, I may not have been able to do it. There's no certainty that they will definitely offer it the following year. And that's why I elected to do those two at that point. And there are two things that I've always been very interested in. I think cyber law is where the future lies, and competition law, I'd always had an interest in it. And the pension law was another thing that I'd always had an interest in. And one can see that it was only the attendance course, it wasn't the exam course, 2019. And that is simply, and you've referred to the outstanding judgments that took place in 2019 and subsequently into 2020. The one commenced in 2019. I originally started that course with the exam course. And I realized during the year that I just wasn't coping. And I had to downgrade that course to the attendance course, which was unfortunate. That ties in with the workload. It ties in with becoming the pupillage chair at a later stage. And already at that stage, I was actively involved from the end of 2018 on the Bar Council and already tasked with a significant portfolio there. So it was a case of where was the master. And certainly my bar work, the importance of what I was doing for the society and for the membership overrode the importance of the thesis for me personally, and doing the exam course for the WITS pension, the pension course. I'll go back to that LLM in respect of the tax course. A friend of mine who was also involved in it has just submitted hers recently. So I haven't closed the door on that at all. I haven't abandoned that. It's not a character. It's not a character flaw. But I understand your concern. I hope I've answered your question adequately, Commissioner.
Thank you very much, Judge. Thank you, Chief Justice.
Thank you, Honorable Magwanishe. Colleagues, I thought I would raise this after the candidate is gone. But at the rate we are going, with 8 more candidates to go, and a meeting scheduled for 6 p.m. tonight, I think we've got to reflect on how we really want to proceed. We're not making progress, the kind of progress we had agreed to make. Commissioner Tsepe?
Thank you, CJ. I will assist you and not ask any question. Thank you.
Thank you for assisting the process, Commissioner Tsepe. Prof?
Thank you, CJ. To a large extent, Commissioner Mgwanishe asked the questions that I was going to put. I just want to ask one follow-up on that. The Muster judgment that was outstanding for that period of time, specifically also during the period that you did pension law. It's just for curiosity's sake, is it because you were dealing with pension funds in that case that you also decided to do the pension law courses, or is that just coincidence?
No, that was just coincidental. And the pension funds, the pension fund aspect enhanced my interest in pension fund, and the pension fund course enhanced my interest in the matter. So that is coincidental.
Thank you, CJ.
Thank you, Prof. Commissioner Barnett?
Thank you, Chief Justice. Good afternoon, Advocate.
Good afternoon.
My question is just on the Muster judgment. Having spent such a long time in preparing the initial judgment, let's say close on a year, one takes the point that it's a long, the record was quite long, 1,600 pages, etc. So that point is well made. The question is this, having heard that and then hearing an application for leave to appeal, having spent such a long time with the matter, would you not have at that stage have had a good idea on hearing the argument in the application for leave, whether or not there was a realistic chance of success on the prospect of success, than to take a further almost 3 months to deliver that answer or that judgment?
Yes, I'm aware of it. The application for leave to appeal raised additional information and, well, not additional information, additional illegal points that were, it wasn't confined, let me explain it this way, it wasn't confined only to the issues that were raised in the case originally. In fact, one of the points that was raised by one of the parties was that the applicants had moved away from what they had argued originally in the main application. And there was new case law that had to be considered as well, and so on and so forth. But the point is that the arguments were not located solely on what transpired in the original application.
So given those facts, you're still happy that it was a reasonable time it took to grant that judgment?
It was an important judgment for the parties and, well, to me as well. And the issues are not easy.
Thank you very much, Chief Justice. I'll also drop the second question.
Thank you very much, Commissioner Barnett. Advocate Crutchfield, SC, you're excused, ma'am.
Thank you, sir. Thank you to all the commissioners.
The candidate is ready. Thank you.
Thank you very much. Good afternoon, Mr. Dosio.
Good afternoon, Chief Justice.
Are you well, sir?
I'm very well. I hope you're well too.
I'm very well, thank you. You were prosecutor, district court magistrate, regional court magistrate. Give us the total number of years over which you were a prosecutor and then magistrate, both district and regional.
I've been in the profession for 30 years, Chief Justice.
Well, for how many years as a prosecutor and for how many years as a magistrate?
It was 5 years as a public prosecutor, 5 years as a district magistrate, and it's 20 years as a regional magistrate, of which basically 11 and a half, 12 years were in the criminal regional court, and the remaining basically 7.5, 8 years were in the civil regional court in Johannesburg.
Yes. And for how many terms have you acted as a High Court judge?
Well, in total now it's about 17 months and about 2 weeks. I've served quite a few full terms and then intermittently for 5-week periods at a time, either in the criminal or in the civil division.
Thank you. Colleagues, may I have your names, please? Those who have questions. All right. JP?
Yambi.
Oh, all right.
And Commissioner Schlimmer as well, please.
Muima.
Matolo Jepo.
Maya.
Over to you, JP.
Thank you very much, Chief Justice. Mr. Dosio, you've given me quite a lot of your time to come and act in the division since 2013, and I thank you for that. And you are what one calls a well-rounded magistrate, am I correct?
I think I am.
In the sense that you've dealt with criminal matters as well as civil matters.
That's quite correct, JP.
Right. And what that is borne out by is the spreadsheet of work allocations, which shows you've acted for 70 weeks, 70,
That's
in the
correct.
division. And you've done your fair share of heavy lifting work, especially in opposed motions. You've done 6 full weeks there.
That's correct.
The full court matters, full court appeals you've set in, have you written any of those judgments there?
Well, JP, in all the 5 weeks that I did sit, for those weeks, I did write every single one of the full bench. 2 were criminal, 2 were civil.
Yes. And you've spent quite some time in the criminal trial court. And am I correct that you are one of those acting judges who've never had big problems in finalizing your criminal trials in the High Court?
Not at all, JP. I think 51 judgments I handed down in the criminal court, which were mostly trials.
Yes.
And I think it was just basically trying to expedite the matter and trying to speak to the council, let's try and get this done as soon as possible.
Yes. And looking at the list of judgments that you've submitted, which you've written since you started acting, they traverse a wide spectrum of areas of law. Any particular work area in the High Court work areas that gives you problems?
I think over the years I've been very fortunate in that you've allowed me to have quite an all-rounded experience in admin law, commercial, family, delict, criminal, constitutional. So I think I've been exposed to an all-rounded area.
Yes. And do you have any judgments that you've reserved for longer than 6 months?
My judgment's always handed down in an expeditious manner, with the exception of one, JP. This came to me by way of a special opposed motion, which was a 3-day special opposed motion. It was a short over the 6 months. The reason is just purely that it was a matter that entailed constitutional principles, and I needed to basically declare many sections of the 2018 City of Johannesburg municipality bylaws as unconstitutional.
Yeah.
And I spent time working on that judgment just purely because I knew it would go to the Supreme Court of Appeal and to the Constitutional Court, and it needed to be a very well-researched judgment.
Yes. One last question, CJ. Section 8 of the Superior Courts Act gives certain responsibilities to the JP of a division in which a regional court falls. You are a regional court magistrate.
Correct.
What is your attitude to that responsibility being given to the judge president in addition to the regional court? And the background of this question is the backlogs that one sees in terms of the finalization of criminal trials in the regional court. Every province, you can look at every PEEC report. Every province is not doing well in that regard from the regional court perspective. So I'm going back to the question I asked. You want to be a judge, you're a regional magistrate. What is, do you think there's a role that the judge president can play?
To expedite matters, I presume, in the criminal courts.
Yes.
Well,
in the regional court.
In the regional court. Well, first of all, in the regional court, we do not have this continuous role, which is, I believe, an impediment in finalizing matters expeditiously. In the High Court, matters are set down for 5 days, 10 days, 15 days, and counsel are ready to proceed with those matters almost in a consecutive procedure. But in the regional court, it's slightly different. in that council obviously take on quite a few matters, and they may only book 1 day or 2 days to hear these matters, and then they have to postpone it for when they're available again. So if the judge president in some way, and I don't quite have the answer how that could be done, but if this could be implemented in the regional court to have a form of a continuous role, I think this will help immensely, in the sense that the council who are dedicated to hear these matters will know you have this number of days, finish the matter. So I think the oversight that the judge president has over regional matters is important, because you can bring a wealth of knowledge from the High Court to the regional court.
Thank you very much, Chief Justice. No questions.
Thank you, JP. MEC?
Thanks so much, Chief Justice. I'm covered. Thank you so much.
Thank you very much, MEC. Honorable Nyambi?
Afternoon.
Good afternoon, Honorable Nyambi.
If you can share with us 3 good attributes of a judge and those that you think you possess that will come handy to assist you if you can be given the responsibility.
Well, I think integrity is most important. You're obviously there to uphold the law, and people are going to be watching you. You need to have a lot of patience. You need to have a lot of fortitude. Naturally, some form of wisdom, because these judgments sometimes are difficult. And you need to be able to also work quickly, in the sense of encouraging counsel to bring these matters to an end as soon as possible. Partiality is important. Judicial accountability is important. Sorry, giving you more than 3. Sorry about that.
So you possess all those that you have mentioned?
Over 30 years, I do possess those. I think I have.
Thank you. Thank you, CJ.
Thank you.
Much appreciated, Honorable Nyambi. Prof?
Thank you, CJ. Good afternoon, sir.
Good afternoon, Chris.
Could you tell us what your judicial philosophy is, please?
Well, I obviously apply the common law, statutory law, customary law, but always within the parameters and ambit of the Constitution. Obviously, there's a lot of schools of thought, whether you're liberal, moderate, or conservative. I think every matter needs to be considered on its merits. But I always look at the law. I don't just apply it as it is. It has to be applied within the ambit of the Constitution. That's my philosophy.
Thank you. And your view of, or your understanding of the rule of law?
Well, the rule of law is that no one is above the law. So, be it a president, be it a person of authority, the law is there to govern everyone, irrespective of your position. And obviously, the rule of law, in a way, forms part and parcel with the separation of powers, in the sense that the rule of law also, to a certain extent, needs to be guarded to control those borders.
Thank you very much. Thanks, CJ.
Thank you, Professor.
CJ, could I have a
Thank
follow-up?
you, Prof. Yes, please.
Thank you, CJ. Good morning, Judge.
Good morning.
Just on your on the issue that Prof asked relating to your judicial philosophy and how you answered that all of this in when you apply or interpret any of these laws, you do it within the ambit of the Constitution. Could you give us example of some of your judgments where this would have been done?
Well, first of all, I had a very important judgment, which was S. Mohamedi, which was of a traditional healer who killed his sister to complete the initiation period to become a traditional healer. And the charge was murder, and it was a gender-based violence matter. And when it came to sentence, the sentence imposed by a single judge was life imprisonment. It came to us in the form of compelling and substantial reasons to impose a lesser sentence than life. And notwithstanding the provisions of Section 13 of the Constitution, 31 of the Constitution, that allows the preservation of your religious and cultural rights, I penned that full court judgment and looked at the provisions of Section 10, which preserves the dignity of the person, and Section 11 of the Bill of Rights, which preserves the right to life. And I found that that superseded the preservation of religious and cultural beliefs. And in the other judgment that I penned, which was the the special opposed motion, well, there were a lot of issues that were, because I declared it unconstitutional, I had to consider issues pertaining to Section 16 of the Bill of Rights, the right to freedom of expression, and related to billboards and advertisement signs. I had to consider Section 25, which dealt the right to freedom of the property, and numerous issues in that special opposed motions were considered, which all form part of the Bill of Rights. And I think in my regional court work, the Bill of Rights always takes a very predominant role, specifically with child witnesses, because Section 28 is paramount, and it's important that when we have child witnesses testifying in sexual offences, I always ensure that their interests are upheld, and that if they are given the opportunity, that they are given a very safe environment to testify in with the closed-circuit television cameras. And obviously you balance that with the interests of the accused in Section 35, but I always consider the interests of the children foremost. And yeah, so there's quite a few.
Yes, but that's enough for now. Thank you,
Thank
Judge.
you.
Thank you, CJ.
Thank you, Commissioner.
Thank you. Honorable Muima.
Thank you, Chief Justice. Good morning, Justice.
Morning, Honorable Momo.
The question that I want to pose relates to putting us at ease in terms of reasons that you can advance around a matter where you said with Judge Msimeki, you refused leave to appeal, but the Supreme Court of Appeal set aside the sentence because the state misdirected itself to the pre-sentencing reports.
Sure.
How did that escape the?
I'll explain. This was a petition, so it was decided in chambers by myself and Judge Msimeki. We read the record, we discussed it. The regional court did not consider the correctional supervision reports. And the sentence was 8 years imprisonment. We felt it was an appropriate sentence. The judgment was taken on appeal to the Supreme Court of Appeal, and the Supreme Court of Appeal held that the regional court had misdirected itself for not having heard evidence of the 3 correctional supervision reports. So it sent it back to the High Court of Gauteng so that new evidence could be led. And that's how that arose.
Thank you, Chief Justice. Thank you, Judge.
Pleasure, Commissioner.
Thank you, Honorable Muima. Commissioner Dlepo.
Thank you, Chief Justice, and good afternoon,
Good
Judge.
afternoon, Commissioner Dlepo.
I just see that one of the parties, the organizations that supported your application is the African Diaspora Forum. And the reason I wanted to tap into you, and I understand that you were, according to them, you are one of the Board of Trustees in 2017. What I wanted to find out from you, have you had a lot of matters that deals with immigration or refugee laws or asylum seeking coming before you? Or were you just their advisor? I'm trying to.
I'll explain to you the situation. There has been 1 or 2 in the unopposed role that have appeared before me, but predominantly I feel quite strongly about xenophobia and Afrophobia. I just felt that I could impart some of my knowledge to assist in helping the the director of the African diaspora, there were many cases where people were assaulted. They had no avenue where to go, how to approach police stations, and with the fact that the Refugees Act and Asylum Act are so important, I try to impart my knowledge that I have in respect to those particular acts to assist them further to try and expedite and ameliorate the finalization of those cases. So it was purely in an advisory capacity that I assisted, and predominantly that's all I really did. There were also some issues where gender-based violence raised its ugly head, and I tried to assist with my knowledge of being in Soweto for 12 years, how to approach the relevant police station, what they needed to do, had they been taken to the Tutuzela clinic, had these victims been properly counseled. It was basically imparting knowledge that I had from an experiential point of view. So I hope that answers the question.
Just a follow up. I'm just interested in finding out whether the issues that we have with the African diaspora, is it because there's something lacking in our legislation, or is just how we apply the legislation towards the African diaspora?
Xenophobia is not per se a crime, but the aspects that arise out of this are of criminal intent. The police can only do as much as they can. I do believe that there's a bill which is the prevention and combating of hate speech and hate crimes. This was a bill which was created, and it addresses quite sufficiently and in detail the aspects pertaining to discrimination more and above than what is included in the Constitution. Namely, it deals with the refugee aspect, migrant status, albinism, HIV, discrimination. So I've been a strong proponent that if that bill could be put into operation, I think it would ameliorate and try and assist to curb this unfortunate hate crime that is committed.
Thank you, Chief Justice, and thank you.
Thank you, Commissioner Klipo.
Thank you, Honorable Zepu. President Maya.
Good afternoon, Mr. Dosio.
Good afternoon, President Maya.
In addition to being an artist and a great cook, we told, I know from our interactions in the Association of Women Judges, of which you are a long-standing member, that you are a committed gender activist with a particular interest in vulnerable youth. Can you tell us a little bit, very briefly, about the mentoring work you do with law students and the gender-based violence projects in which you are involved?
Sure. President Maya, this stems back to many years ago when I started in Soweto in 2000. I had obviously public prosecutors who were black females and legal aid black females who appeared before me, and I saw their potential, tried to encourage them to pursue becoming magistrates, becoming advocates, which ultimately they all have become exactly that. But in addition, the IAWJ, the South African chapter of which I was there in 2004 when it was formed under the then President Thabo Mbeki, we created, and it's a team that we work together, a forum where we have mentored 100 students in 2018, 150 students in 2019, and about 160 students in 2020. 2020 was a little bit more difficult in the sense with COVID, but we had a Saturday afternoon on the couch session, which we did virtually, where we invited a lot of prominent female members, judges from the Supreme Court of Appeal, attorneys, female advocates. We even had Tembeka Ngaitubi, who told us about the transformation issues, that females need to be briefed more on commercial matters, black females, and all this assisted to try and give some kind of input to demystifying the whole legal profession to these final year female LLB students. I must say, apart from the female students I was given to mentor, I also had a male black student, and I need to mention his name, Andile Ntuli, and he actually has learned a lot from this process, and he himself has now started to brief young black advocates in matters. So it's a matter of changing mindsets. And regarding the gender-based violence, we unfortunately could not proceed as we intended in 2020 with COVID, but we have a project in place whereby we do hope to go to the various schools and allow the children to participate and give their points of view regarding gender-based violence. The project hopefully will start soon. We have other options to do it virtually, and this is a proposal that we are working on at the moment.
Thank you very much, Mr. President. Thank you, CJ.
Thank you, President Maya.
Thank you, Honorable President. Colleagues, are we not taking a lunch break now? I would propose that we take a lunch break now, and I assume it will still be for the usual 40 minutes. You're excused, Mr. Dosio.
Thank you, Chief Justice.
Thank you, sir. Thank you very much. May we take a break now, colleagues, and come back at 1:30.
We can take one more, TJ. I think we still have the strength.
Yes.
Are you all agreed, colleagues?
Yes.
Yes,
One more?
CJ. Yes, please.
Let's move. Thank you. And again, I'll be interrupting you. Please take it in the good spirit that it comes with. Just to try and remind us.
Thank you.
Thank you. Yeah.
Thank you.
The candidate is ready.
Thank you, JP. Good afternoon, Advocate De Villiers SC.
Good afternoon, sir.
How are you, sir?
What must I say? I'm well enough, thank you, Chief Justice.
I'll try a quick intervention so that you are as relaxed as we are.
Yeah, thank you very much, Chief Justice.
Where were you born?
in this division in Hillbrow, but although my family lived in London at the time. But I grew up in
And
Uppington.
Uppington.
In Uppington.
Wow. And what degrees do you have?
I have a BCom LLB from the University of Stellenbosch, Chief Justice.
For how many years did you practice as junior counsel?
I think the figure is about 24, 25 years. It started in 1994, and I formally received my letters patent in 2018, but I was recommended in 2016.
So you've been senior counsel for about 4 or 5 years?
Yes,
or is it 3?
but formally it is about 3 years because there was unfortunately in my intake also a bit of a delay. But practicing after your recommendation, you actually start to practice on the basis that people know that you've been nominated for that great honor.
And for how many terms in all, or how many months in all have you acted as a judge?
The figure in my head is 55 weeks, but I look at my application and it says 51. So I'm going to stick to 51 because I think it's the safest figure. And if you work on a term being 9-10 weeks, then it is for more than 5 terms in total, Chief Justice.
And was it a struggle for you to produce judgments timeously?
No, it is not a struggle to produce my judgments timeously. I keep statistics about what I do. I've never gone over the 3-month limit, and only 4% of my judgments, of which there are now something in the 70s, would take me in that period between 2 and 3 months. But of course, those are the large special motions with many thousands of pages and where one must think hard and deep about the matter. The majority of my judgments, almost 60%, I deliver within about 2 weeks, and then practice and all of those things play a role, and the rest I deliver in between. It's not been a struggle at all to deliver judgments timeously.
Thank you. Colleagues, may I have the names of those who have questions for the SC?
Matonsela.
Schlemmer.
Dodovu.
Singh.
Lucas.
Tepe.
Barnard.
JP.
Thank you, Chief Justice. Advocate de Villiers, I think the Chief Justice just traversed a bit of what I wanted to check. My own spreadsheet suggests you've done 57 weeks in total acting, but that's neither here nor there. You seem to think it's 55 or 51. The last I checked, I do the work and I keep the statistics. But anyway.
Thank you, Judge President. I just don't want to oversell here and make it more than what it is. I would rather go below the actual figure. Thank you.
You don't have a criminal practice, do you?
No, I don't.
Yet you acted for 15 weeks in the criminal trials.
Indeed, Judge President.
Do you have any outstanding work from that role?
No, but in truth, that role happened during COVID. So my biggest struggle in that time was to get those matters on the roll because the practitioners could not access the prisoners to consult. But no, the short answer is no.
Yes, but you were prepared to go to that role despite the fact that you don't practice in that.
Indeed, I think criminal work is an essential part of an appointment in our division, and I need to, if I'm appointed, need to be able to carry my share of that load.
Yeah, and I think the spreadsheet was for the purpose for the commission to see what work areas you've covered. The full court appeals that you set in, did you write any of those judgments?
I think the only one which I haven't written is the one which Judge Sutherland recently wrote. In the rest, I wrote the judgments in all. I think in all matters where I sat in appeals, I remember perhaps one in 2016, I didn't write the judgment, but thereafter I wrote the judgments.
Yeah, and you had 3 weeks in the Asian court. How did you find that?
It's actually a wonderful court to sit in because of the pressure under which you are. You have very little time for preparation, and really difficult matters come to you at short notice.
Yeah. You've also submitted a spreadsheet, a spreadsheet regarding the judgments you've handed down, and they traverse almost all the conceivable work areas that one can find in the High Court. Am I correct?
Yeah, indeed so, Judge President. If you would allow me to, the discomfort that you obviously see that I am here under is that I have to sell myself here, and that sits uncomfortably with anyone. The powers of a judge are enormous, and it is constrained by humility and by integrity. But I think I need to point out in that list that I provided to you that about 4 of those judgments, all of which have been marked not reportable, have been reported in some form or another. Several have been included in the major textbooks on Close Corporations and Companies Acts. They have been referred to in other judgments, and I would submit that I not only have a width of experience, as the Judge President with respect points out, but also the depth that comes with this, the great honor it would be to be appointed.
You've acted, I think there's 4 full terms that you've acted, and you've availed yourself, you've come for this interview, you regard yourself as well ready and able to take up a permanent appointment.
Yes, I'm not a finished article. I will grow into the position, because I don't mind asking for advice, and the judges in your division, with great respect, are extremely helpful. So I don't want to submit myself and say I am as good as I will become, but I am ready.
Thank you, Chief Justice. No more questions.
Thank you, Judge President. MEC.
Thanks so much, Chief Justice. Advocate, good morning. Good afternoon.
Good morning, Commissioner Lesotho.
In your CV, it indicates that for your entire life, you have never involved in any community projects. Why do you hate communities?
No, with respect, I don't hate communities. My community involvement was in my work communities, and prior to that in the church communities, where I had access to where people needed access to my services, and there I gave freely of my time.
We are quite aware we are trying to promote social cohesion in our province here in Gauteng. We try to make everything available to everyone, including opportunities. I'm trying to check from your career and your involvement in any other thing that you've been involved before. I don't pick up anything that can convince me that you're promoting social cohesion, or you're involved in something that brings other communities that either were previously disadvantaged or they were denied access to opportunities. If you have, do you mind to take this forum in your confidence and elaborate those activities?
Gladly so. In the community, what I would like, Commissioner, I don't want to hog the microphone for too long on this aspect, but the community in which I grew up in is, of course, an Afrikaans community, and I want to start there. Before the Constitution, before any of these things that we talk about today, constitutionalism and so forth, was
involved in this country. In 1983, I was at university, a second-year student. There was a vote by the student parliament, a hypothetical question. It was put to the residences at the university. How many of you would allow, and I mean, it is terrible to talk about those times, how many of you would allow people of different races to sit in one race? I counted in my race, and that's the community in which I was, that out of the 120 of us, 3 would vote yes. I said, it can't be, it's an outrage. I started a campaign. In the end, I got 30 votes. That would show you where my commitment to social cohesion and social transformation is at a time when those things were not buzzwords. In those times, through the church, we reached out to students at the University of the Western Cape, and we went on retreats and so forth. We confronted our painful past. In that time, apartheid looked invincible. So if you start to look at my commitment to social cohesion, you will see it there. If I go to the end of my career, and I can tell you what I've done at the different stages of my career for transformation. But when I spoke yesterday to a junior, a black junior, about this interview, he said to me that since I've resigned from the bar, the thing that he misses the most is how my door always stood open for him and his colleagues. How they could walk into my room and I would drop everything what I would do and I would help them. The role that I played in the development of their practices. So what I've done, if you look at my actions, you will find that I have advanced social cohesion. But you don't find me in committees and you don't find me on other places. It's just not who I am. But if you look into my soul, you will find someone who seeks social cohesion. And I can continue with school sport, but what I've done there, I can give you many examples, schools being so close to you, how I've dealt with that. But I sought social cohesion and I absolutely believe in inclusivity, and I try to bring people together, and where necessary to try to change mindsets.
Do you know any African language?
No, I don't.
Why?
By the time that it occurred to me that I should start learning one, I was too old. I don't have an ability. I'm not good at languages. I struggled with the ones that I tried to learn, being one Latin, struggled at school with German. English is really, you hear my flat Northern Cape accent. I mean, it is who I am. I'm not a language
There
person.
seems to be a problem with sound.
Can you hear me, Chief Justice?
I'm fine, Chief Justice. Thanks. Thanks, Advocate. Thanks so much.
Thank you.
Thank you, MEC. Advocate Madonsela SC.
Thank you, Chief Justice. Good afternoon, Advocate de Villiers.
Good afternoon, Izzy.
You studied at the University of Stellenbosch at the same time that you were employed by the Department of Justice. Is that correct?
That's correct. You would have seen.
And can I just add that when you were at the University of Stellenbosch, you were also a head deacon in the Dutch Reformed Church.
I was.
And I have a sense of uneasiness about that because, please just help me understand. Wasn't the Dutch Reformed Church a supporter of the Apartheid Project at the time? And just assist me if that's not the position. And what was your role with your combined involvement with the Department of Justice in the 80s? It was about 1984, at the height of things that were happening in this country. What was your role at that time?
My role was that we were the young Turks, in the sense, I don't know, there are a number of people here with religious connections. And you will remember, if you follow those things, that the Bell-out Confession came out just a little bit earlier. The Bell-out Confession is to the effect that God is in a specific way the God for the poor and the oppressed. We pushed for its acceptance. It was through the Dutch Reformed Church that we would reach out to the church at the University of the Western Cape, and that I would go and sit in the mountains with people, and I would say to them, you know, I carry this collective guilt. There wasn't, of the official church, the church leadership, of course, that was far more conservative, but I wasn't part of that. I was part of a group of people to say, you did support apartheid. We're not cool with it. We must change all of that, and we must actually come through to the biblical norms. But it was still a place where I felt at home, because it was this rich in tradition, and it is. I know you're from a different denomination, but that I was at home there. Although the chief leadership of the church, of course, was different. Just bearing in mind, I mean, the leaders of that church included, for instance, Bayer Snowdeer. I mean, he was an icon to us.
Okay, thank you. In your CV, it appears that
follow up, CJ.
Sorry?
Follow up, CJ.
Okay, Advocate Madonsela, are you proceeding on the same line, or is it a different point altogether?
It is related to the one that I asked. Maybe, can I ask?
Then continue. Then continue.
It appears from your CV that you also participated as a member advising members of the military veterans organizations.
Indeed.
In their constitution.
Mm.
Which military wing was that? I would find it hard that you were part of the MK military veterans. Which military wing?
I may not have the history completely, but there was a new act for veterans. And these associations had to be formed. And the man who asked me to assist was a permanent force soldier in the new South African Defence Force. He became a general, but he was also a client in the demutualization of an insurance company for which I did work. I knew him well, and I knew that he was a man of integrity. And he asked for my assistance, and I gave it. And that is, there are associations for gunners and for old Navy people and so forth. And
from which military wing?
No, it's not a military wing. There are two groups. There is MK and APLA and those freedom fighting military armies. They also combined. And so they called this wing on which he was the so-called statutory forces. And they called those ones. These things are misnomers. I know, I'm sorry, but I'm just giving you the names, the non-statutory forces. So they needed a constitution for the statutory forces, and I assisted with that.
Thank you, Chief Justice. I have no further questions.
Thank you, sir. Was it Commissioner Sigogo who wanted to follow up?
Yes, Chief Justice.
Please go ahead, sir.
Thank you. You mentioned that you looked forward to people like Vesnodie at the church, but then isn't it so that Vesnodie was the son of the pastor in that church, and for the position he took in respect of black people, as well as the manner in which the church associated with apartheid, he was disowned by that church.
Yes.
He left that church.
Yes.
And he joined the black version of that church. Is that
Yes.
not so?
Yes, and eventually they apologized for that. Eventually they came round and did the right thing. So he was terribly treated by the church, absolutely.
If you looked up to him, didn't you see it necessary to as well join him in protest on how they treated him for the stance he took in respect of black people?
So those events, Commissioner, played out before, when I was young. So by the time that I was active in the church in the early 1980s, that had already taken place. But we were then still in separate churches. That is correct. But from where we were as a student congregation, we were pushing for the unification of the churches.
Thank you, CJ. Thank you, Judge. Thank you, Advocate.
Thank you, Commissioner. Prof.
Thank you, CJ. Good afternoon.
Good afternoon, Prof.
I would just like to come back to your dealings on the bench and the fact that the GCB tells us that you're always well prepared, that you can converse with counsel, and that you always also said that your judgments are delivered promptly. I've also seen in your questionnaire that you have, and that is what my question is also all about, that you refer to books and articles that refer to your judgments. Did you only do that for purposes of this interview?
Professor, you just have to, I'm sorry, I don't fully understand your question. The reason I went and looked, sorry, let me first hear your question.
Okay, so the question is, do you normally read in addition to judgments and court papers? And did you only, for purposes of this interview, look at what the impact is of the work that you are doing on the bench?
In one sense, I would be sorry to disappoint you. There is not next to my bed a stack of law journals and books. But I love books, so I buy them all the time. But it's more that I use them. So for this list, I specifically went to look to see if my work had any impact. So that is why I know it is there. It was I looked for it, but I try and think about my judgment. So I try and find the principle, and to apply the principle to what I must decide in the matter. And for that, I make extensive use of textbooks all the time. And in as far as journals are accessible to us at the High Court, I make use of them. I make use of the researchers. I will say to them on this topic, this is new to me. Do you know of any article in point? And that is why you will find in my judgments references to articles.
Thank you, sir. You've answered my question. Thank you, CJ.
Thank you.
Thank you, Prof. Honorable Dodovu.
Thank you, Chief Justice. Good day.
Good morning, Commissioner.
Yes. The shortest section in the Constitution is Section 11, life.
Yes.
Everyone has got the right to life.
Yes.
Do you subscribe to that? And what is your view on euthanasia?
Now, I would love to deal with this aspect because it's actually an aspect that I think about a lot. I must do so with circumspection because at the moment there is a court case on the go about the right for a terminally ill person to terminate his or her life. Depending on what happens there, that matter may become before me again. In principle, I agree with the system that exists in Holland, that in appropriate circumstances, a very ill patient can take the position to end his or her life. I have read the most informative book about a doctor in one of those facilities who described the various journeys that people have to get to be on that. And as you grow older, you will all get to know people who are terminally ill and who are suffering from strokes and so forth, and who long for this ability. So if it comes before me, though, I will have to apply the evidence that is laid in that court, and I'll have to apply the law. And if that takes me to a decision, to a position different to the one that I have just expressed here, then I will apply it, no doubt about that. I have, because a higher value as a judge is that you must apply the law to the facts.
Will that apply to assisted suicide?
Yes. Again, if I think it's a remote possibility, so I'll answer it. Yes, I do think it is the same, because if you get to that position, and let's paint the picture. A university professor who has lived throughout his or her life, defined by a brain and so forth, unable really to speak, to communicate in pain, and wants to take that decision when he or she is 92 years old, I don't think it is for me to say you can't.
All right, thank you, CJ.
Thank you, sir. Honorable Singh.
Thank you very much, Chief Justice, and good afternoon, Advocate de Villiers. I've been looking at your CV, and in particular the section which deals with particulars of employment. And what I see there, the only time you were really employed was the Department of Justice as an admin assistant and then acting ad hoc state prosecutor from 1979 to 1986. Most of your career, other than the 57 weeks, I think, which the JP said of you acting as a judge, has been, if I may use the words, on the other side of the law, not on the adjudication side, as a judge or a magistrate or a judicial officer. Can you just briefly speak about your strengths in that regard, if you are appointed as a judge? Thank you.
Mr. Singh, if you will forgive me for telling a story, but perhaps it is who I am. In December 2016, we went on holiday after I acted for the first time for 5 weeks. My family said, "Who is this person?" Because normally in December...
Sorry, let me interrupt you. I take it that you'll be brief in telling that story.
Yeah, I will.
Because time really not on us.
I will, but I think it will illustrate, Chief Justice.
Thank you, sir.
My family said, "Who is this person?" Because in December, normally you fall down on the bed and you just sleep to recover from the year. And here you walk in and you're energized. I think I'm ideally suited to be a judge. I do like to decide matters. I don't shy away from deciding a matter. I weigh up different views. Even as a counsel, maybe it's a defect in my makeup. I've always been able to see the other side's version. And clients sometimes just want somebody who is a bulldog and will fight at any cost. And my approach very much always has been to look at both sides of the picture. I think that is why I have the report about how I conduct myself in court. Although, of course, I haven't spent my life adjudicating. I've spent my life at the coalface.
Thank you very much, Advocate. Thank you, Chief Justice.
Thank you, Commissioner.
Thank you, Honorable Singh. Honorable Lucas.
Thank you very much, Chief Justice. Goeiemiddag, meneer de Villiers.
Commissaris.
Ek het net een vraag wat ek graag vir jou wil vra, en dit is nou, ek sien dat jy 'n lid is of 'n trustee is van die de Villiers Family Trust, maar is ek uit op 'n algemene vlak, wat beskou jy as 'n konflik van belange in so 'n setup? Want dit kom van tyd tot tyd op, maar wat sou jy sê, wat is jou persoonlike mening daaroor?
Commissioner Lucas.
Justice, before the candidate answers the question, will you be provided with a translation of the question, because my Afrikaans is exceedingly poor. I didn't follow what was being said.
I understood that Afrikaans and English is the language of the,
No,
bench.
Commissioner Lucas, that's where I was going. If I wanted to say to you that I need these people to vote for me, so I need to translate.
Yes.
Doesn't Commissioner Lucas want to know what your understanding of conflict of interest is in view of the trust in which you serve?
Yes, that Chief Justice is the short answer. So if you don't mind, Afrikaans is my language, but if you don't mind,
Sure.
I want to answer you in English.
No problem.
I'm not involved in anything that I think would create a problem. The one trust is the one taking care of my mother, and the other one is our own family trust that we are in the process of dissolving. It just takes a little bit of time to do that. In as far as the share investments are concerned, we don't hold direct shares in any of the two trusts. They are in financial instruments managed by financial advisors. I can't even today tell you in which shares the shares are invested. I can't. A conflict of interest it goes deeper than that. It's also an appearance of conflict, and that is, we must avoid it at all times. So I can understand that somebody would feel very uncomfortable if I sit in a court and I'm a shareholder of Standard Bank and Standard Bank seeks relief before me, but I am not in that position at all.
I will ask you the second question because I'm allowed. There is a section where you say, I am doing it small, not headline grabbing. Can I understand better what you are saying there?
I just want to sit, if I may, in a corner of the High Court in Johannesburg and be the best possible judge that I can be.
That is the kort die lang van die storie.
That's the short and the long. I don't want to be in the newspapers. I don't want to be on Twitter, whatever. I just want to sit there quietly and carry my share, and hopefully more than my share of the burden of that court.
Thank you, Advocate. Thank you very much, Chief Justice.
Thank you, Commissioner.
Thank you, Honorable Lucas. Commissioner Tsepe.
Thank you, Chief Justice. Good afternoon, Judge.
Commissioner, you're partly correct.
Freudian sleep.
But Commissioner, you're partly correct because I'm acting.
Good afternoon, Acting Judge.
I'm pulling your leg.
I know. Thank you, CJ. I just wanted to talk to you about your practice. In your CV and in the questionnaire, you say that you have not done a lot of constitutional law in your practice. I wanted to understand that despite that, how that impacts on your ability to meet the obligation in terms of the Constitution to ensure that when you're doing your work, you take into account the values of the Constitution. And if you do, if you could give me some examples of the matters where you would have done so. Thank you.
It's a great question and a necessary question, but I think I also said it's almost a trick question because in every matter, the Constitution plays a role. What I will take out of this process, no matter what the end is what the GCB wrote about my judgments, that through them flow the norms and the values of the Constitution. And I think that panel who wrote that report got me. And I think it's a fair summary of what my work entails. Because if you consider that they didn't look at the judgments that I attached to my application, they looked at one of them and I think 5 or 6 other ones. So because I believe in judicial transparency, my work is available, my body of work is available that people can read it and comment on it. And that is where they found that. So if you ask, for example, I have made a few notes here that I can go back to. But the one case that they rely upon is my judgment in the Bosasa matters. And I applied the right to equality, for instance, in the interpretation of the Insolvency Act one section where there is a difference and where I think I had to develop the law to apply for protection for people also buying movable assets at such a sale. That judgment very strongly upholds the right to dignity as part of what I have had to say about how the case was conducted. Now, I don't know if the Supreme Court of Appeal will agree with me, but I mean, I think that is one good example that they refer to. But in many of these other cases, if I deal with a bail appeal, if I deal with the refugee matter, or if I deal with anything, I mean, the rule of law and the rights there are there all the time. There's another aspect about the Constitution that's very important here, and that is, will I overstep the mark? Will I stay in my tracks? And that is how I deal with stare cases, for instance.
That's fine, Judge. Thank you.
Thank you.
Thank you, CJ.
And forgive me for my biggest downfall is my wrong sense of humor. I apologize for the joke that I made when you started.
Not to worry at all.
Thank you, Commissioner Tsepe. Commissioner Barnard.
Thank you, Chief Justice. Good afternoon, Advocate, Acting Judge.
Yeah.
No, I'd like to...
Advocate, please.
Advocate, I'd like to take you to a matter that you might or might not remember, Boetes versus Road Accident Fund, but to just quickly jot your memory, it's the 420 Rand claim that was litigated on, and you felt that shouldn't have been done. And my question on that is, you indicate quite clearly in the judgment, and then there was an addendum judgment, that you don't want to saddle the plaintiff with these costs. And yet when you go on to make the cost order, and you do make it, you make the joint and several cost order, which includes the plaintiff. Your comment on that and how you think justice was done in that instance.
I think it is in my bundle. Can I just have a look at what my final cost order was? Because
page 194
because what
of the bundle. I can assist you to find it quickly. Sorry?
When I did sorry, if I might just stop, if you just give me 1 second. It is on page on mine. I've got just a slightly different numbered system here. That is the matter. There was an addendum because I thought that the attorney should get the second bite. Let me just.
That's correct.
Yeah, it is not a bad. Sorry, it's a good point. It's a good point. Why did I say jointly and severally with the plaintiff, and not completely leave him out of the equation? That's a very good point. I think on reflection, I should have left him those jointly and those words with the plaintiff should not have been in my judgment.
Thank you, Advocate. Thank you, Chief Justice.
But I think what my intent in my judgment is that the attorney should pay these costs, and I did so. It's not a cost order that I easily made. Thank you, Commissioner.
Thank you very much, Advocate De Villiers. See your excuse.
Thank you, Chief Justice.
Well, colleagues, are we ready to proceed with the next candidate, or do we take a break now?
Break.
Lunch.
Okay, 40 minutes.
All right.
Thank you for
Thank you.
Justice. Yeah,
Let's come back at 2:15. Let's come back at 2:15. Thank you, Judge President. Good afternoon, Judge.
Good afternoon, Chief Justice and the
Are
commissioners.
you well?
I'm well, Chief Justice. Thank you.
Thank you very well. Tell us very briefly why you want the transfer.
Thank you, Chief Justice. Maybe I should start with explaining why I left Gauteng, why I transferred to Mpumalanga. I transferred to Mpumalanga due to medical conditions. Now that I am healed, and the fact that my transfer was also premised on the fact that I will be, or we will be selling our family home, and that hasn't materialized. So it is, we found it probable that I must come back to Gauteng because I am healed. I healed gradually. Thank you.
Thank you. JP, I think I must hand over to you, but before I do, let me just have the list of colleagues who who would want to put questions to the judge. Colleagues?
Nyambi.
Schlemmer?
Mpofu?
Sorry, Prof, who came after you before Mpofu SC? Who came after Prof?
It was Matolu Tlepo.
No, she came before you, Prof.
Then I think it was just me, and after me it was Mpofu.
Okay, thank you. And who was after Chain SC?
Singh.
Thank you. JP.
Sigogo CJ.
Oh, okay, Commissioner Sigogo. All right, JP.
Thank you very much, CJ. Jolingo.
Tatutivan, JP.
You left one also important reason why you want to come back to Gauteng. Can you mention it, please?
Thank you, JP. I believe I will add value to the development of jurisprudence in the tax court because Gauteng, the tax court of Gauteng division is a very busy tax court in the country.
Thank you very much. I wonder why you left out, but at least now it's out there. Now,
thank you, JP.
I didn't prepare a spreadsheet for you because you are a judge. Instead, you prepared a list of judgments. And those are just tax court judgments, am I correct?
Yes, JP.
Now, in how many of those were you reversed?
3 of them, JP.
Thank you. Now, the GCB makes a lot about one matter where you were reversed by the Supreme Court of Appeal.
Yes, JP.
Do you have any comments about that?
Yes, JP. It's Sasol versus Commissioner for South African Revenue Service. The GCB's comments are to the effect that the SCA.
They say you didn't pay attention to detail, and
yes, and that they say
it's your area of expertise. I just want you to deal with that.
Yes, JP.
Yeah.
Maybe in that one we are referring to Amawele on that one.
Okay.
The Amawele, there are 2 judgments where they are complaining about my area of expertise.
Yes.
I did Amawele in 2014 whilst I was acting, but that's not the reason for the error there. It was a mistake because I was supposed to have ordered the interest to run from the date of assessment, not from the date of the order. Be that as it may, another day that judgment was reversed because it went to the full court, to our division, and our division confirmed me, and the issue of interest was a cross appeal. But in the end, the matter went to the SCA, and the SCA overturned the full court.
I see. And in any way, it's an occupational hazard for any judge to be reversed, isn't it?
Yes,
Now
JP.
and then by an appeal court.
Yes, JP.
Right. And you just to end off, you will add value to the jurisprudence of the tax role in Gauteng, but you've also done other things since before you transferred to Mpumalanga in the tax court.
Yes, JP.
Do you want to just spend a minute, just explain what you did?
JP, in the tax court, to summarize it, I brought the transformation of the tax court, or of the functioning of the tax court. One of the problems which are found in the tax court was the issue of selection of tax court members equivalent to assessors in other courts. A judge will go to court and will meet the assessors on that day at the door. You don't even know the assessor, and a SARS who happens to be a litigant or a party to the matter has already chosen the assessors or the tax court members. I was not raising, in fact, I used to raise this issue when I was a member of the LSNP and sitting in the tax committee. We raised it many times, but it was not attended to.
But in a nutshell, you resolved that.
In a nutshell, I resolved it, and it even went through my judgment, the Renette judgment, which was confirmed by SCA.
Yes.
Though the SCA didn't say anything about that, because the SCA looked at the main matter, that is the accrual issue, where they agreed with me. But I wrote at a length in that judgment about Section 120, the lacuna in Section 120 of the Tax Administration Act, which deals with the appointment of tax court members. Because Section 120 does not prescribe what the duty of the tax court members is or how they get selected, except that they get appointed by the minister because they are accountants or commercial members, and it ends there. Then on daily basis, practically, when a judge gets a matter, it's silent. That's where I got into. At the end of the day, we ended up with a policy which is applied nationally to the effect that the judge must have a say on the tax court members, and it must be based on the issues which are in the matter. As a result, now we get 3 names for the commercial member, 3 names for the accountant member, and the judge has to match that with the issues before him or her and be able to say, this tax court member can assist me in this issue. For example, without dwelling too much on this.
Let me stop you there. I
Thank
think
you, JP.
you've made your point, and thank you for assisting us in that regard. But I don't want to leave this out.
Thank you, JP.
You also found that people who did not fit the description in the Act to be tax court members
Yes,
were
JP.
being imposed on judges.
Yes, JP.
And that your intervention has resulted in all those matters, those non-qualifying members being pruned from the system.
Yes, JP.
Yeah, I mean, one famous example is Judge Satchwell sitting with a former school teacher.
Yes, JP.
Thank you very much, Chief Justice. I've got no further questions.
CJ, just a follow-up.
Thank you, Judge President. Honorable Malema.
I think the JP was a bit impatient because of time, but she's got a very important information to share. And I think that we must be a bit patient with her, because I'm interested in how she transformed SARS court. And you were dealing with how the assessors were being appointed and how you intervened. I think I need that part, so you can expand on it, how you transform the whole court.
Thank you, Commissioner. Maybe I must give a background to how this came into being, because it's the issues was raising whilst I was still outside. Then I got an opportunity as a judge. The opportunity came in this sense. I was sitting in this matter, the Runette matter versus a commissioner for SARS. And then one of the tax court members, a commercial member, you have two members, an accountant member, supposed to be an accountant, and a commercial member. The problem is too much on the commercial members. That's why you get a teacher, you get a correctional service officer, you get anyone SARS likes or liked to come and assist you. And some of them will even tell you, oh, I don't even know tax. And you're like, why are you here? No, SARS decided to appoint me. And then those people are imposed on you. Fortunately, in this matter, I had an attorney coming from one of the big law firms who was supposed to be a commercial member to assist me. Firstly, the law is very clear that the only person in the tax court who's supposed to decide issues of law is a judge and no one else. So you don't need a lawyer to sit with you or to assist you. But I was patient because there was no clear policy. I sat with this gentleman and the tax court member. When we were supposed now to write a judgment or to come to the conclusion, he says, Judge, send me a judgment to write. I said, no, I write my own judgments. You are not supposed to write judgments. You'll hear from me. I'm going to write a judgment. This is how I'm going to do it. This is how I write my court. I'm going to write a judgment, send it to you, you comment. He came back. Fortunately, everything was in writing. He kept on pestering. When are you sending me the judgment? When I explained, I'm still writing my judgment. In fact, when we were discussing, the matter took about a week sitting, so we'll have tea time, we sit, we talk, we speak. And then he even said, I harbor the desire that SARS may win this case. I kept quiet. Then he started pestering me for the judgment. He wrote, I don't remember in details, but it's in my judgment. I quoted everything in my judgment, in that judgment. Then I told him, oh, you said, Judge, when am I writing the judgment? I quoted the law. You are not writing any judgment. Section 117, Section 118 is clear, Section 120 is clear. I am the only one who's writing a judgment here. He came back with a long email as to how, in his 20 years or 30 years experience, he used to write judgments for judges and whatever in this court. I told him that I'm not those judges. I write my own judgments. That is when I saw an opportunity. And the judgment went against SARS, not in favor of SARS. That is where he harbored his wishes. It didn't go according to his wishes. And the matter, I granted leave to appeal to the SCA deliberately, not to the full court. Not because full court has anything, but I just wanted to make sure that the matter goes to the SCA. The SCA confirmed me, though they never commented or made any comments on Section 120. I set the law then, and I showed the JP, and even SARS read it, and JP suggested, John Gomo, come with a strategy. What do we do here? I sat with SARS, said, let's craft a policy. This is how, let's discuss how we're going to select tax court members to the satisfaction of all. Because even other colleagues were asking me, Nelisa, why do we meet these people at the door? Some are teachers, some, not that there's anything wrong with the teachers. Let me explain here. If you are an accounting teacher, well and good, I can sit with you only if your accounting can help me in that particular matter. I even say, I can sit with someone from Edgar's, from SPA, who has done stock taking, because there are a lot of issues involving stock taking, where there's a lot of tax evasion. So a person who has done stock taking or stock counting, that person can help me in terms of Section R20 of the trading stock as to the closing and opening values. That is a very important section because a lot of tax gets siphoned through that. I can sit with someone working at SPA. So it has got nothing to do with undermining anyone. It's about whether this person can assist me in this particular matter. So that is how, with the JP, we came with a approach that 6 CVs, at least 3 CVs, 3 CVs per member. At least from those 3 CVs, I can say this person has done pay as you earn. Because other people are very detailed in their CVs that have done pay as you earn, have done tax computation. Because at times you find someone who says, I've done tax, and then now you want to do capital gains tax calculation and everything, and then the person says, no, I've never done such a thing. Tax is very wide. So those CVs help you gauge. And just to add, when it comes to commercial members, pardon me, I don't know. The legislators, I'm happy that there are some legislators in the room. I don't know why tax court members, why commercial members are a matter of must in the constitution of the tax court. I'm going to say it openly here. It is a waste of taxpayers' money. Because at times you don't need a commercial member at all. The person sits next to you, says, I don't know, I've got nothing to say, I've got nothing to ask, because the matter is so straightforward. The rationale of tax court member for commercial members, accountant members are always needed or required. But the rationale for having a commercial member, it's, for example, as I said, trading stock. Someone who has counted 10 bags of sugars and milli can help me from SPA. That is his specialization. He understands it better. You have a straightforward matter of capital versus revenue. Why do we need a commercial member? The reason one might need a commercial member is when, for example, you have an engineering issue, and the tax issues are around engineering. For example, I had another matter where there was a claim for trading for obsolete stock, that is the deduction or depreciation for obsolete stock. And then I needed a technical person to tell me that if this nail is like this, it means it's obsolete. It cannot work in this. Then you need those people. I don't see why it must be a matter of must that you have those people. Because at the end of the day, they earn fees, they get there, they sit, they prepare for a week. Tax court files in Gauteng, you'll never have get a thin file. It's few times. Many times, this is the average. This spec is an average. It's about 200, 300 pages text file. And then that person is going to claim preparation for 2 weeks, and then it's going to sit with you for another 10 days, and then it's going to claim writing judgment or preparing for judgment, and the person is sitting there doing nothing. You are working hard with the accountant.
Thank you, CJ.
Thank you, Honorable Malema. Honorable MEC.
Thanks so much, Chief Justice. I'm covered. Thank you so much.
Thank you, sir. Honorable Nyambi.
Thanks, CJ. Afternoon, Judge Mali.
Afternoon, Commissioner.
The first question has been covered by the JP. It's only one question. Mpumalanga High Court, in a manner of speaking, is still in its infancy. So how will you describe your experience in working in an environment that is still in a developmental stage, as we are preparing to leave it and come back?
Mpumalanga is in infancy, but it is a strong infant. Because most of or some of the judges, few as they are, they come from Gauteng Division, where we get cooked. Thank you.
Oh, thanks, Judge Mali. Thank you, CJ.
Thank you, Honorable Nyambi. Commissioner Lepu.
Thank you, CJ, and good afternoon, Judge.
Good afternoon, Commissioner.
I think the first question I wanted to ask about how do they appoint commercial members, at least now I know you don't favor having commercial members. I wanted to know where do they find them? Is there a panel of commercial members in the test court? And the second question is actually inquiry from you. I know you do a lot of work for women lawyers with their seminars. So when are we starting now that we'll be there?
I didn't get that, Commissioner.
I'm saying that when we'll be starting to do those seminars of young women attorneys who want to be tax experts.
I'm always available. I just done one with Saula Mpumalanga. I'm always available when I'm invited to do work, to hold seminars for lawyers.
The first question about are commercial members really needed? That's what I wanted to know.
Oh, I thought we covered. Thank you, Commissioner. The commercial members, what happens is that the Minister of Finance sends invites or advertise for tax court members, accountant and commercial members. It appears that everyone who applies gets appointed. That's what I discerned. And then now, SARS, then all those names, they go to SARS, and then that's where SARS, they pull whoever they want to pull and throw to the judge. They used to before we changed policy in 2018. I also trained, in fact, after we did that, I also did trainings for tax court members, all of them, what they expect, what is expected from them in court, judging from that case that we are not expected to comment on issues of law. We are here to help me, to tell me if this water is at this level, because I'm not a scientist, whether that will form deduction. If you look at this water, is it 100% or 50% in terms of science, not in terms of law? So I tried to explain to them what is expected of them in court.
Thank you for the clarity. Jay?
Thank you. Thank you, Commissioner. Prof?
Thank you, sir. I'm covered.
Advocate Ngofesi?
Thank you, Suchi. Good afternoon, Judge.
Good afternoon, Commissioner.
Thanks. Well, I have to declare that I know you very well, long before you even became a judge, and your family. But the issue actually relates to that, to the fact that I've known you for a long time, long before you, when you were still a tax consultant. So I want to, because, you know, there's a whole lot of comments here about commercial expertise and all sorts of things that we have to face here. And when we find somebody like you who's a polished tax lawyer, maybe we give you an opportunity, as the CJ always says, to brag a little bit. So I'd like you just to briefly explain the depth of your expertise in that field, but also related, so that I don't have to ask a second question, related to that, to comment on why a person like you, who is of such a high caliber in tax, is not given an opportunity to be part of the Davis Commission, because there's something called the Davis Tax Commission, which has been chaired by Judge Davis, who also has the necessary expertise. But we don't want to run into situations where such important institutions are almost owned by a particular individual. To what extent could somebody like you, and those, you might know other people like that, start to be prepared to play those roles to take it forward, if and when Judge Davis is no longer around?
Thank you, Commissioner Mpofu. Let me start with the second one, the last one. My understanding is that the Minister of Finance, in consultation with the Minister of Justice, if I'm correct in that part, is the one who appoints the commissioner or the chairperson for the tax commission. Because when that commission started, it started as a tax review committee. And then in 2013 or 14, it changed to be a Davis Tax Committee. So I do not know whether, I don't know the criteria, put it this way. I don't know the criteria, how one gets there, But the second part of your question is people like us. I'm saying us because there are a lot of black tax lawyers who were together at SARS. Some of them are in practice, some of them are in the bar, but we don't get to be seen. we have to swim, we have to fight to be seen as a black tax lawyer. You have to put a huge fight, not lack of better words. You have to work hard, you have to push boundaries, put it this way. You have to push boundaries for you to be recognized, even from the clients, even the clients themselves. They believe that a white person is the only person who can do tax work. I believe that that core can be used in that commission, but as I said, it's within the prerogative of the Minister of Finance. Then the second question, you said something about my depth of expertise or brag about myself. I started as a prosecutor in 1988. I started as a prosecutor. But I have a disclosure to make. I never wanted to be a lawyer. I wanted to be an accountant. I grew up from Standard 5, doing commercial studies, business studies, accounting, typing, everything. But in grade 12, which was Standard 10 then, your accountant, your symbol for maths had to match that of accounting. I failed maths dismally. My accounting, it was just poles apart. So they admitted me in law as a second choice. And I was not, I got to university at the age of 17. So because there was also an option for applying a matriculation exemption, but I couldn't wait to be 23. It's good I didn't wait because at the age of 23, I was already a senior state prosecutor. So I started at 17. At the age of 19, I got appointed as a prosecutor, but I still had this passion and desire of doing commercial work. I decided I'm not going to go start all over from BCom degree. What I'm going to do is to look for something closer to commerce. That's how I ended up in tax. I resigned as a prosecutor in 1995, registered at University of Cape Town, and obtained my master's in tax in 1996. Thereafter, I couldn't get articles in a tax law firm because there were no tax law firms in Eastern Cape where I came from. Even in Cape Town, it was difficult for a black person. So I just served articles the normal way. In 1999, I was knocking at the doors of audit firms, law firms, wherever I could find tax. And Deloitte in Durban said, come, but you're going to start all over as a trainee tax consultant. I welcome that because I never practiced tax, so it was like repeating articles after serving articles. So I joined Deloitte in February 1999. I got recruited by SARS whilst I was at Deloitte, and then ended up joining SARS in August 1999. At SARS, the first business unit I worked for was law interpretation. I worked there for 2 years, where we were dealing with application for rulings in simple terms. I hope we all understand. Do I have to explain? Let me pass.
No.
Let me pass. Yes. Then in 2001, because SARS was dealing with issues of tax evasion, he had a new strategy, and then I was transferred to special investigations because of my background as a prosecutor. Then I headed special investigations, Gauteng North, covering Pretoria, Limpopo, and Mpumalanga. I was heading special investigations, Gauteng North, for 3 years. And when again it was decided that I must be seconded at NPA because NPA wanted to start a tax unit And it was said that there was no one was available to start a tax unit. And again, my prosecution background helped. And then I moved to NPA to start a tax prosecution unit. I didn't stay long. I think about 7 months, they called me back to excise unit to head, because at that stage, there was a separation of customs business unit from excise unit in order to monitor the revenue of excise and transform excise, because excise unit was not very transformed, not necessarily in terms of incumbents who were doing the job, but even the policies and everything. And then I got back, I headed excise, and as part of transformation, I had to spend some time at Her Majesty Revenue and Customs Excise in UK for a month as part of a study, benchmark study. And I came back, I implemented the policies, and there's a policy which we worked on, which is running successfully, called Duty at Source, or DAS. It assisted a lot in terms of collecting excise duties, and it still assists. Then it was at that stage, after I ensured that DAS is working, everything is fine.
Can I
that
summarize?
Yes, that I decided I'm ready now to open my law firm, because I also realized that there were no opportunities for black kids or black people. And then opening my law firm gave me the opportunity to transfer the skill.
Thank you very much, Judge. Thank you, CJ.
Thank you, sir. Advocate Kennedy.
Chief Justice, I'm covered.
Thank you. Honorable Singh.
Thank you, Chief Justice. It's good to hear such a renowned expert on tax matters. Just one question, Judge. I know you mentioned this in the beginning. Just like to know how you're doing with your health nowadays, and is it impacting at all on your ability to get to work and make these wonderful or not wonderful judgments, depending on which side you are on tax matters?
Thank you, Commissioner. I am healed, and I must say, the fact that Gauteng now is working on virtually really assists, because one of the problems I had then was the driving between home, Joburg and Pretoria. And as I divulge here, I had 2 surgeries on my left arm, which is my dominant hand.
Thank you very much. I wish you well.
Thank you.
Thank you.
Sigogo. Thank you so much. Thank you, Honorable Singh. Commissioner Sigogo.
Thank you, CJ. Good afternoon, Judge. How are you?
Good afternoon, Commissioner.
I wanted to talk to you about your expertise in tax, and that has been covered very well, and how you'll put your expertise at work in Johannesburg as opposed to Malanga. But I'm covered. You need not answer that. Thank you.
Thank you.
Thank you very much, Judge Mali. You're excused.
Thank you, Commissioners.
CJ, did you hear that covered you were talking about?
Explaining that it's covered.
CJ, that
Good afternoon, Advocate Malindi SC.
Good morning. Good afternoon, CJ.
Yes. If you prefer the mask on, it's fine, but feel free to take it off if you're so minded.
Thank you, CJ.
Are you well, sir?
I'm very well. Thanks yourself, CJ.
I'm very well, thank you. We've interviewed you before, and I won't take time with you. I think I'll hand over to the JP. Thank you very much. But before I do, may I have the names of colleagues who want to put questions to the advocate, please? Colleagues?
Muimang.
All right.
Singh.
Schlemmer.
Mpofu.
Thank you. JP?
Thank you very much, Chief Justice. Good afternoon, Nzele.
Good afternoon, Chief Judge President.
You were interviewed previously, as the Chief Justice says. You've also acted in a number of work areas in the division. All I want to ask you is, you are a silk, you've appeared in many of these high-profile cases that are in the... Have you appeared in the Constitutional Court?
I have not, Judge President.
Yes. What I want you to explain, if you don't mind, is I asked you to compile a list of judgments you've handed down since you started acting, and also reflect the dates when the matter was heard and reserved and when the judgment was handed down. The last part of your report shows judgments only. It does not have dates, but you say those were heard in the 4th term and delivered in the 4th term. For record purposes, you only acted for 2 weeks in that term. Am I correct?
Judge President, that extra list is judgments of the 4th term, 2020.
Yes.
That were delivered in April this year.
Were delivered, you mean this month, in April?
This month, actually.
They were heard when in the 4th term?
They were heard in between 30 November and the 2nd of December.
Right. And for completeness sake, in those 2 weeks you added in the opposed motion court, how many did you have?
I had in excess of 10.
And thereafter you then went into the agent court?
And thereafter I went to the agent court.
Right. That's quite a tough allocation, even for permanent judge standards, from opposed to agent, isn't it?
That is so, Chief Judge President.
But all of them have now been handed down?
They all have been handed down.
Thank you very much. And you regard yourself as ready than ever to be appointed permanently?
I'm ready to answer to the call that I make myself available.
Thank you very much, Chief Justice. No more questions.
Thank you, Judge President. MEC?
Thanks so much, Chief Justice. Good afternoon, Advocate.
Good afternoon, MEC Lesufi.
Are you well, Advocate?
I'm very well, thank you.
Thank you so much. Ever since I knew you, you have been on the side of the weak, the vulnerable, and protecting the rights of individuals across the system. And you are well known for that. The time that you have spent acting, do you think your presence have brought uncertainty to other people, or you have been welcomed?
my presence as an acting judge
Yes.
at MEC.
Amongst other judges. You are not seen as a deployee of some sort and therefore not being treated like any other judge.
My presence has been most welcomed by the leaders of the courts in which I've acted, and the permanent judge who's that I've had occasion to act when they are in court. And I believe that my presence as an acting judge has been welcomed by those judges as well.
Well, we are well known within the circles of one political party in this country. And I know the last time you were interviewed, you indicated that you took a cool-off period so that you can concentrate on your legal matters. Do you think if we recommend you, you'll be in a position to handle matters fairly, regardless of where they come from?
MEC, it is 4.5 years since 2016. I'm therefore 4.5 years older. And it's a two-pronged answer. To those to whom it mattered that I applied after about a year of not renewing my membership to the ANC, they've had 4 years to consider and observe me if they have. And I believe that period is more than long enough to allay fears that I come here as being supplanted from the Tulu House. The second part, JP, is that I never believed that cooling off period applies to me. And I believe it does not believe to assessors of judges who assess what their past political beliefs were and whether they are consistent with the values of the Constitution. Thank you.
Thank you so much, Chief Justice. Thank you so much, Advocate. Truly appreciate it.
Thank you, Honorable MEC. Honorable Moima.
Thank you, Chief Justice. Good afternoon, Advocate Malindi.
Good afternoon, Councillor, Commissioner.
Your experience as a legal practitioner and having acted, and drawing from your experience, which was not very good, as a former Delmas trialist, how do you compare the philosophy that governed the courts then and the current philosophy that governs our court, that governs our courts post 1994? The second one, second question relates to the narrative that sometimes can be quite discomforting around accusation of courts or of our judges as being judicial activists. Do you think there is a cause for concern? Because even with the former president of the USA, Donald Trump, when he replaced the Chief Justice then, what he said is that he's not going to appoint a judicial activist because judges are not there to make law; they must implement. Likewise, with the Prime Minister of United Kingdom, when the Queen dissolved Parliament following the Brexit crisis, the courts set aside that decision. Do you think there is a cause for concern on the narrative of judicial activism? Thank you, Chief Justice. Thank you, Advocate Malindi.
Commissioner, first of all, we know, as judgments would usually say, that the Constitution provides a bridge from the old to the new. In fact, there has been that bridge and it's firmly built. We come from a system where the choosing of judges was by the prerogative of the executive. That has changed, and that will not change in as far as things stand now. We now are selected by a panel of no less than 20 commissioners who assess our ability and our suitability, and therefore it's no longer the choice or the prerogative of the minister. That's the first thing. Secondly, the judicial activism we celebrated post-1994 because the apartheid laws were not pro the liberty of individuals, and we agitated for the judiciary to interpret the law to encompass international law and international customary law. We now are in a dispensation where the Constitution encourages judicial activism to the extent that the Constitution and the laws that give effect to the Constitution do not cover those areas in which our laws still fall short of giving freedom and liberty to the people. That is why we have in Section 39 an injunction that the Constitution or the judges must at all times interpret the law with a purpose of giving freedoms instead of taking them. And that interpretation will apply to questions of customary or common law. I believe, therefore, that there is a measure of activism that is encouraged by our Constitution, that where the Constitution and our laws fall short, international law may be looked upon as well to assist in interpreting the Constitution in such a way that it remains progressive and not regressive. I must say, therefore, that it is still a question whether with those sections in the Constitution that encourage activism, whether the bench can still go beyond that. And it is a matter of debate, but there is enough judicial activism to ensure the liberty of individuals.
Thank you, Advocate Malini. Thank you, Chief Justice.
Thank you, Honorable Mwema. Honorable Singh.
Thank you, Chief Justice, and good afternoon to Advocate Malindi. It's good to see you again, even if it is virtually. I remember the last interview. I have just one question for you, Advocate Malindi. Over the past 10 years or so, I mean, you've indicated that you've held directorships and trusteeships and interest in business entities, about 35 of them. But at the time of this application, you've resigned from all of them but 3, and you've indicated that you will resign from the 3 should you be appointed. Now, the one area I want to question is, I remember in the last interview, you did say you was a trustee in a matter, in the Sequoia Family Trust matter, but you have resigned from those trusts. And now you also say that you may be cited in these matters moving forward. Do you think in any way this, if you are appointed as a judge, this will have any impact on you and on your position? Thank you.
I don't think so, Commissioner Singh. I have resigned, but as citations in matters would be I remain cited in those proceedings, and I do not think it is a matter that will affect my standing as a judicial officer if appointed.
Thank you very much, Advocate Marindi. Thank you, Chief Justice.
Thank you, Honorable Singh. Prof.
Thank you, Chief Justice. Good afternoon, sir.
Good afternoon, Professor.
Would you mind sharing your judicial philosophy with us?
Professor, we live in a constitutional dispensation, and therefore our philosophy is mainly guided by the values and principles that are enshrined in our constitution. I remain committed to the advancement of human rights, and I remain committed to advancing the rights that we enjoy in our constitution to encompass other rights which we may not have encompassed yet in international law. And our constitution has, our country has become a signatory to many international instruments, and we have ratified them. I believe that our constitution has embraced philosophies and constitutional principles that place us in a situation where we can proudly say that, let's say me as an individual, that the Constitution has placed me in a way where I don't have to philosophize on any aspect of the law, because the Constitution has embraced all those areas of the law which require development, although there is room for philosophical development of the law in several areas.
Thank you, sir. On another point, I noted in your application that you sat as an arbitrator in quite a number of commercial cases. Do you think it is perhaps detrimental to the development of our specifically commercial law if one is to refer more and more cases on arbitration instead of to deal with the disputes before the courts? What is your view on that?
I do not think so, Professor. I think that arbitration is a very efficient and cost-effective manner of resolving international disputes, especially for those who can afford to pay for those arbitrators, because parties pay in those instances. I think that the rate of interstate investments and trade involvement requires speedy resolution as contained in many rules of arbitration. So I do not think that it will be a stifling method of resolving problems, but it will be ensure speedy resolution. And of course, courts still have a role in international arbitration where parties seek those proceedings to be reviewed for the grounds stated in arbitrations.
Thank you, sir, but that relates to international arbitration. What about domestic arbitration? Or were you just involved in international arbitrations?
I'm involved in domestic arbitrations mainly, and I think even in domestic arbitration, I think arbitration is the way to go, including mediation in those processes. I must say that at the beginning, there was a misgiving about the move to arbitration because it flourished at the moment that there was transformation of the bench, and without being able to put to you statistics, there was a perception, and I think it was an informed perception that arbitration was resorted to in order to avoid benches that are now populated by Black and women practitioners who historically were not considered to be familiar with commercial law. We have gone a long way since then, we have practitioners, Black and female, very few female at all, who participate in those forums as adjudicators in arbitrations and mediation. It has become more legitimate recently than in 1998 when it was first muted into the first decade or so. So I am happy that arbitration is but one of those methods of resolving disputes. And I am aware that until recently, there were judges that were complaining that parties appear before them when they realized that a Black judge is presiding. They ask for an adjournment for an hour, come back and say they've decided to go to arbitration. So that stigma of Black people as not being competent to deal with arbitration matters still exists. But as a principle, and as the commercial world now demands, arbitrations and mediations are more legitimate than they were some 2 or 3 decades ago. And I would say I support arbitration and mediation, and I believe that courts will ensure that they stand at the same standing as arbitrations, so that there isn't much choice between litigants as to whether they go to a conventional court or whether they go to arbitration. And whether they go to arbitration will depend on the arbitration clause that they have fashioned, especially if it's international arbitration, as to whether which court should jurisdiction over their matter. But definitely for domestic arbitrations, I believe courts should remain the primary forum that we go for resolving our disputes.
Thank you, Sir. CJ, if I just may have a follow-up question. It deals with the question of the publicity given to arbitration awards. My question related specifically whether it isn't detrimental to the development of commercial law if disputes are taken on arbitration, and it's due to the fact of the confidentiality of the awards. If you could perhaps just deal with that part of the question.
Does it go to his suitability, Prof? I'm just trying to balance time, the upcoming meeting, and the need to test the suitability of a candidate for what he has applied for. Would you say it goes for suitability, or is it just out of curiosity?
It was basically to see what his position is on the resolution of disputes and what the easiest way is and the most beneficial ways for the South African court law to develop. But if you don't want to allow it, that's fine. Thank you.
No. If you feel strongly about it, go ahead, Prof. I was just cautioning.
No, that's fine. I can live with that. Thanks. Thank you, sir.
Thank you, Professor.
Thank you, Prof. Thank you. Advocate Mpofu.
Thank you.
May I also add my name, CJ?
Go ahead, Advocate. I have President Maya.
Okay, thank you, CJ. Good afternoon, Senior Counsel.
Good afternoon, Commissioner Mpofu.
Thank you. I'm going to ask you about, thank God you're the last person I have to declare that I know for a long time. I've checked the list, but I think I must put that on record, that I've known you for more than 35 years. I think. Now, the question that I'm going to ask you has to do with something that I feel gets neglected a lot, and it is about judicial temperament, which is one of the requirements for a good judge. And I'm asking you specifically this question because of what I've just said. Having known you for more than 35 years, I've never seen you or heard you raising your voice at all, not even once. I don't know how you survived like that. Yeah. But, yeah. But and yet you are a very effective person and with strong views. Now, the reason why I'm asking you in particular is because you probably, as a Delmas trialist, which is where I met you, you probably were exposed to one of the worst forms of what not to do in respect of judicial temperament, because of the relationship that the judge who was a judge in your matter, how he treated counsel in particular, which was very, very bad. I think one of them, he reported twice to the Bar Council, Mr. Marcus SC now. And he fought with George Bezos, Chaskalson, and all the other people that we respect. To what, how important is judicial temperament and the effects? One of the candidates this morning talked about being bullied from the bench. She was giving experiences from a woman's point of view. But what is the importance of this element, usually forgotten element of judge making, which is judicial temperament, particularly vis-a-vis treatment of counsel, treatment of people in the courtroom, making juniors feel comfortable that they're not going to be told that they're asking stupid questions and things like that. If you can comment on that, please. As I say, as someone who's a professor of temperament.
Well, Commissioner Mpofu, I think as we get received as acting judges, and as some get admitted as full-time judges, we should be educated on the importance of the role that we have to play as judges. We are one of the arms of government, which is regarded as so important that the other two arms of government that are elected choose to appoint some of the best practitioners who must carry along with them the best of professional conduct and integrity into resolving disputes between the state and its citizens and amongst its citizens. So it is required of those people to see the significance of their role, that it is not a personal attribute that they are being chosen to be judges. It is an acknowledgement that they must stand as the most upright, as the most understanding, as the most persons who, when they pronounce on their decisions, they are decisions that will be accepted throughout by the citizenry. And especially that judges' standing enhances what we now believe is the three arms of state in the modern state. So judges must see their role as precisely that they are chosen to be these persons who stand above petty squabbles where people are involved in a dispute, that they must rise above all of those, Theirs is not to show off about their understanding or to throw around their weight when they are adjudicating matters, but that they are discharging a very crucial part in maintaining the triad, the state that stands on three legs like a tripod. So if judges are seen as bullying or unfeeling, unempathetic to the people who stand before them, they may easily lead to one of the legs on which the state stands on breaking or collapsing, discredited. And therefore, if that one leg of the tripod is disabled in the manner that you suggest, it undermines the whole concept of a state where we have the judiciary, the legislature, and the most revered state as the one that keeps the others in check and takes into account the views and grievances of others, having treated them with the dignity, respect that they regard, because they may impact on the two other arms of government. I don't know if that answers your question.
Yeah, no, it does. Thank you very much. Yeah. Now, the last question is about you've been involved most recently with the initiative of the formation of PABASA as a crucial part of the transformation of the profession, broadly speaking, not just the practicing profession, but the profession as a whole, including the judiciary. Firstly, can you just tell us why those experiences, what will you be bringing to the bench, given those are your own life experiences, including that one? And that includes all the other life experiences of yourself as an accused in a long trial, as a prisoner on Robben Island, as a former president of NADEL, and all that. What will be the unique contribution that comes from those life experiences that you'll be bringing to our bench if you are appointed?
And Advocate Malindi, if you could just summarize, please, so far as possible, just give us a brief response. Thank you.
Thank you, Chief Justice. Commissioner Mpofu, the formation of PABASA is but a drop in an ocean. It is an endeavor to create an environment where practitioners will feel respected and recognized for their ability. Secondly, for those who are not there yet, will be in an environment where they know it's an initiative of people who are not seeking assimilation into other structures that usually undermine the background of those people, either on the basis of race or gender, and that people will endeavor to achieve what they want to achieve, knowing that they are being intellectually and otherwise is appreciated. And I'm saying that it's a drop in an ocean, because we know as much as we endeavor to achieve that culture within PABASA, whether those people succeed depends on who control or who are the consumers of legal services. And at present, the majority of consumers of legal services are people who own the resources of creating a livelihood. In other words, I know you will say those who own the means of production. And those that control the networks of access to work. And we are not there yet, because a minority of us still owns the means of production, and therefore litigate on substantial matters to a very limited extent. So PABASA is great to be in, and other initiatives that we know about that collaborate with PABASA at various levels. We are giving skills to people so that they are not seen as incapable to deal with any matter. But at the end of the day, whether they get to deal with those matters depends on whether they have the necessary networks amongst the people who own the means of production and the people who are the consumers of legal services. Thank you.
Thank you, Chief Justice. Thank you, Advocate Malindi.
Thank you, Advocate Mbofu. President Maya.
Thank you, CJ. I won't be long. I was actually going to ask you about Papasa Council. First, well, I still have another question, but first, I'm very glad that you put the name forward again. It's not often that black souls make themselves available for judicial office, and that is important. Now, did I hear you correctly when I thought you said you've never appeared before the Constitutional Court?
I have appeared before the I have appeared before. Okay, there's a feedback.
All right. I misheard. No, that is fine.
What I was saying, President, is that from 2016, when I was last here, I have not appeared before the Constitutional Court, but I must be mistaken because I think I appeared in the Steenkamp versus Edcom matter, which was post-2016.
That would have been only once. Has that been from lack of briefs, or what's the reason?
It is lack of opportunity to appear in that court, President.
All right. Thank you, Counsel. Thank you, CJ.
Thank you, President. Advocate Malindi SC, thank you, sir. You're excused.
Thank you, Chief Justice.
Thank you very much, JP. Good afternoon, Mr. Malungana.
Good afternoon, CJ.
Are you well, sir?
I'm good. How are you, CJ?
I'm very well, thank you. Where did you obtain your qualifications?
University of the North, which is currently called University of Limpopo.
Yes.
Yes.
And what have you been doing all along, apart from being an attorney? Did you do something else before you became an attorney?
Yes, but that is in my high school years when I was when I was a president of the SRC.
Yes.
Yes, and I participated in the local structures, and I was also part of COSAS.
Oh, yes.
Yes.
And for how many years have you been an attorney?
Now 24 years.
And for how many terms did you act as a judge?
Oh, many times. I think I acted for about 45 weeks.
Did you find it very difficult or comfortable?
I grew fond of acting or being a judge because earlier on when I went to the bench, I just wanted to acquire an experience and see what is happening on the other side. But I found it very interesting because each day you meet new challenges. And
Yes.
that was very interesting.
Thank you. Colleagues, may I have your names, please? All right.
Schlemmer.
Nyambi.
Thank you.
I don't know whether you heard Schlemmer.
I've got to hear both. All right. JP?
Thank you very much, Chief Justice. Good afternoon, Tatan Malunga.
Good afternoon, JP.
The CJ covered the first part. You've acted for about 45 weeks in the division, and I note in the spreadsheet that you have yet to do special civil trials and special motions. Is that correct?
Indeed.
Yeah, you've had 1 week in the agent court. How did you find it?
I can't hear you well.
I say you've acted for 1 week in the agent court. How did you find that?
It taught me a lot of things, and especially to the skills of having to make judgments on your feet, and to be able to research the law and apply it without having to wait for a long time.
Yes.
Yes.
Yeah. And you think the acting stints that you've done have prepared you to raise your hand for a permanent appointment?
Yes, it's quite long. Other people, they already call me a senior acting judge, and I don't really like the title. I want to move on and, do some other things. Yes.
The last question I want to ask you, well, there are those who've acted more than double the period of.
Well, I'm not aware, but all I know is that I'm called a senior acting judge, and I don't know where that comes from.
Thank you. The last issue is you will confirm I requested you probably 4 weeks before the date of the interviews, more than 4 weeks before the interviews, to compile a list of your judgments that you've prepared. And the reason I do this is to give the commission an idea how long it takes you from when you reserve a judgment to when you hand it down. Your list, and I think just one part of the candidate was just finished now, but yours does not show us when these judgments, it shows a date, but I'm not sure whether it's a date when the judgment was handed down or when the matter was heard. Is there a reason for this?
Yes, there is. There's
a good reason. Can you explain to the
commission? There's a good reason for that, JP. Firstly, when you sent me that email, I was sitting on a very complex part-head trial, and it was actually a commercial trial for 2 weeks. And when I received your email, I delegated that to my registrar to try and extract the information, because you'll recall that most acting judges, when they live with some reserved judgments, they don't know when those judgments were actually delivered. And I didn't have the opportunity of extracting the information timeously to be able to comply with your request. But however, I managed to get some of the information in which it was stated as to when those judgments were actually delivered. And that is what you will have in my spreadsheet.
So the dates we have here, the dates when the judgments were delivered.
The dates?
The dates that are in the list, are those the dates when the judgments were delivered?
Indeed,
Were handed
indeed,
down?
JP, indeed,
Okay.
yes.
Are you able to tell us whether in any of these judgments it took you less than 3 months, or in fact, don't deal with that, whether it took you more than 3 months or more than 6 months?
My time around usually is 2 months or a month. I had to go beyond 3 months to deliver my judgments.
Yes.
Yes.
Okay. Thank you very much, Chief Justice.
Thank you very much, Honorable JP. Honorable MEC.
I'm covered, Chief Justice. Thank you so much.
Prof.
Thank you, Chief Justice. Good afternoon, sir. I'm to your right.
Good afternoon.
Directly to your right.
Good afternoon, Prof.
Would you mind sharing your judicial philosophy with us, please? And the reason why I'm asking you this also is because in the GCB's commentary, they say it is not clear to what extent you are committed to human rights and your experience with regard to the values and needs of the community. So if you can elaborate on that, please. So firstly, your judicial philosophy and then linked to the values and needs of the community.
Yes, as you will know that most of us who come from the rural areas and the townships, sometimes we don't really record exactly what we do in our communities. But I was involved in a number of social programs when I was still a student, and wherein we would assist people who are less fortunate to do things. And the other things that I've been doing in my years is to try and meet those students who are not sure as to where they want to go in life in terms of career choices and things like that. And I have assisted them a great deal, especially when I'm back home in Limpopo, and I would try to meet with the youth leaders of the community and try to deliberate on issues that go around the community and assist them where I could from legal perspective. And especially the issues regarding the land claims, and some of them would ask me that, how do I go about filling in the land claims document, and I will assist them in that regard, but without necessarily recording them in a formal manner. Yes.
And your judicial philosophy, sir? Judicial philosophy.
Yes. Probably maybe you need to elaborate as to what do you mean by judicial authority.
No. Judicial philosophy.
Philosophy.
Yeah, what is your philosophy as a judge when you determine the answers to matters?
Oh, yes. Firstly, I will have to...
Mr. Mlungana, do you understand it, or do you want it to be simplified?
I wanted her to actually simplify it and elaborate so that I can be able to, get the context.
Let me try. When you deal with cases before you,
yes,
central to your thinking or approach,
yes,
what is it that you see as a contribution of a judge or a judicial officer towards making life as we all desire to see it be? How do you see a judge or a magistrate contributing towards the attainment of a South Africa for all?
Yes. Firstly, I would consider the legal principles and the constitutionality of the issues that are being raised in the particular set of facts, and then because of the fact that as you know, the Constitution is the basis upon which we as judicial officers need to have regard to before we could determine whether whatever relief that is being asked is competent or not. And those are the things that I would actually frame in my mind to really check whether is there conformity to the Constitution, is the end result going to bring justice to the litigants in a particular matter. But the Constitution, the constitutional imperatives will always be my guiding principles.
Thank you, Chief Justice. Thank you, sir.
Thank you.
Thank you very much, Prof. Honorable Nyambi.
Cover CJ.
Thank you, sir. Commissioner Barna.
Thank you, Chief Justice. Good afternoon, sir. My question is regarding the community involvement. Once again, there has been concern raised about lack of community involvement. You do refer to two church organizations that you have involvement with, and I must declare I'm involved in at least one of them. But my question is, why do you, when you declare that, is there any specific involvement that, outreach to the community or anything in that regard which would amplify that part of your answer?
Yes, I was actually mentioning those churches as, when I want to, uplift myself spiritually, but I've never really participated in the running of those particular churches, in the leadership positions of the churches.
Thank you. And then one other question is just you list as your membership of organizations, you list the LPC as a member. I'm assuming that is a member in the wide sense.
Yes, it is.
Members of the council are elected, so strictly speaking, it's a regulator. And you're not a member of the council, just for clarity.
No, I'm not.
Okay, thank you. Thank you, Chief Justice.
Thank you.
Thank you, sir. Mr. Mlungwana, you alluded to your role in COSAS. Very briefly, what drove you to be a member of COSAS? What did you want to achieve?
When I was a member of the COSAS, it was still the early years of our country's democracy. I was president of the SRC in our schools, and the most important objective at that particular time was to expedite the emancipation of our people at that particular time. You will recall in the 1990s when Mandela was released from jail, most of our schools in the country, they embarked on various forms of resistance, and sometimes we had to be under one umbrella body where I was representing my school, and other presidents were representing their schools, and we had to all gather under the umbrella of COSAS at that particular time, and that was in the early years of COSAS.
Now, let me ask you a rhetorical and yet necessary question. Is it possible to talk about what COSAS stood for as something that is divorced from a commitment to human rights?
Yes, education, COSAS is involved in the struggle for a better education, and education has always been part of human rights. That every child must acquire the necessary skills and must acquire education, and must be able to participate in the economy of our country, and that all stems from education.
CJ, allow me, I beg your indulgence. I want to follow up two questions on the basis of what you've just asked quickly.
Yes.
Please, if you allow
Is that Honorable Dodovu?
Yes.
I also want to follow up, CJ.
Yes.
Okay, all right, okay.
Yes. Okay. When was COSAS founded?
When was COSAS founded?
Yes.
I've got no idea as to when it was founded, but when I was an SRC president, I was part of. We became part of COSAS.
Okay. Can I give me two former presidents of COSAS?
I remember David Makura, the current president, who was also the member, the president of
COSAS.
Yes.
I think he
COSAS, are you
means,
sure that COSAS?
he means SASCO.
SASCO, yes. Sorry, I beg your pardon now.
No, I want to talk about COSAS.
Yes.
COSAS.
No, it was actually SASCO, yes.
Yeah, you was SASCO.
Yes.
You don't remember two presidents of COSAS?
No, I don't remember them now.
Look at.
But I remember Mashauman Zin from our area. He was the regional president.
There is a former president of COSAS.
Not the national one, but
I'm saying there is a former president of COSAS.
The other one I remember was Julius Palema.
Okay, thank you very much. I'm done, CJ.
Thank you, Honorable Dodovu. Advocating for
No, I'm covered, CJ.
Thank you, sir.
CJ, follow up, CJ.
Is that you, Commissioner Sigogo?
It's me, CJ, thank you.
Yes, sir.
Good afternoon, sir. I'm on your right, yeah. You made mention in your document, in your pack,
yes,
that there's a role that you played in the Black Lives Association. Which role did you play?
I did not say in my CV that there is a role that I played. I only said I was a member of the PLA.
Okay, which year?
That was around 2010 when Princeman Mabunda was the president of the PLA.
Thank you.
Yes.
Thank you, CJ.
Sorry, just a follow-up question, CJ. Sorry, Clever.
Yes, Honorable Clever.
Thank you, CJ. Good afternoon.
Good afternoon.
Yeah. Candidate, you say you were a member of COSAS. Sorry, SASCO.
Yes.
Not COSAS.
Yes, but Mr. Kaba, I need to.
Honorable Kaba, he said he was an SRC president that affiliated to COSAS, and that's how he became a member of COSAS.
Yes, that's how I understood.
Yes, I was not actively involved in COSAS. Yeah.
Chair, no, let me pursue the question. You were a president of SRC that was affiliated to COSAS.
Yes. All I'm saying is, at that time when we had to meet every day, and if I may mention this, at Namakhale there was actually a central structure that if we were to meet, all of us as presidents of these high schools around the area, we had to meet under that umbrella. So I think the mistaken part of the whole thing is whether it's COSAS or it's SASCO. But that was in the early 90s, and it's not something that I also mentioned in my...
CJ, it serves no purpose to pursue the question, thanks.
Yeah.
Thank you. You are excused, Mr. Malungo.
Thank you. Thank you.
Thank you. Thank you. Good afternoon, Mr. Manuel. Good afternoon, sir.
Afternoon, Chief Justice. Can you hear me?
Yes, I can. Are you well?
Very well, thanks, Chief Justice.
You seem to be relaxed and comfortable, so I won't waste time on you.
Thank you.
You were with the Competition Tribunal for about 20 years, am I mistaken?
That's correct, 20 years. 10 years as a full-time member and last 10 years as the chairperson.
I will leave most of what needs to be asked at this preliminary stage to the JP. I just want to know one thing. There seems to be a considerable delay in having both the Competition Commission, the Competition Tribunal, and the Competition Appeal Court help achieve what the Competition Act was enacted to help us achieve. Is that the sense you have, or could it be that I'm not as informed as I ought to be?
Chief Justice, I think we have actually achieved what we're out there to achieve. It's not a finished project, but not all problems in the economy are problems created by competition problems, and not all competition regulation is the responsibility of the competition authorities. But to the extent that we've had things to do, we've intervened in probably every sector, and I think that we have made a difference. But it's an ongoing project, it's a never finishing project.
And you're quite satisfied that the jurisprudence developed, particularly at a Competition Appeal Court level, is such as to help open up the door to meaningful participation in the mainstream economy to the previously excluded, and that both the legislation and the way it is interpreted helps to strengthen the hand that ought to keep checks on collusions and this, I forgot the expression, this slapping together that tends to frustrate the objectives of competition appeal at the Competition Act.
Chief Justice, I think the experience is variable at the level of what you're saying of cartels or collusion. There have been a lot of decisions, and I think there is greater clarity than there was before. In other areas such as abuse of dominance, there is some jurisprudence, but it needs to be developed further. In merger control, I think there's quite a lot of experience and clarity. But the Act was recently amended 2 years ago to deal with issues of inclusion. And those sections still need to be litigated. And so there's, at this stage, a lack of clarity, a lack of jurisprudence. But those are terribly important sections which will properly litigate, give people access to the economy which they haven't had before, such as what it's like to experience the buyer power of an incumbent firm, or how to be included in an economy where there's a club of people trying to keep you out.
And you would say that the progress is commendable. We shouldn't get impatient with the pace at which things are happening, and the direction in which the development of the jurisprudence is going.
I think it's developing, but I suppose we can always be justified in saying it should be developing further and at a greater speed.
All right. Thank you very much. JP, before I hand over to you, let me first get a list of my colleagues, our colleagues who would want to put questions to Mr. Manuel. Colleagues? Okay, it doesn't look like there's any colleague who has a question.
Chief Justice.
Over to you, JP.
Chief Justice. It's
Is
Commissioner.
that the Commissioner Tsepe?
Yes, Chief Justice.
And both.
And Schlemmer, please.
And Lamola CJ, my mic was not properly functioning.
Okay, Minister. All right. JP?
Thank you very much, Chief Justice. Mr. Manoim, good afternoon.
Afternoon, JP.
I have circulated your spreadsheet of work allocations since you started acting in 2019. I see that the only work areas you haven't covered are the special trials, which are the trials of long duration, as well as the criminal trial court. But that's not your fault. It's the person who allocates work. He didn't put you there.
Thank you, JP.
That's correct.
That is correct, yes.
Yeah. But what the spreadsheet also reveals is that you've done quite some heavy lifting. You've got 5 weeks in the opposed motions court. Can you confirm that at any given point in time per week, how many opposed motions would you get if you are allocated there?
It's varied because I think during the lockdown we got fewer, but sometimes you can have 15 to 20. Sometimes they settle on the day, so it varies.
But that's where most reserve judgments come from, isn't it?
That's correct.
You've also dealt with 2 full court appeals. Did you write any of them?
I haven't written any full court appeals yet. I got one last week. We heard a full court appeal, and I've been allocated to write it.
Right. And you had 2 special motions. That is the special motions that are allocated outside of the ordinary opposed motion.
I think that I've one settled. We were ready for trial, and it settled. Yeah. The other, I wrote a decision.
How did you find that one that you wrote?
It was a very interesting case, and it was nice to actually hear something over a longer period of time. It involved removal of trustees in a family trust.
Yeah. And my last question to you is, the 44 weeks you've acted in the division since 2019 is in addition to your extensive judicial exposure sitting in the competition tribunal, am I correct?
That's correct. The tribunal is an adjudicative body. We hear trials, we hear motions. We really do judges' work, although we're an administrative tribunal.
Thank you very much, Chief Justice.
Thank you, Judge President. Honorable MEC.
Thanks so much, Chief Justice. Good evening, Mr. Manon.
Good evening, MEC.
What's your attitude towards judges that don't deliver judgments within the 3 months norm?
Well, judges must deliver on time. That's part of their job. And if they don't meet the 3-month obligation, there needs to be a reason. There may well be a reason. But if there's not, then I think it should count against them.
Do you have any outstanding judgments?
At the moment, just the appeal I mentioned from last week is my one reserve judgment. But we heard the matter on Wednesday last week.
Thanks so much, Chief Justice.
Thank you, MEC. Commissioner Tsepe.
Thank you, Chief Justice. Good afternoon, Mr. Manoem. Chief Justice, may I declare right now that I was a candidate attorney under Mr. Manoem when he was at Chidel Thompson and Haysom, a great mentor indeed. Thank you. Mr. Manoem, just on the issue relating to your criminal work, could you just, and I say this because I know that in your time at Chidel Thompson and Haysom, you would have been involved in a great deal of work in criminal work, and I just wanted to talk us through that, including constitutional work that you would have done over and above the work that you would have done sitting as a member of the competition tribunal. Thank you.
Okay. When I was in my firm of attorneys, Chidel Thompson Haysom, most of my time in practice was actually doing political trials, and they were criminal trials, and they were actually very lengthy trials where quite a few complex issues were raised. Now, admittedly, it was at a time before the Constitution, so certain of the principles that have evolved post the Constitution didn't arise. But nevertheless, it is a form of, I did get exposed to criminal trial experience. In the competition tribunal, we run cartel cases. Cartels have got a criminal element to them. Cartels are a criminal law offense as well, but where we run them, they're a conspiracy. So a lot of what you see in a criminal trial would come up in a cartel case.
And in relation to constitutional law matters?
In relation to constitutional law, my time in practice preceded, for the most part, the adoption of the Constitution. But constitutional issues have arisen time and time again in the Competition Tribunal because there have been constitutional challenges which we've had to address. Some of them are in the judgments here as to whether we could, for instance, fine people because we are not a criminal system, as to whether we were sufficiently independent. And the economic rights came up. Then we had jurisdictional points which involved the common law and the Constitution. So it's come up on frequent occasions.
Thank you, Chief Justice. Thank you, Mr. Manoy.
Thank you very much, Commissioner Tsepe, Advocate in both SC.
Thank you. Good afternoon, Mr. Manoy. How are you?
Fine, how are you?
Very well, thanks. I'd like you to just take the commission or the commissioners through. I said to an earlier candidate that that seat you're sitting on is for bragging and not for modesty here. So can you please just explain, when you say you have 20 years of adjudication experience in the competition tribunal in particular, to what extent is that relevant? Have you found that relevant to your stints as an acting judge, particularly because some of those cases include issues of procedure, jurisdiction, exceptions? I remember one of the biggest cases there was the Standard Bank, the banking manipulation of the currency case, where the biggest cases were jurisdiction, exception, very complex. And also that many of us and very senior advocates have appeared there against each other. Some of the most eminent counsel do battle in those forums. So it's not just some little forum somewhere in a corner. Can you just explain that intersection and how that would assist you if you are appointed?
Well, the experience of being in the competition tribunal might seem narrow because you're looking at one area of substantive law. But we actually, when we hear a case, we're crossing into all sorts of areas of law, company law, sometimes trust law, intellectual property. We're also dealing with civil procedure issues. There are exceptions you have to deal with. We run trials as you would a civil trial where lawyers appear and they object and you've got to make decisions on the spot. As you mentioned the Banks case. That was a case where there were 13 legal teams in which all of them were led by a senior counsel. So one of the challenges is actually how do you manage a trial like that? And I think one of the things that I've learned is how do you handle a complex case to make sure it's run on time and run efficiently against quite a few big people in the room. You led one. You were one of the eminent counsel who led one of the teams. I think it was 12 teams up against you, and we had to make sure that you got your voice in the room and not just all of them all the time. So I think many of the challenges that you're going to get in a courtroom, this helped as preparation, and then you've got to write decisions, often very, very complex decisions, and write them in a way that's comprehensible to people to see what's going on.
Thank you. CJ, out of interest, in that case, there were maybe about 100 lawyers against us when I counted in the room.
I think the room wasn't big enough to fit them all in.
The room was not big enough, even for the egos. Thank you. So the second question is around your student activism. We just had somebody here who wasn't sure how exactly he was a student activist. Okay. So you were involved in student politics when it was really, really unfashionable as a member of NUSAS and an activist part of the SRC and so on. Can you, and the question that was put by the CJ to the previous candidate was, what is it that drove you to participate in the struggle at that level? And whatever it is that drove you to do that, how is that going to inform your your work if you are appointed? In other words, in the area of human rights and abhorrence of inequality.
When I was a student, I was the president of the SRC at the University of Witwatersrand, and I was the vice president of what was then the National Union of South African Students, or NUSAS. What got me into it, I suppose, was an early political consciousness, which had been formed partly by my family, partly by the environment of people I was with. So I didn't see involvement in student politics to get the cheapest chips prices in the canteen. I saw a greater involvement, and we try to both conscientize what was largely then a white student body about the issues of the country, with sometimes mixed success. But we also had contact with student organizations at the time. It was AZASA and it was COSAS, and we tried to get involved in certain of their activities with them. That had to be in some way clandestine, because those people had to operate underground. They met with us openly, there would be problems. And also we couldn't use the resources of the, as it were, the so-called white SRC to assist other organizations. But we found ways to do it.
Thank you, Chief Justice.
Can I just make a follow-up, Chief Justice?
Thank you. I couldn't make out the voice. Is that you, Minister?
Muimang, Chief Justice.
Oh, okay. Well, maybe I'm prophesying.
Prophetic.
Honorable Muimang?
Thank you, Chief Justice. I guess you are familiar with Justice Alvie Sachs.
Sorry, am I familiar with him?
Yes.
Yes.
There are two questions that he poses in one of his books. The first question is that if a paternity test were done on South Africa's widely admired constitution, whose DNA would come up? Is the constitution just a beautiful piece of paper or not? What is your view on that?
Sorry, I couldn't hear what you said. Which view would come up? I think I lost part of it.
Okay, let me relax.
Thanks. Perhaps pull the mic closer. Thank you.
He poses two questions in his book, in Dedication to Oliver Tambo's Dream. He poses two questions. The first one is, if a paternity test were done on South Africa's widely admired constitution, whose DNA would come up? The second one, is the constitution just a beautiful piece of paper or not? What is your view with regard to these questions?
Well, I think we've got to make sure that it isn't just a beautiful piece of paper, and that it's implemented, and that it has beautiful language in it. But unless judges are continually trying to implement it, and I see it as a working project, then it will simply be a beautiful piece of paper. We've, as it were, got to get the beauty to work, and that's our job as judges.
Thank you, Chief Justice. Thank you, Justice Ma'am.
Thank you, Honorable Muimang. Professor?
Thank you, Chief Justice. Good afternoon, sir.
Sir.
I should perhaps also just declare that we met when you worked at WITS. We didn't get to know each other quite well, but we did work together. Yes. Most of my questions have been covered, but I have just one question for you, and that relates to the time that it took for the judgments in the competition tribunal to be written. I've noticed in some of them it took around about a year for a judgment to come out, whereas with your judgments at the Gauteng court, they come out very quickly. Is it due to the complexity? Could you perhaps just elaborate a little bit on that?
You're correct. There are one or two which have taken a long time to do. I think there are a couple of reasons for it. One is the complexity, and sometimes when we've written a judgment, because we've got to deal with economic issues, we've in fact asked people to give us more information whilst you're writing the thing, because you want the information isn't satisfactory. Secondly, as chair, I was also managing the organization, so it meant that it cut down on my ability to write. The third thing is that there's no recess in the competition tribunal; it sits all the time, and you've got the benefit of a recess in the court. So you're actually continually having to have new matters. We also don't have acting members. So there's no ability in the competition tribunal to not hear a case. You've got to give priority to hearing cases. And so judgment writing falls behind. There have been some reforms which I've suggested and the minister then have taken up to try and deal with that problem, but they're institutional problems.
Thank you, sir. That answers the question. Thanks, Chief Justice.
Thank you, Prof. Honorable Minister.
Thank you, CJ. I must also declare that I drank lots of water with Mr. Mayom in various conferences of the competitions.
It was only water.
Well, Honorable Minister, I think they are wondering whether it's waters of immortality or
yeah, no, thank you. Mr. Mayor, my question relates to where you started with the CJ. What other instruments do you think could help us to deconcentrate the economy from the monopolies? Because you answered that it's not only the Competition Act that can help us in that.
Well, I think there are various ways. One of the new powers under the Competition Act is the market inquiry. And the market inquiry main focus is on economic inclusion. And so once you can get inclusion right, you erode monopolies because they get competed down. Most monopolies are actually inefficient. And so if they face some competition, we will erode them. That's probably the quickest and best way to get rid of monopolies. The other problem that we've experienced, and it's outside of the competition authorities, is that for many industries, you need a license to actually enter the industry. And without a license, you can't compete. So historically, for instance, we've been a bit critical of the banking regulator because it's taken many years for them to issue new licenses. Similarly for the telecoms regulator. And if you issue more licenses in a regulated industry, you'll get deconcentration and more entry. Also with new technology, it's more likely that you'll get entry than you did in the old bricks and mortar economy.
One of the things I had observed, you may not want to say whether you agree with me or not, but you can make an observation, was that sometimes the tribunal felt frustrated by some of the judgments that the Competitions Appeals Court, in particular that it seems to have allowed parties to raise characterization as a defense against the cartel conduct.
There have been issues on which we and our colleagues in the appeal court would not have agreed on interpretation. So the characterization is an issue in a cartel case as to whether you needed to say with people fix the prices, you've just got to characterize whether they're in fact doing that or not. In other words, we've always felt it was an unnecessary step. But I think one can deal with that. There was a suggestion there should be characterization should actually find its place in the new act when amendments were put in. And there was opposition to that, fortunately, by the Commission, and it didn't go in. But sometimes, in a sense, we have differed with them, but I respectfully say that on these issues there can be differences. They're very, very difficult issues.
With your indulgence, CJ, last one.
Yes, Honorable Minister, please go ahead.
Yeah, what could you say has been your contribution in laying the foundation for the current amendment to the Competitions Act, and how do you think they can change the structure of the economy?
Well, I think in some way we've written certain decisions where there have been, due to later competition appeal court, some difficulties in interpretation, and the amendments have been done to try and deal with those situations. I can think of two on the substantive area, predatory pricing and what's called excessive pricing. There've also been we've made certain suggestions in relation to merger control that will expand the jurisdiction of consideration of mergers. And thirdly, the issue of a market inquiry is a very, very powerful tool for the competition authorities and should be a quick one to use. And that's gone into the act, and hopefully we will see the results.
Thank you, CJ. Thank you, Judge.
Thank you, Minister. Just my last question, Mr. Manuel. You know, there are two competition matters before the Constitutional Court at the moment. I must say I have found a lot of depth and breadth in their reasoning, and some of the decisions tend to be long, up to over 400 paragraphs. Is there a way in which, that's the first question, is there a way in which the decisions could be shortened without compromising the quality? And number two, given the critical role that the tribunal plays, if you were to equate it to any of our existing courts, so that its role is properly appreciated, where would you place it?
On your last point, I suppose the equivalent of the competition tribunal would be the labour court, where you've got a specialist court, which is a court of first instance. So I think that would be the closest equivalent in the legal system. On why these judgments are so long, I would have to plead guilty myself. The two that are before you at the moment are not my decisions. I was on the panel, the one, but I didn't write it, and the other one was decided after my time. I think it's because we not only have to deal with legal issues, we've often got to deal with economic issues. And so as a result of doing an economic analysis, the judgments may take longer than one would like them to take. But because you've got to deal with a number of arguments, we can't dispense with them. Otherwise, people will say, well, you left out this particular issue. I think that over time we may refine them, but you will find that competition judgments of courts of first instance are generally quite long if you were to look around the world for what they are. Once you go on appeal, their points narrow, and so there should be less that has to be decided.
Well, I was hoping you were on a lighter note. I was hoping you were going to come up with something that could ward off the attacks against the Constitutional Court regarding the length of our decisions.
We did that on this side of the table.
We did. Madonsela and I were saying that is very thick coming from the Constitutional Court about the length of judgments.
Thank you very much, Mr. Manuel. You are excused, sir.
Thank you very much, everybody. Thank you. Well.
Good afternoon, Mr. Mbongwe.
Good afternoon, Chief Justice. Good afternoon to the Commission.
I'm almost embarrassed to apologize to you because it has almost become the practice that we keep candidates waiting for too long, but nevertheless, we're sorry.
Apology accepted, Chief Justice.
Yes. How are you?
I'm well, Chief Justice, and how are you?
I'm very well, thank you. You have been an attorney for many years, am I right?
That is correct, 36 years.
Is it 3-6 or 2-6?
3-6.
3-6. And for how many terms have you practiced? Acted, I beg your pardon, as a judge?
Just over 2 years.
Over 2 years.
That is correct.
Very well. I'll leave it there. And colleagues, may I just have the names of those who want to put questions to Mr. Mbongwe?
Any Kane?
Schlemmer.
Bongwe, Mpofu.
Singh.
Thank you very much. JP, over to you, sir.
Thank you very much, Chief Justice. Good afternoon, Mr. Mbongwe.
Good afternoon, JP.
My spreadsheet suggests you've acted for a period of something like 109 weeks.
That is correct.
Okay, I just wanted to clarify the 2 years you gave the CJ. You actually started acting in 2013.
That is correct.
And now and then you've come. You've been before this commission before?
Twice, yes, I have.
Twice already, yeah. Just before I go further about what you've done, I think in your first interview, there were issues that were raised about your temperament and about one judgment that went to the SCA. After your second appearance here, you then went into a cooling period and then you've started coming to act again. Do you think there's a change in the maturity of the Mbongo we see today?
Very much so, very much so.
I can agree. I've been watching you since you've come back. You've done a fair share of your own heavy lifting. I see you've done a whopping 26 weeks in the unopposed motion court.
That is correct.
It's one of the most difficult courts that one can find. And you've done the urgent court work 4 weeks, as well as the opposed motions. You've done 7 weeks.
That is correct.
Right. In the full court appeals that you sat in, did you write any of those full court judgments?
Yes, I have, including including last month, yes, where I was called on short notice to close a gap of a judge that was unable to attend to those matters. I wrote 2 judgments in those 2 full court sittings.
Yes, and you've always been on hand should, especially when you're sitting in the criminal trial court, should your matters not go on for a day or 2, to raise your hand for extra allocations from the DJP.
I've done that.
I see.
That is when I observed that there is particularly the ADJPs. Yeah. My chamber was very close, so I could see the streamline of people that were working. So all I did was to get inside and talk to the clerk and say, tell the DJP that I'm available.
Yeah.
And in that matter, I managed to assist.
Yeah, as a permanent judge, one wants to sit far away from where the JP or the DJP sits. I hope you won't change that attitude of sitting near them, if this commission recommends you. Chief Justice, I've got no further questions for this candidate. Thank you.
Thank you, JP. MEC?
I'm also covered, Chief Justice. Thank you so much.
Thank you very much. Advocate KNSC?
You would have seen there's a review by the GCB, and they detail a number of criticisms from appeal courts against you. In particular, the SCA criticism in the Naidu matter. I presume you're aware of it, and I want to just give you the opportunity to explain what you would do differently if you were in such a case again.
In response to that, I must say that we actually dealt with this matter in the interview. I hope President Maya is listening, because after I'd given the explanation of what transpired, she actually took time. I think the commission on that particular day was chaired by the CJ's previous deputy. She understood what I said. She actually came to say she understood the explanation and accepted my apology. I'm actually surprised that it has come again. In any event, I did say that subsequent to that matter, I had a discussion with the JP and gave him certain undertakings that there wouldn't be any such thing happening. And I'm happy to say the JP has called me to come and act. There has never been a repeat. Otherwise, had there been any complaint, surely the JP would say, I failed to keep my word. No, it has changed me. It has actually, that matter has molded me. The judgment in particular molded me.
Yes, that is indeed what I was hoping to hear from you. Now, similarly, pertaining to the 2016 review, there were apparently at that stage complaints from advocates that you descended into the arena and you refused to listen to argument and be persuaded by judicial precedent. Have you, in your view, have you changed the way that you deal with your matters and the way you deal with counsel since that time?
You know, that came in 2015 interview, and there has never been any complaint after that.
Have you changed the way you?
That's an indication that I had to change, and I changed.
Thank you, Chief Justice.
Thank you, Counsel. Professor?
Thank you, Chief Justice. Sir, I'm to your right. Good afternoon.
Good afternoon.
Would you mind sharing with us your judicial philosophy, please?
Yes. My philosophy is we live in a democracy, constitutional democracy. In whatever matter I preside in, the very first thing that comes to mind is one has to make sure that uphold the rule of law and the Constitution with its Bill of Rights. In a way, it's looking broader at the matter, at the matter beyond the issues themselves, to say that I have to make sure that I'm acting within the confines of these, the Constitution as well as the Bill of Rights.
Thank you. I would just like to come back to the GCB's comments. It seems when I read it that there's a little bit of a concern with some of, well, the knowledge that you sometimes have of particular areas of the law. There's a fairly old reference to prescription, but then there are also more recent references to instances where you were overruled on appeal. And then there's a concern about the fact that it seems that's the impression created, that you're quite reluctant to allow appeals to your judgments. Would you mind to comment on that, please?
Yes. When it comes to appeals, if I've given judgment, the person applies for appeal, for leave to appeal. It's not. I don't think there's a judge who gives each and every application I have given. Unfortunately, I must say, I don't have too many matters where there was an application for leave to appeal. I don't have too many. So it cannot be said to be a tendency. The other question is about knowledge, whether it's questioned. If you look at the judgments that I've written, it's about 80 judgments. You'll pick them, most of them, on safely. It's different aspects of the law. It's matters that are in various aspects of the law. I haven't had a problem of dealing with any single matter that perhaps I did not understand what was happening. That has never happened.
Thank you, CJ. I'm not going to belabor this point. Maybe some of the other commissioners have questions.
Thank you, Prof. Advocate Mbofu, C.
Thank you, CJ. Good afternoon, Mr. Mbongo.
Good afternoon, Advocate Mbofu.
Unjani?
Sapira mfethu unjani?
Nasaphi. Now, okay, my questions are usually long, so I only ask one question. Otherwise, the CJ won't allow me to go on. So I want to ask you about fusion of the sidebar and the bar in particular. But I wanted to start by saying that, you know, in the judiciary, there was a time, as you know, where it was believed that judges should only be drawn from the ranks of senior counsel, and attorneys were not appointed. But I think that since those days, judges like Mlambo, Lidwaba, Mojapelo, Matopo, Sisihampepe, and Daisy Mulife, and other people have long finished that myth off. But as far as the profession is concerned, there is still this division, and there is a belief, I think, or even an air of superiority on the part of advocates, despite the fact that attorneys like you have acquitted themselves on the bench. Do you believe that the struggle for fusion should be carried on or should be abandoned, seeing that those of us who are fusionists lost the battle in the current LPA, when the current LPA was drafted? And what would that do for access to justice if we were to have a fused profession? Assuming you support fusion. If you do, if you don't, of course, you tell us why. Thanks.
I actually do support it. I think the breaking of the barrier between the sidebar and the bar is very important. Actually, it's long overdue. It is correct what you mentioned, that unfortunately we had a situation where you find that members of the bar would sort of look down upon attorneys. And the same thing applies when you start acting as an attorney. You don't get the same respect that an acting person coming from the ranks of advocates get. But with time, settled in the or on the bench as an attorney, people tend to. I guess it has to do with the work. You have to prove yourself that you know what you're doing. Only then do people sort of accord you some respect.
Thank you, Chief Justice.
Thank you very much, Honorable Singh.
Thank you very much, Chief Justice. Good afternoon, Mr. Mbongwe. Buisa. How are you this afternoon, Mr. Mbongwe?
I'm very well, Commissioner Singh.
Good.
I'm glad that you called me with my clan name. Huh?
Yes, no, I know most of them. Yeah, you know, I'm a Zulu boy. Chief Justice knows that. Mfana KwaZulu. Mr. Mbuisa, I note that you have gained some experience and exposed to commercial matters and litigation when you had merged and practiced as a partner at Moody and Robertson Attorneys.
That's correct.
You held your own company, and then for 18 or 19 or 20 months you merged, and then you went back to your own firm. Just a bit of history of what caused that merge and then go back to your own company. Thank you.
Yes. When I wouldn't really say what caused the merger, I was approached if I was willing to merge with the firm. To me, it proved to be an opportunity to be exposed to a wider range of legal work. When it comes to the separation, it was a different thing. I actually, from the beginning, drove towards the goal of introducing more Black people. I was one Black partner amongst 10. There was resistance at some point, despite the fact that we agreed initially. So I wasn't really happy. And furthermore, we had a big client of us, which was the city of Johannesburg, pulling work from smaller firms where you find that juniors who are looking up to you come to you and say, but by being part of that, you are depriving us of the opportunity to get work. And it really sticks. The fact that my goal could not really succeed of bringing more people. Ultimately, I decided I cannot push it any further, and I decided to reconstitute my firm.
No, thank you very much. A very good reason. I mean, 12 years into democracy and people were doing that just to use others, as a stepping stone for themselves. I'll leave it at that. Thank you.
Thank you.
Thank you. Thank you very much, Mr. Mbongwe. You're excused.
Thank you, Chief Justice.
The candidate is ready, Chief Justice.
Thank you very much, Judge President. Good afternoon, Mr. Miller.
Good afternoon, Chief Justice, members of the Commission.
Are you well, sir?
I'm very well, thank you, Chief Justice, and yourself?
I'm very well, thank you. You've been an attorney for about 27 years, am I mistaken?
26 years this year, Chief Justice.
26 years.
I'm flowing into my 27th.
Oh, yes, oh, yes. And I take it was, or it is a busy practice.
Yes, we keep ourselves busy, and there's always things to be done. An attorney's job is never done. There's always things to keep you occupied and keep you moving forward.
And I take it you are here because you believe that experience, together with your acting stint as a judge, have prepared you for the position of High Court judge.
Yes, Chief Justice. I believe that the cumulative experience I've gained in my practice as an attorney, and also the opportunity that I've been given to act, has prepared me where I believe that I would be able to acquit myself and discharge my duty as a High Court judge if appointed.
Thank you. Colleagues, may I have the names of those who have questions for Mr. Miller?
Nyambi.
Matolo Lepu.
Jenny Kane.
Dodovu.
Schlemmer.
Mpofu.
Leo.
Wanawan.
Sigogo.
Matonzel.
Tepeche.
JP, over to you.
Thank you very much, Chief Justice. Mr. Miller, good afternoon.
Good afternoon, JP.
Yeah, the Chief Justice covered part of my questioning, but your acting judge work allocation spreadsheet tells me you've acted for a total of 76 weeks.
Yes, sir.
And it spans a period from 2017 to date.
That's correct.
But what other candidates don't match with you is that you've had a solid 8 weeks in the urgent court.
Yes, Chief Justice.
No, sorry. I don't want to get into
sorry,
trouble.
JP.
Thank you. and you've also had a solid 8 weeks in the opposed motion court.
Yes, JP.
You've also spent a full term doing criminal trials.
Yes.
Right. Have you had any problems with any of your allocated work areas, sitting in the urgent court, opposed motions, or special motions?
JP, not at all. I've found that I've been able to cope with the work that's been allocated to me, and the work's been done timelessly.
Yeah. And in terms of your judgments that you've handed down, you've got the spreadsheet that the commissioners have, and your trend is not to reserve for longer than 3 months. In fact, it's very quick. Within a month or two, all your judgments are out.
Yes, JP.
Have you had judgments that you had to deliver beyond 3 months?
No, JP, nothing beyond 3 months. There was one matter where it was a full court appeal, which I think was delayed slightly because there were other parties involved, but not that I've penned personally and solely.
Yes. Well, we know the hazards of sitting in a full court appeal. It's not only you're sitting with others, isn't it?
Correct.
Yeah. Thank you very much, Chief Justice. Sorry, but the way you've behaved, written your judgments, handed them down, and the time you've given acting, you feel it's prepared you very well for a permanent appointment.
Yes, Judge President, I believe that I'm as prepared as I can be, and that if appointed, I would acquit myself, and that the Commission's confidence in me would be justified.
Yeah, this is the second time you come before this Commission.
Yes, Judge President.
Thank you. Thank you very much, Chief Justice.
Thank you, Honorable JP. Honorable MEC.
The MEC has stepped out, CJ.
All right. Honorable Nyambi.
Thank you, CJ. Afternoon, Mr. Miller.
Good afternoon, Mr. Nyambi.
You are known to have championed lower legal cost of your clients. What are the demographics of your clients, and how have your actions contributed to access to justice?
Mr. Nyambi, the vast majority of the clients that I represented in respect of the legal cost issue were clients from disadvantaged backgrounds. Persons who placed their hands or their lives in the hands of legal practitioners who were going to obtain redress from them, whether road accident fund cases or cases against the MEC in respect of birth injury claims. Across the board, all of them without exception were very big claims. And unfortunately, there are those instances where practitioners don't do things according to the law, and it results often in serious overcharging. We've recovered in many cases, we recovered for those clients millions of rands. In individual cases, the amounts in some cases were in excess of 2.5 million rand recovery in respect of the legal fees component only. So it's important for access because the public need to have confidence in the legal process. They need to understand that when you go to a lawyer, it is someone you can trust, somebody that is going to look out for your interest. Yes, the lawyer must be paid for the work he does. It's important. We're all trying to make a living, and they must be fairly compensated. But there's certainly no right, because your client is in a particularly vulnerable position or doesn't have the knowledge or experience that you as the lawyer have, for you to then exploit that person. It's a form of exploitation, and it can't be permitted. So I believe that in the work that I did, besides helping my individual clients, it helped to send a message to the wider legal profession, but also to clients, that if you're unhappy and there is an issue you have with the legal practitioner, there are other legal practitioners who will come to your assistance. It's not a closed shop or a situation where once something has happened to you, you're now left with no recourse. So I believe in the publicity that attached to those cases, because many of them did have publicity, set the word out amongst the general population, particularly those who were in that situation, and then empowered them to come forward, whether to myself or to many other legal practitioners who were prepared to do those cases, and to then assert their rights. And if you look at the case, the judgments that have been handed down, you can see across the provinces there's an increase in those types of judgments. So I think I'm quite proud of the role I played in being able to put that aspect of the legal profession on show to the public so that they would be aware that, in fact, we're not a closed shop. We're actually here to serve the public.
No, I commend you for that good work. Besides the issue of the cost, what else poses the biggest challenge when it comes to the issue of access to justice?
Well, I think the biggest issue is knowledge of rights. Many of the people in our communities don't know what their rights are. And that's the cause of that may be a combination of things. Laws that are complex and that aren't easily understandable by people, but also the availability of legal practitioners. I believe that we really need a profession that extends and expands across the entire country, so that wherever someone finds themselves, they're able to access a lawyer and then be able to explain their situation and then assert their rights. So it's an issue for the future, and it's an ongoing and developmental issue. We have a resource challenge within our country, both physical resources, but also knowledge resources. We're building and we're developing. And as we build and we develop, that will then roll out, and there'll be a wider awareness of rights and a wider take-up of the implementation of those rights.
Thank you, Mr. Miller. Thank you, CJ.
Thank you, Mr. Nyambi.
Thank you, Honorable Nyambi. Commissioner Matolo Zepu.
Thank you, CJ, and good afternoon, Mr. Miller.
Good afternoon, Commissioner Dlepu, or should I say Chair.
I have to declare that I've known Mr. Miller for quite some time. Him being a member of the BLA, and also he's a present council member of the Legal Practice Council, which I'm chairing. So don't forget, I'm not chair here. Okay. So what I want to I know we have been together for some time fighting for transformation of the profession. And now I'm quite worried that we are about to jump ship when we haven't gotten to finish, the race. But with your in-depth knowledge of transformation of the profession, can you just maybe briefly just tell the Commission what are the 3 challenges that we are facing in trying to transform?
Yes, thank you, Commissioner Dlepu. I think the challenge with the transformation of the profession is really the first challenge I would say is integrating the 2 arms of the profession, the bar and the attorney's profession. Previously, they were regulated separately, one under the Admission of Advocates Act, the other under the Attorneys Act. The Legal Practice Act brings us together to a single regulator. And that's on paper and now in practice a single regulator, but we still have 2 separate fields of endeavor within this unitary legal profession that we share. And it's bringing 2 different bodies, 2 different fields of endeavor, really working towards the same goal and the same outcome into a single regulator with a single regulatory culture, but also to create an environment where the particular needs and demands of the individual components can be met within that context. And I think that is where the first challenge comes. The attorney's profession was taken by statute. There was no choice. I think if there had been, we wouldn't be sitting with the Legal Practice Council. We'd be negotiating for another 100 years probably. It was taken by force, and I think that was correct. The advocate's profession wasn't taken by force, and I think one must understand that the advocate's profession has been through successively oppressive regimes. It's an old institution. It's got to find itself and bring itself within the framework of the LPC. It's taking a little longer than one would have liked, but I think there's very good progress being made in that direction, and I'm hopeful that eventually we're going to have a situation where we have a single regulator, but sensitive to and accommodative of the needs of the individual fields of endeavor. We need advocates, we need professional advocates, we need attorneys. They do different work, and they're really two halves of the same, or two sides of the same coin. They need to coexist and to work together, not work separately, and pull in different directions. If they pull in the same direction, I think what we will achieve and what we'll see will be far greater. So that's the first challenge that I see. The second challenge is allied to the first challenge, which is really when information and the coordination will take place. We see, for example, that the LPC has taken great steps and great strides towards expanding access to pupillage and to empowering prospective pupils through the stipends that have been arranged with CECITA, so that those who come from backgrounds where they wouldn't have afforded it beforehand will be able to do pupillage. So we see moves in those directions, but that's the bigger picture of what is being done. But it's still happening within the framework of the established bar councils, all 14 of them for the individual divisions of the High Court. But then there are also bar councils that are outside what's considered to be the established bar councils, and about 25% of the total number of candidates who are, or practitioners who are registered as advocates, don't fall within what's considered to be the traditional bar. So it's a case of it's trying to bring them together as their profession, so that they can also then be regulated and be coordinated in order to move more, to move forward. The third challenge is I think an economic one that we face, and it relates to things like briefing patterns and access to work. And at the moment, we are in the process of addressing that as the Legal Practice Council. Yourself and other members of the council and many of the esteemed council present here are aware of the steps that are being taken to regularize the profession within the economic framework that synchronizes with government, so that the profession as a whole, but the individual components can then work with each other and with government in order to move forward to transform. And I'm referring specifically to the development of a legal sector code, which is going to provide a specific framework within which that can be done. Until now, it's been voluntary. And we've seen after 25 years that voluntary steps only go so far. Very often, you need to be pushed. And I think that's true of us as people, but perhaps professions also, that sometimes the fear of the unknown is really what is holding things back. Not necessarily that what will eventuate is going to be a problem. It's just the uncertainty. So I think we're on the cusp of addressing particularly that concern, and I believe that those issues will play themselves out, and the parties involved are parties of goodwill. They give their honest opinions. It's debated honestly and openly and robustly, and on that basis, I believe that the challenges that are there are going to be overcome.
Okay, thank you, Mr. Miller, and thank you, CJ.
Thank you.
Thank you, Commissioner. Advocate KNSC.
Thank you, Chief Justice. Good afternoon, Mr. Miller.
Good afternoon.
I need you to please assist me in relation to this concern. On a review of your judgments, there's a distinction drawn between the area of expertise, the road accident fund work, and other types of judgments. And the distinction is, as I understand it, that in your RAF matters, your judgments do demonstrate sound reasoning. And in the other areas of law, there's a qualitative difference, and that sometimes it's being picked up that you lead to conclusions without a rational process that the reader of your judgments is capable of following and understanding. Could you address that concern, please?
Yes, thank you, Commissioner Kane. I think let me start first with the issue of the road accident fund cases. Yes, I have extensive experience in that area of work. It's quite a massive area of work that dominates all the courts in the Republic. I read an article a few days ago in which the Chief Executive Officer of the Road Accident Fund, Mr. Collins Letswalo, remarked that there are presently 189,000 road accident fund cases before the court. Now, yes, that is an important area of work. There are presumably 189,000 South Africans who are looking to receive compensation. One can accept that all of them have either suffered injuries or have lost loved ones, because that is the basis on which one approaches the road accident fund for compensation. So yes, that is an important area of work. It's absolutely essential that our courts address it, and with the particular challenges that go with it. So I appreciate your compliment in regard to the judgments that have been written in regard to those matters. I regard them as very important and affecting the lives of individuals very profoundly and very directly. In regard to the judgments, the other judgments, the criticism leveled by the General Counsel of the Bar focused on two matters. The SM versus AB matter, which was a matter involving a mother and daughter who sought an interdict to prevent the distribution of very private communications between each other and communications they had with third parties. They sought to interdict that. That information had been obtained by the ex-husband and was being used to maneuver and it was being used against their interest. I've set out the reasons, specifically what happened in the matter in the judgment. So there's that matter where one criticism was raised. In that matter, I referred specifically to the rights to dignity and the rights to privacy and the best interests of not only the lady concerned, but her child. And the second matter is the Lekwa matter. You'll forgive me if I just deal with both, but there's a common thread for both, which I will deal with afterwards. Was the Lekwa matter, which were special allocations. It was two urgent applications, and this is really the point. The SM matter was also an urgent application. Two urgent applications that were brought by communities to interdict the limitation of electricity supply by Eskom. The cases, as made out, demonstrated profound and very serious consequences as a result of the limiting of the electricity supply, the switching off of the water reticulation, that's the sewerage, hospitals being affected, emergency services, and so on. Both of those matters were dealt with as urgent applications. They weren't dealt with as armchair cases, if I can put it that way, and no disrespect to any other type of case. But I didn't have the luxury of a week or 2 weeks or 3 weeks to sit back and research and decide and pen and craft a judgment for posterity. There was a very...
Yes, thank you. In fact, you fully satisfied me, so I'm going to stop you. I do really understand the distinction that you've drawn between armchair positions and urgent court.
Yes.
If I could just ask you one more question, please, on a different topic.
Yes, Ms. Kane.
You've expressed views in relation to the unification of the profession, and I know you hold strong views in that regard. Could you explain to me how attorneys' firms that don't necessarily have in-house experience in an area of law would get the benefit of a separate referral profession where the cab rank rule applies and they're able to avail themselves of a leading practitioner at the bar to deal with a particular case and still retain that client, even though they may be a small firm, a rural firm. How do you dispense with that advantage that is currently available to such attorneys?
Yes.
If you could just
Yes, Ms. Kane, I think
give
perhaps...
me a short answer on that question, please.
Yes, I think perhaps we're at cross purposes on that question, because I'm not advocating the abolition of the bar as a part of the profession. You'll recall earlier I've said that the bar as an institution or as a field of endeavor is essential to the functioning of the legal system. The attorneys get the work and will be the interface with the client, and the advocates with their particular areas of proficiency and speciality are then available on the basis of a cab rank rule to be briefed and to render the services to those clients. So it's absolutely essential that we maintain both parts of, or both fields of endeavor. The challenge isn't, and the issue isn't to abolish the practice of advocacy as a distinct part of the legal profession. The challenge is to bring it within the ambit of a single unit, a single regulatory profession, and a single vision of the profession as to what is going to be achieved. So I'm certainly not advocating, and I've never advocated for the abolition of advocacy. I think it would be self-destructive to the practices of attorneys, and it would certainly not be in the interests of the public at large, who rely on our eminent and very senior and competent counsel to get up and argue for their rights. So
thank you very much. No, you have answered my question. I'm cutting you short solely because of our time pressures and not because I'm finding your answers of immense interest. Thank you. Thank you, CJ.
Thank you, Ms. Kane.
Thank you. Thank you.
CJ.
Is that Commissioner Sigogo?
Yes, CJ.
Please go ahead, sir.
Good afternoon, Mr. Miller.
Good afternoon.
How are you?
Mr. Sigogo, I'm well. How are you?
I'm good, thank you. You indicated that you had the CEO of the RAF that their matters in court are about 189,000 countrywide. Will you agree with me that if a specific field of law can occupy our courts with such number of cases, we also need judges who specialize in that field in order to deal with such cases?
Yes, Mr. Sigogo, I agree, and I think it's essential. Road accident fund cases are not simple cases. There tends to be an impression that it's simply a matter of filling in forms and sending forms in. But the cases are often very complicated and complex. They involve matters relating to engineering, relating to motor vehicles, and the specific mechanism of what has happened to cause the collision. And once liability is established, then one has to deal also now with medical aspects. It's not that the attorneys or the advocates that are dealing with those matters are themselves medical practitioners, but they need to have a sufficient understanding to know the direction for the preparation of the cases and how things need to be done. With that, with knowledge of those things, very often one is able to get to the issue a little quicker and to facilitate either a resolution of whatever the issues may have been between the parties, or to then deliver a judgment that deals pertinently with what was in issue without taking court time to hear extraneous and unnecessary evidence, because you have the knowledge and experience to see exactly where the issue is. So I think it is important to have practitioners and judges with that experience.
CJ, with your permission, if I may ask my question so that I may forego my space later on.
Please go ahead, sir.
Thank you. Will you tell this commission, as a white man, why did you see value in participating in the transformation of the legal profession, particularly playing role in the Black Lawyers Association, the Law Society of Northern Provinces, Legal Practitioners Fidelity Fund, as well as the Legal Practice Council?
Thank you, Commissioner Sigogo. At a very early stage in my career, I've always held the views that I have now. My views haven't changed. And it became apparent to me quite early on that the home for my views, because those were my views, was the Black Lawyers Association. And so I joined the Black Lawyers Association because I subscribed to the values and the principles in the Constitution, and that is who I am. And that is the path that I chose. The organized attorneys profession at the time hadn't yet caught up. It was just post 1995. It was still catching up. It was taking steps. It was moving, but it wasn't moving at the pace that I thought it ought to have moved. I was still a very junior practitioner in those days. So my home was the Black Lawyers Association. As time passed and I gained experience, and I suppose it happens with all practitioners, that with time and experience, one's confidence grows and one becomes a little more outspoken with one's views. I then started to move forward, and the Commission will recall the last time I appeared here, I did give an indication of what had happened with regards to the then Law Society of the Northern Provinces. That for 20 years they'd had no election, there were bottlenecks, things were not happening, and the component, because of the structure at the time, that wasn't having an election was what one would call the white component, the non-BLA, non-NADEL component, which on the face of it really had nothing to do with me because I was part of BLA. BLA held regular elections. I voted for my candidates when we had elections and took part in the process. And so my voice was heard through the BLA on that council. But when the opportunity arose, the then president said to me, after having called for the election, I initially called for the election and I wasn't going to put myself forward, but the then president, after the members voted for an election, Mr. Mabunda, said to me, well, you've done all this hard work, don't you want to stand for the election? And I mentioned to him that I was prohibited from standing for election by virtue of my membership of the BLA. So it'll give the Commission some idea of how far the attorney's profession has come, that once you had put your colors to the BLA mast, you were on the outside of those people. You weren't part of them, and you couldn't even stand for election amongst them. And so what happened was, I was asked by Mr. Mabunda, would I be interested in standing for election, because he felt that I would be able to help bring our shared values to the council if successful. And I agreed to do so. And I mentioned the last time, and I think it's an important thing for me to say, that I specifically recorded in my letter of resignation from the BLA that I was not resigning for any reason other than the fact that I was being asked to undertake this task in the wider interest of not only the organization, but the profession. So that's what I did. And as things worked out, I then found myself at the Law Society of the Northern Provinces as its president. So I then became the president of the Law Society with a new council reconstituted on the white side. The BLA and NADEL colleagues were still there. But now we had a very different situation because we had a majority on the council who now shared a vision of actually getting things moving forward. And we started to then do things within the scope of our powers that were governed by a statute to make things happen and make things move forward. And I think we made a lot of progress in the relatively short period of time that we had. One lament which I have, and Mr. Sigogo knows that I previously mentioned this not only to himself but to other members, is that we didn't reach that situation 15 years earlier, because who knows where we would have been by 2015. But that, as I said, is a question of the passage of time, and one's maturity and one's experience with these things. So once I was on or was the president of the Law Society of the Northern Provinces, as part of what we were doing, we reactivated the Transformation Committee, which had been a dormant committee because no one had really been interested in getting things moving. So we reactivated the committee and tried to take steps to get projects moving forward. I gave a lot of attention to the pro bono department. It was a very small department which I tried to have elevated into being a fully fledged department because it was doing essential work primarily to those from disadvantaged circumstances. So we tried to expand that. We weren't successful in getting agreement to actually make it a fully fledged department, but it was still a very important unit of the LSNP, the Law Society of the Northern Provinces. So we managed to achieve that. I also took up a seat on the Law Society of South Africa in my capacity as the president, and was now exposed to the wider attorneys profession, not just for Northern Provinces, which was where I'd been elected, but now nationally. So now I had exposure and interaction with colleagues across the spectrum, and found many who shared the same views that I did and who were moving towards and wanting to move towards the same shared common vision of a transformed profession where...
Sorry, Mr.
Yes.
Miller, I know it's a lot that you can say on this topic because you indeed played a role, but I think I should cut you here so that for the benefit of time, and I believe other councillors will engage you on similar topic.
Yes.
Thank you, CJ.
Thank you, Mr. Sigogo.
Thank you, Commissioner Sigogo. Honorable Dodovu.
Thank you, CJ. Good afternoon, Mr. Miller.
Good afternoon, Mr. Dodovu.
18 months ago, you were here applying for the similar position. Not that you were a bad candidate, but I think we were spoiled for choice. We had very, very good candidates appearing before us, and we had to make a decision. And this time around, you are here. What is it that is exceptionally good about you when we compare to 2019? Or just give us something that will make you outstanding, better candidate for selection. Yes.
Yes.
In short, yes.
Yes, Mr. Dodovu, I bring a lifetime commitment to improving not only the lot of the general public of South Africa, the people who need it, but also to the legal profession. I bring my energy, my commitment, and my passion to see that happen. That is what I bring. I work hard. I think that JP's got the statistics. I deliver judgments timelessly. I'm very conscious of the fact that litigants need to know what the outcome of their cases is. It's an integral part of access to justice, is to know the outcome of your case. It cannot be that you must wait extended periods of time. You've already waited an extended period of time to get to court. Now you must wait in a further period of time. So I bring a passion for service delivery, for wanting to ensure that the rights of the people of South Africa are properly looked after and properly represented.
Thank you very much. My second question, I read your judgment of 2018 on Ngobo versus the Minister of Police about unlawful arrest and unlawful detention. Does it follow, in your view, does it follow that when the arrest is unlawful, therefore the detention will be unlawful?
I see it slightly differently because each level of government has its own responsibilities. We're all bound by the principles of Batopele. So when the policeman exercises a power to arrest, if it's unlawful, then once it comes before the court, the prosecutor must look at the matter and see is this person properly arrested? It cannot be that one person takes an action and everyone else is absolved and doesn't bear any responsibility. At each level, responsibilities must be exercised. And so that is my view. I don't recall the specific case you're referring to. Perhaps you can refresh my memory. Is it the case where there was a warrant for arrest, but then the prosecutor, yes.
And you found a prosecutor, I think, involved liable for
yes,
for damages.
Yes, in that particular case, the warrant of arrest, there in fact had been a warrant of arrest issued by a magistrate. So the question of the legality of the arrest wasn't an issue. It was a question of what happened after the man was deposited at the police station, or once the man came before the court, and the prosecutor now had the evidence in front of him, and it didn't bear scrutiny. And by the time the criminal case had come to an end, the prosecutor in that case actually conceded to the court that there had never been any basis to detain or prosecute Mr. Ngobo. And on that basis, the prosecution must bear responsibility because the continued detention was no longer at the instance of the police.
No, thank you. I heard you. Thank you, CJ.
Thank you.
Thank you, Honorable Dovu. Prof.
Thank you, Chief Justice. Good afternoon,
Good
sir.
afternoon, Professor.
Mr. Miller, I have one serious question that I want to put to you, and that relates to the criticism that the GCB has made to the lack of judicial reasoning in your judgments, and also linked up now to your answer to the Commissioner Dodozu when he asked you what you would bring to the bench. And your main focus was your contribution to the legal profession and the society. I didn't hear anything about your contribution to the development of the law, or the fact that since we have, and I didn't expect you to say that out loud, the fact that we have an unwritten, uncodified system, that it is very important for judges when they write their judgments that people are able to glean the legal principles and that everyone can understand where our law is going to as well. Would you mind talking to us about that, please?
Professor, the two matters that the GCB specifically spoke to and raised criticism were both urgent applications. So I think Ms. Kane accepted the explanation that there was a time factor in those matters. The vast majority of cases that I've had the privilege of hearing haven't been cases that are legally of a nature where the law is going to be developed. The vast majority of cases seem to be cases where the principles are settled. And it's an application of the settled principles. People must know what the outcome, what was considered and what the outcome of the case is. The judgments are written for the litigants. That's really my focus, because that was my experience, is that the litigants want to know. I have a difficulty if one has to craft a judgment that now requires the litigant to go and pay someone to explain to them what's just happened to something that, pardon me, which could affect their life. So yes, I think it goes without saying, one would want to contribute where appropriate cases came before one that required deep consideration and development of the law and the legal principles. One would bring that mind to bear and would bring dedication to ensure that that was done. But that hasn't been the type of case that I've had. And one doesn't get to choose what cases one has. One really deals with what is there and must discharge one's duty with what is there. I don't think the criticism is a fair one. And I say the criticism is not a fair one because, and I did look at it seriously when I saw the comment of the GCB. Of the 120 judgments that I've delivered, 48 of them have been reported by JUTA in their online law report offering. That's 40%. And I think I can accept that if we speak about individual judgments, I'll be able to address what happened or what the time constraints were or what informed the approach. But as a general proposition, I think if JUTA, without any input from me, has picked up 40% of them and published them in their online offering, I think, then that's a factor which I think ought to be considered as well.
And just to follow up, CJ, are you referring to the SAFLI and
No, not
to
SAFLI.
SAFLI?
Not SAFLI. SAFLI is a platform which is partially sponsored by the Legal Practice Council, which collates every single judgment handed down in every single court. It's a simple database where everything is put. The JUTA publication is a private publication. JUTA are the you know who JUTA are. They publish the blue books and the bound books that clients often see in lawyers' offices. So they're a private publisher. They aren't a
No.
free
I
service.
understand that. The reason why I'm asking this question is just because some of the candidates that came before you said only judgment that are requested are put on SAFLI and then don't automatically end up there. So, but you don't have to answer
Well,
to that.
I can perhaps amplify. The judge president will know that there's a directive that when you hand down a written judgment, your secretary is you're required to send not only the Word format of the document to your secretary, but also the signed PDF document, the scanned document. And your secretary then sends both of those to the library. So that is the practice in both Pretoria and Johannesburg where I've acted. And every time I've authored and penned a judgment or handed down a judgment, that has been the procedure I've followed. So that ought to happen. I did understand that there were some snags in the libraries with the uploading of the documents. So at times it looks as though there's very few judgments from a particular division, and then you look 3 weeks later and you can't believe how many others have been added because they've now caught up with the uploading. But SAFLI is simply a database of all judgments that have been delivered.
Thank you, Chief Justice.
Thank you, Professor.
Thank you, Prof. Honorable MEC.
No, thanks, Chief Justice. I'm covered. Thank you so much.
Thank you very much. Advocate Mbofesi.
Thank you, CJ. I'm covered too. Thank you.
Thank you. Honorable JP Leo.
Thank you, Chief Justice. Good afternoon, Mr. Miller.
Good afternoon, JP.
Yes, I don't know whether you have seen the a letter written by Mr. Ronald Bobrov, dated the 8th of March 2021.
Yes.
It's a bulky document. Do you have a comment with regard to that?
Yes, JP. Earlier on, I spoke about my work on behalf of clients to recover fees that had been overreached from them. A great deal of that work was in cases where those clients brought actions against Mr. Ronald Bobrov. There are numerous judgments which can be found on SAFLI and reported judgments dealing with those specific cases and the circumstances relating to what happened there. In every instance, I acted on behalf of clients in matters which came before the court and which were decided by the court. For some reason, Mr. Bobrov, who has since been struck off and has fled to Australia to avoid arrest, has embarked on a campaign of vilification. He writes letters which, with all due respect, JP, I have read that letter. It is bizarre in the allegations that it makes. It's more suited for Ripley's Believe It or Not, a TV program, than it is for reality, because it doesn't withstand the scrutiny of the judgments of our court, which deal with the misdeeds of Mr. Bobrov and his son. The letter is written it's written out of spite. It's written with malice. It bears no relation to reality, and it would be my submission that this commission would dismiss that letter as being of no consequence. I might mention that there are a number of persons in the room who've been party to cases dealing with Mr. Bobrov, from the Constitutional Court to the Gauteng Court, and even counsel present who've also consulted with me and acted in matters pertaining to the conduct. So I don't want to go any further. Perhaps I can leave you with this, that the Supreme Court of Appeal is presently there's a judgment awaited from the Supreme Court of Appeal which deals with many of the things that have been said, it pertains to an order obtained by the Asset Forfeiture Unit for the forfeiture of 100 million rand that was moved to a foreign country by Mr. Bobroff.
Yes, can I make a follow-up? Are you saying then, despite the fact that these allegations came from Mr. Bobroff, who is a fugitive from justice, that as a result of that, the Legal Practice Council did not deem it necessary to look into some of the issues that are raised in that complaint?
JP, all these issues that are raised were raised previously over many years. These aren't recent allegations. Everything in that letter predates the Legal Practice Council's existence. It all relates to things that happened from about 2011 or 2012 onwards. And during that period, Mr. Bobroff and his son were in the Republic. They were operating a law firm. They lodged complaints. They were dealt with by the proper structures and dealt with properly by the Law Society. Not once did they ever institute action in respect of any of those things. It has absolutely no basis in fact or in law, and I really can't take it any further than expressing that view of it.
Thank you.
Yeah, I can't make out my handwriting.
It could be me, Chief Justice. I'm covered.
Yeah, and it's you. Now I see it's you. Yes. Commissioner, thank you, sir. Commissioner, is there a follow-up?
No, CJ, it's me.
It's your turn.
Yes.
It's your turn.
And
I thought I heard the voice.
Chief Justice, I have follow-up. It's Barnard.
Oh, yes. And I had skipped you by mistake. Over to you, Commissioner Barnard.
Chief Justice, the question I want to ask, I will still ask when you give me an opportunity, but I'll follow up on what has just been discussed, if I may.
I think do everything then.
All right, so let's start with that question then, Mr. Miller, just before we get back to that. You also do some valuable work involved in the small claims court. Perhaps you could tell the Commission about that. The Randburg Small Claims Court, I believe, is quite an active court.
Yes, thank you, Commissioner Barnard. I've served in the Randburg Small Claims Court for 18 years. And 10 of the years until this year passed, I served as the convener of every small claims court has a minister or an advisory board, which sends input to the minister relating to the operations of the court so as to facilitate the smooth running of that court. It's a very busy court, and I'm proud to say that I think I've made a good contribution with the other commissioners who sit there and who serve with me on that advisory board. We've been able to really ensure access to justice for those who can least afford it. We've made accommodations, and we've organized the court in a way to accommodate those who don't have access to private transport and various other things. Commissioner Barnard, you'll know that a number of years ago, we did discuss this issue of the small claims court in the context of the app that you were developing for free distribution to the public to empower access to the small claims court. So I think it's really the first port of call for those who have the least means, and it's their first experience of justice without having to put their hands in their pockets or to go and ask for assistance somewhere else. It's absolutely crucial and essential, and I'm proud to have served there for 18 years and to have helped to bring conclusion to the matters that came before me there.
Thank you. That also just reminds me to disclose that we did serve together on the LSSA for a period while you were there as well. Maybe just for the benefit of the Commission's knowledge. I'd like to, and as far as the Chief Justice will indulge me, just raise a couple of the specific issues in the interests of transparency that are raised by the Bobroff letter. And if you can please give brief answers on those, or if you feel you need to expand. First one is, there seems to be an allegation that your practice address is no longer accessible to someone who tries to contact it. Files have been handed over to I think I saw the name Volmerant somewhere in the document, or Volmerant's attorneys. And so that's the first question. If you can maybe just, apparently they've phoned and there's been no answer to practice, etc.
Yes, well, after COVID, my partner, who's reached the age of 83, decided he wanted to retire, and a decision was taken to downscale and reorder the practice. I did see in the letter that Mr. Bobroff had obviously sent someone to our prior business address and was most concerned about the to-let sign. Those were business premises. We've moved. The Legal Practice Council has been notified of the new address as is required by the regulations, and I really can't explain why the Legal Practice Council wouldn't have given the new address to Mr. Bobroff. He would have to amplify upon that. But compliance with the Act and regulations, I serve on the council. You can take poison on the fact that we are fully compliant.
Thank you. I'll move on. The next one is an allegation of touting, and there are a whole number of touting allegations. And the thread seems to be that there was a person by the name of Jabu, yes, who worked for your firm and then touted or solicited work to the practice.
Yes, that's absolutely false and untrue. Mr. Bobroff at the time corralled a group of clients who ostensibly made those complaints. We came to the Law Society for a hearing. The clients were there. Mr. Barnard, I'll just mention, because it's important in the context of this question for the commissioners who've read it, Mr. Bobroff sent an advocate and an attorney to come and listen to the hearing. And when they were asked by the panel, what is your capacity? Why are you here? They said they were there as observers. And the panel said, but this isn't a public proceeding. The complainants can be heard and the attorneys can be heard, but you cannot be here as observers. Are you representing the complainants? They said no. And on that basis, the panel excused them, said it wasn't a public proceeding. And the rules of the then Law Society didn't provide for a public hearing. Once the hearings got underway, the evidence was from the ladies and gentlemen who testified. They said, where is my money? I still remember the vernacular term that was used, because each one said it. Ufuna imali nyami. And the panel then said, "What? But why?" And when they were questioned, it then came out that every letter of complaint had been written by Mr. Bobroff's clerk, and that they'd simply affixed their signatures and been told, just sign this document and come here and you will get money. So when they sat down, they said, well, we're here, we want our money. Then the panel questioned them, and I was there, and I also had the opportunity to question them, and we dealt with the individual allegations that were made. And they said, but that's not true. And we never said that. And we never wrote that statement. And they pointed to the man concerned and said, he wrote the statement. And at the conclusion of the hearing, he was then brought into the hearing and he was questioned, and he conceded that on the instructions of Mr. Bobroff, he had done it. The context of that complaint and that situation was a full bench hearing in a case which declared the use of so-called percentage common law contingency fee agreements invalid and illegal. In other words, what was happening was a concerted effort to stop me from bringing the case to court, which would put an end to the gravy train that Mr. Bobroff and many others like him were riding. And that is what happened. The issues were fully ventilated. There is a transcript at the Law Society. It bears out everything I've said. And interestingly enough, this was in 2013 or somewhere around there. Nothing ever further was done about it or ever came of it. It's raised only in terrorem to try and improperly influence this commission.
Thank you. The use of unlawful contingency fee agreements, various clients are mentioned, various agreements, but the question is, you being aware of contingency fee agreements and the statutory requirements. Have you ever used an unlawful contingency fee agreement with clients?
No, not ever. I would never do it. It's immoral. It's reprehensible. My views on it are very well known, and I stand by those views. Till the day I die, I'll stand by those views.
Thank you. And then on the circumstances of the election that you referred to, did you disclose to the colleagues at the time of the election that you had resigned the previous evening from the BLA?
I was asked at the meeting, which took place in order to hold the election. I put forward the resolutions. It was a special meeting of the Law Society, and I was asked specifically in the meeting, are you a member of the BLA? And having resigned shortly before midnight the night before, I said correctly, I am not a member of the BLA as I stand here. The minutes of that meeting are also available. And that was correct. I was not a member of the BLA on that day.
But I think the question is, did you disclose to them that you had been until the previous day?
It was common knowledge that I was a member. It was common knowledge. It wasn't an issue. The right to call for the election and so on was open to all members. The statute and the way the profession had been structured wasn't the difficulty. It was the voting that was the difficulty, because the special resolution called for a vote of the so-called statutory or white component. It didn't relate, so anyone could have called for the election. It didn't matter whether you were a BLA member, a NADEL member, or a member of no organization. But once it became an issue as to the voting, yes, there it was an issue, and those are the circumstances under which it happened. I can assure you, Mr. Barnard, if there was anything impeachable that happened, I have no doubt that those that tried to prevent the holding of the election would have taken steps to raise it and would have done it. Everything was done absolutely above board and according to law.
Thank you. And I'm almost done, Chief Justice. I may just have one or two more questions with your permission.
Go ahead, Commissioner Barnard.
Thank you, Chief Justice. Mr. Miller, have you ever tried to block any complaint that was laid at the former office or the former Law Society of the Northern Provinces? Have you ever tried to quash any claim that had been lodged there by anybody for that matter?
As the president of the Law Society and a member of the council, I had nothing to do whatsoever with the administration, other than to see that the staff were empowered to do their work and to then take decisions according to law. I've never been involved in such a thing, and I would never do such a thing. I think the way in which I've addressed this and my reputation is that if there's something to be dealt with, I meet it head on. I have no need to quash things or hide things. I will deal with whatever is put before me head on, and that is the basis for it. So absolutely not.
And my last question then is as far as information obtained from the offices of Mr. Bobroff, there's an allegation seems to be that there was almost a clandestine flow of information from one of Mr. Bobroff's staff members out to someone that's mentioned, and then it was passed on to you, and then your firm used it for gain of your firm. Is there any
absolutely untrue? Every client who instructed me, found me and came to me on their own, and nothing arose from the office of Mr. Bobroff. In regard to the flow of information from Mr. Bobroff's office, there was a whistleblower who is protected under the legislation. The information provided by that whistleblower was not used by me and had no value to me and was nothing to do with me. It was provided to the appropriate authority, and the appropriate authority dealt and is dealing with it. But I certainly gained nothing. Mr. Barnard, Mr. Bobroff cannot accept responsibility for what he's done. And so the allegations, as one reads his letter, become more bizarre and more outlandish. It's everyone else's fault. It's part of a grand conspiracy. As I indicated earlier, it's really something from Ripley's, believe it or not. It ought not to have been before this commission, with respect.
Thank you, Mr. Miller. Chief Justice, thank you for the indulgence.
Thank you, Commissioner Barnard. Commissioner Tsepe?
Chief Justice, thank you. I'm covered. Thank you.
Thank you very much. Thank you, Mr. Miller.
Chief Justice,
Yes.
I'm so sorry. May I have one follow-up to Mr. Barnard?
Yes, Honorable Breitenbach.
Thank you, sir. Good afternoon, Mr. Miller.
Good afternoon, Ms. Breitenbach.
I'm afraid that I'm an old prosecutor and old habits die hard. Would you agree with me that if Mr. Bobroff wanted to be taken seriously, he should come here and say that?
Well, Ms. Breitenbach, I think you're 100% correct. A lot of allegations are made while he sits over the sea in Australia. And if there was any basis for any of the allegations he's made, he would come here. He asserts that he's innocent and that he was improperly struck from role, but he's never prosecuted his appeal against his striking off. I think...
No, the allegations against you. If he wants to be taken seriously, he can come here and say it.
Yes, the allegations against me, he must, if there was any basis, he should come here and do it. It seems improper that fugitives from South African law can pull the strings from afar.
I agree with you.
They must stand by their words and face the consequences if it's found to be false. And
thank you. You've answered my question. Thank you.
Thank you, Ms. Breitenbach.
Thank you very much, Mr. Miller. You're excused.
Thank you, Chief Justice. Thank you, members of the Commission, for your time.
You are excused.
Thank you.